built 100 years
Yeah,
ago.
well, the population's changed and all that. But anyway, okay, guys, we're all set to go. The administrator's here. Everybody grab a seat. And I'm going to take this. I just broke my mask. All right. It's November 16th, 2020. It's about 5:08 in the afternoon. We're at the Flagler County Board of County Commissioners Government Services Building in Bunnell, Florida. And we're going to begin our BOCC meeting at this time with a pledge. I'll ask Mr. Hanson, Commissioner Hanson, to do the pledge. So please stand.
Ladies and gentlemen, join me as we salute our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. For a moment of silence, we ask God to bless all the citizens of Flagler County, especially the men and women in the military around the world standing watch to maintain our freedom. Here at home, our brave first responders, police, fire, and medical personnel keep us safe, away from danger, and secure in our homes. With that, we'll start the meeting and the agenda. I have some announcements to make, and just bear with me as I go through these so I make sure I get them right. Due to neighborhood concerns received after the agenda was published, would any commissioner like to make a motion to table item 909F, which I'll read? It's a quasi-judicial, it's item 9F, quasi-judicial application 3144, request for approval of a preliminary plat for Relay Ridge, parcel numbers 231430 000 0202 and 241430 0020 45.75 acres, Phase 1, owner Relay Ridge LLC / agent Parker Mecklenburg, PERLA, project number 201-807-0020, until time and date certain of December 14th, 2020, at 5:30 p.m. or soon thereafter, to allow the neighborhoods more time for community meetings. So that would be the motion, and I'm asking to go forward.
Mr. Chair, I'd like to make a motion to table that
9F.
9F. I'm sorry, I don't have my glasses. So
Right.
Until time certain.
Till time certain,
Which is December 14th.
December
2020,
14th.
or thereafter. So
Second.
we have a motion and a second to table item 9F. Any additional comment from the public? Seeing none, come forward, bring it back to the board. All those in favor of tabling item 9F, the quasi-judicial application 3144, please signify by saying aye.
Aye.
Aye. So that item is removed from the agenda. A couple of additional announcements. County offices will be closed Thursday, November 26th, and Friday, November 27th for the Thanksgiving holiday. Our next upcoming meetings, workshops, and special meetings, special meeting Tuesday, November 17th, which will be tomorrow here, and that'll be for the swearing in of our some re-elected commissioners. We invite the public to come to that. And our next regular meeting will be Monday, December 7th, interesting date, 9 a.m. And one additional meeting that I'll just make a quick announcement on, we'll have our legislative priorities presented to our representatives, Travis Hudson, Senator for the state, and Paul Renner, our U.S. representative. And that'll happen on December 18th. So with that, those are the announcements. We'll get on with the agenda. We'll start with, recognitions, proclamations, and presentations. The first recognition is for Commissioner Charles Erickson for 8 years of service to the citizens of Flagler County. And Mr. Cameron, our county administrator, will have a few comments concerning that.
Thank you, Mr. Chairman. I have not had the opportunity to work with Mr. Erickson, but for about a quarter of that term, but it has been a delightful quarter, and we have had many good conversations over coffee. I've thoroughly enjoyed it. You're a gentleman and a credit to the board. You have served 2 full terms, and when you were elected District 1, which is pretty much the area that is west of Belterra between State Road 100 and Palm Coast Parkway, you brought thoughtful and deliberate issues to bear to ensure that all the residents of Flagler County are being well represented. You have been especially passionate about issues facing older adults, which I am truly personally very thankful for, and actively welcomed and participated in the advocacy and aging community conversations that have taken place during your tenure. Your service includes being a staunch supporter of Flagler's drug court, and I believe you have attended every graduation and given encouragement to those that were graduating to continue in their healthy practices. You have further demonstrated your desire to help people through your dedication to the Family Life Center Committee and the Washington Carver Center on their governance board. You have served on the Circuit 7 Juvenile Justice Advisory Board and the Flagler County Department of Juvenile Justice Council and Management Advisory Group for GTM NER, the School Planning Oversight Committee, and the Transportation Disadvantaged Local Coordinating Board. Your career has been marked by service to your community and some of those that needed the assistance of government most. You were elected in 2016. You weren't elected in 2016. You were certified in 2016 as an advanced county commissioner through the Florida Association of Counties. And that included seminars about making tough policy choices during a tumultuous time and working with stakeholders. Commissioner Erickson, you epitomize what a representative of the people should be, and we thank you for your service.
Thank you, Charlie.
Thank you for those kind words.
I want to recognize any of the other commissioners that they just wanted to say anything.
You looking at me first, sir?
You are first.
Okay, well, thank you. Yeah, it's been my honor to serve with you, Commissioner. You know, I've watched your career even when I wasn't in politics, when, you know, for a lot of years, and you've always been a role model for comportment and friendliness. And I remember when I was running 4 years ago, and you were running for re-election. Yes, you were running for re-election. And, you know, one of the hard things you have to do as a candidate is to collect signatures on petition cards. And, you know, when you run for office locally here, you get to know everybody because we're all at the same events. And I would always be jealous about the fact that, you know, you could walk in and get 50 cards signed or 30 cards signed, and I'd get 5 or 6 because you're just a friendly, outgoing person, and people know you, and they admired you and, you know, felt comfortable with you. So, again, for those of us that serve, we know what kind of hard work it is and how many hours you have to put in behind the scenes. And you've been a friend to a lot of people, and it's been my honor to serve with you. So thank you.
Thank you.
Yeah, Charlie, I second all of that. And I wish you good bicycle riding and safe bicycle riding. Now that you don't have all these rigors of being a county commissioner, you should be able to put in some more time on the bike and keep yourself healthy. You've been a great asset.
to this county.
Charlie, I concur with all that. It's been a pleasure working with you, and I've learned a lot. I know we've had some bumps, but you know what? You're a hell of a guy, and I appreciate being a mentor of mine. Thank you.
Charlie, for me, it's been a long time. I mean, this goes back to before you ran for commissioner, back in the original days of trying to get the Republican Party together and all that kind of thing. So you've been through a lot. When you think, in addition to what you've had to face medically and keep going, you've gone through, hurricanes, COVID-19, floods, just a lot of tough issues dating back into the history of Flagler County, which we're still, working on, but made a lot of progress as you get ready to leave us as an elected official. It's great all you've been able to accomplish, and I think you should look back on your 8 years as being very significant and positive for all the citizens of Flagler County. So thank you very much.
Thank you.
So I'm gonna,
I think it was.
oh, I thought you were gonna, go ahead.
Now you got me nervous as all get out. No, I've had a lot of fun. Actually, the 8 years I've spent here with the county is the longest I've ever spent in any one job in my life. I spent 4 years with the military, which I enjoyed. I'd tell you about some of the tasks, but I was stateside during Vietnam. I was a sworn junior officer. I was just a first lieutenant. The toughest jobs I had 7 of the toughest jobs I've ever had in my life. I had to call a priest and walk with that priest up to a person's home and tell them that their son was not coming home alive from Vietnam. Toughest job one could ever have. And I did that as professional as I could, and that always stays with me. I have a list of all those young men who made some fatal mistakes. One died 4 days from showing up at the camp in Vietnam. He ran outside during a missile attack on the base, just didn't follow orders. But I'll tell you something, I did it as a proud American. I did it in a manner that I would like it be told if something like that happened to one of my sons. And I tried to live by that particular life the rest of the way. That impressed me. I wasn't a very good college student. I picked the Army. I ended up at Fort Bliss, Texas. And what I just told you was some of the toughest things. I continued as a young first lieutenant, and they assigned me to a Nike Hercules missile site in Connecticut, my first assignment. And I'm proud of my military background. I'm proud of my dad, who was a survival of the war in the Pacific on board an aircraft carrier. I'm proud of the 2 gentlemen to my right who also have dedicated a far number of years to the military. Military life isn't for everybody. Sometimes you can't make phone calls. I've got a grandson who's on an aircraft carrier someplace out in the Mediterranean. He can't call home. He can't even use a computer to contact people, etc. But that was where I started. And when I came here, I went to work afterwards and joined the company, and they moved me around from office to office, managing people, and that's always been a part of my life, is talking to people, finding about what their needs are, and asking them to join me in managing an office. There's been some particular people here in Flagler County that I'd like to mention. My first person I'd mention passed away a couple years ago, Mr. Al Jones. He too was a commissioner here in Flagler County in the past. We had a comedic commissioner, I think 6 or 7 years, George Hans. And a name not so popular with some people, but popular with me, was Nate McLaughlin. I'd also like to recognize Sal Ritigliano, who passed away from Flagler County here a few weeks ago. And he was a good military man, worked here in the county. But I have to mention other people that I've crossed paths with, and in a positive manner, and have been quite helpful to me. Gail Wadsworth, Tom Bexley, Jay Gardner, Suzanne Johnston, Katie Linhart, and Sheriff Rick Staley. All of them I consider friends, and I will in the distant. And I also have some odd people. You know, I came here, I used to be able to ride a bicycle and get out 8, 10, 12, 20, 52 miles a day on my bicycle. And had a few blips in that over the last couple of years with health issues, but I'm coming back. But you know, we've got a man out in the back part of Flagler County here, Chet, and he's got one heck of a hard-working team out there, and they repair all the county vehicles, take care of the gas pumps. And interestingly enough, they keep care of all the sheriff's cars that get crashed in this county. You got to go out there and look at the number of vehicles that are out there. The Flagler Health Department's been especially responsive during the past months here with our everybody's health. The medical people at Care Here, which is our own employees' clinic out here, are just unbelievable. I think they named a room after me. I've been in there so many times this past year. But one of the biggest and best things I think that I did and was part of was dealing with short-term rentals. A good friend of mine who's no longer with us, Frank Meeker, and I spent numerous days and weeks in a car on the way to Tallahassee to represent Flagler County with short-term rental information. Luckily for us, we were plugged into Mr. Al Hadid, who told us the people to go visit up in Tallahassee. And Al was right. He even told us how to get through the maze of offices up in the 2 big buildings up in Tallahassee. Even a veteran up there gets lost with the number of offices, number of stairways, et cetera. I had the opportunity to talk a lot to Mr. John Thrasher, who was our representative up there. He was an elected official. He now, believe it or not, is the president of Florida State University. And I enjoyed the talks he had and the wisdom he had of just working for the state of Florida, and it helped me here. But I've enjoyed the 8 years. I might even come back, et cetera. But I'm going to take a break here and fool around with my two little friends at home. Gracie and Molly are mother and daughter dachshunds who make enough noise as two bulldogs, and yet I'm their contact for food, and they're my contact for entertainment. So I thank everybody for recognizing me, the nice comments, and I'll see you again. Thank you.
Thank you, Charlie, and there'll be some additional time and event to recognize your service, and that'll be forthcoming here before, I guess before the end of the year. I'm not exactly sure what the date is. We may have that.
I think it's Thursday, sir.
Thursday? Okay.
He said it was in Hawaii.
Okay. All right. We'll go on with, we have no proclamations this evening. Our next presentation is on emergency management, COVID and CARES Act funds, presented by Jonathan Lord, our Emergency Management Director.
Good evening, gentlemen. Commissioner Erickson, let me first say it's truly been a pleasure in my short time here.
Thank you.
Working with you. As you all know, our hurricane season is still chugging along. We had a little storm graze us last week, and luckily we had no real impacts of note with that. That was Theta. And we continue to watch the tropic. There are two systems out there right now. There's Iota, currently in the Caribbean, that's getting increasingly stronger before it makes landfall, and there's a potential system that might be Kappa by the time this week is over. So in almost the same area as Iota. So it's an interesting hurricane season, to say the least. So we keep our guard up. We're not let our guard down. We keep watching it. We remain prepared to deal with whatever may come our way. Hopefully nothing comes our way, and we can say goodbye to hurricane season at the end of this month, and that would be a great thing to happen. On the coronavirus front, just so you're aware, and I think I had sent you all a little something last week, we have fully expended our second allocation of coronavirus relief funds, and we've entered what I mentioned last commission meeting, which was the request for reimbursement phase, and most likely this evening and or tomorrow we'll probably file our very first request for reimbursement.
Just one quick question on that. Although we've expended it, have all the people who will be in that group of money, have they received their checks at this point?
No, there's quite a big lag from expending the funds because we can count encumbrances as expenditures, so the state sends us more funds. So there's quite a big lag of probably another few weeks before
I know with all the
we get
commissioners,
caught up.
we get calls all the time, and so that's fine.
So from moving forward now on the business and the individual side, just so you're aware, as I get them approved from social services or tourism and economic development, and when John Brower and I sign off on them before they go to the clerk's office, we are now going to have to send them to Tallahassee, get Tallahassee to send us money for all future batches. When Tallahassee sends us the money, then we'll send them to the clerk for checks to be issued. So an additional step in there, but that's how the state set it up. So we're going to do that. We're going to be very aggressive with that. And like I said, today was the day we had to file everything to prove that we'd spent the initial two allocations that applied to all counties that were part of this process. And we met that. That happened today. So depending on what, unfortunately, when I walked over here, I didn't have a chance to check with Michael from Finance, who's doing that with me together. He may be filing that first request tonight, or it's going to be sometime tomorrow morning. So that was our key deadline. Last week, our PIO sent out a press release sharing that both the individual and business programs will be closing to new applicants at the end of this week. That was because of that moved up deadline by the state to December 3rd. And we have no control of that deadline, but we need to be able to show we have all those things in process. It does not mean that we're not still cutting checks to those applicants after December 3rd, but we have to show everything in the pipeline to the state on December 3rd, and we can't accrue anything new after that date because of that deadline. So our residents and business will continue to receive checks if they've applied and have been approved throughout the month of December, even though we have to stop incurring new expenses with the state on that date. As of this past Friday, our total expenditure encumbrances, I'm going to use very round numbers here, business grants are over about $4.5 million so far, individual housing and utility assistance about $3 million, give or take, local government expenditures are about $2.5 million. One thing we did find out new, even though the state cut some time off underneath from our legs on it, is they did open up a new category for reimbursement costs, and that is the regular salaries of first responders, so the firefighters in the field, the firefighter paramedics in the field, as well as law enforcement officers in the field. So the balance of the funds that are not used for those other programs, we are going to be going after getting those funds back into our county and into our municipalities with the state. And those will 100% be requests for reimbursement processes. The one thing the state did nicely with that is the burden for documentation is not as high as is with all these other processes. So that actually came from the Treasury, and the state initially did not agree with that statement. Over the last couple of weeks, I think they've been beat up quite a bit by local governments and are now allowing us to go after that as well. So that was that's very helpful, and that will get us to fully expending that $20 million when we're all said and done by the end of December. As of today, on the COVID front in general, there are over 880,000 cases here in Florida across all ages, over 17,000 deaths attributed to COVID. Here in Flagler County, we're up to a cumulative total of 2,399 cases as of last night. 6% have been in long-term care facilities. I don't know if it's like a weird little number, I don't know if you've noticed that, but up until this commission meeting, I've been saying 7%. So now that the number has shrunk, not because we have less cases in there now, it's just showing the majority of new cases are happening outside of that healthcare setting. They're happening out in the general public. 178 people have been hospitalized in our community. Unfortunately, 40 have died. Our trend recently, we kind of go up and down, kind of like a roller coaster. The last 30 days has kind of flattened out. We're hovering around just below 7%. We peak on some days. We have valleys on others, but we're hovering right around 7%. So we're kind of staying flat. It's not necessarily the best number to hover around, but we're kind of, if you look at the trend over 30 days, we're staying sort of flat. Our case rate per 100,000, as I've been saying, we kind of hover around the bottom of the list. As of about an hour ago when I last checked, we are at the bottom of the list. And so that's a good thing to stay there compared to other counties. Again, it's not the greatest number in the world, but I would rather be the bottom of that list than any other list out there. As you've seen, our state and nation are experiencing rapid growth in new cases, as was expected as we entered the winter season, especially as the northern states, people started heading indoors more. So unfortunately, our state's seeing some of that growth too, and so is the entire nation. So therefore, as we approach the holiday season, our continued vigilance and recurrent messaging, as we have been doing on hand washing, social distancing, face mask usage, is really, really key as we head towards the holiday season. And fingers crossed, a vaccine starts becoming available towards the end of this calendar year, at least to the responders and the healthcare workers, and hopefully soon into the new year, we can start putting out vaccines to the general public, which we've been working very closely with the health department to make sure our community is ready to do that once that time comes.
Thank you. Any thoughts or questions?
Yeah, there's been some talk about the tests sometimes not being very reliable. Have you run across that, or?
It all comes down to, it's just like any other test. Sometimes if it's not done 100% correctly, there's errors. Every body is different. Everyone's body's reaction to the COVID-19 itself. Sometimes you'll have people who have COVID-19 have negatives, and sometimes there is an error rate for every test.
Yeah.
The newer, faster tests have a higher error rate than
That's
the
what I
original
heard.
swab tests.
Right.
Even the blood-based test is now showing to have a certain error rate. So there's no perfect solution to knowing whether or not someone has COVID-19, unfortunately.
It's just something we have to live with.
Yeah.
Okay, thank you.
Well, it's also good that we're getting newscasts about there is a vaccine.
It is. It was getting a little ominous. We got kind of excited for a while, and then it was not looking so good. But two massive pharmaceutical companies have reported two very good results in the last week. So that's an exciting sign to see.
Any other commissioners have? Okay, well, thank you very much, Jonathan.
Thank you, gentlemen.
Hope those hurricanes stop at some point. We're going to run out of names. All right, with that, the next item on the agenda is community outreach. This 30-minute period has been allocated for public comment on any consent agenda item or topic not on the agenda. Each speaker will be allowed up to 3 minutes to address the commission. Speakers should approach the podium, identify themselves, and direct comments to me, the chair. So at this point, we're ready for the first public comment. Please come forward.
Pam Hathaway, 38 Hernandez Avenue in the Hammock. If you allow me, Chairman Sullivan, to thank Commissioner Erickson for his service, thank you very much. And congratulations to Mr. O'Brien and you, Commissioner Sullivan, for your reelection. I'm here tonight, well, for two reasons. I'll speak later, but this is not on the agenda, but it is on the way to become onto the agenda, I'm sure. And it is a grant that has been allocated to Flagler County, $800,000 for paving and $1 million for drainage in the Hammock area, Commissioner Hansen's district. Most of us in the Hammock do not want our roads paved. In order to pave those roads, many, many beautiful trees will have to be destroyed. And the reason the Hammock is because of our beautiful canopy of oak trees. There is a drainage problem in one small area, which is on First Avenue or First Street, I can't remember which one. And I request, and most of us who will speak to this, would request that the money be used to solve that problem. But most of us in the Hammock do not have a drainage problem. We have enough trees that will soak up the water, and it just goes through the sand that we drive on every day. Again, although this is a grant, and I know, being an accountant, what a grant means, we request that this grant be redirected to someplace that really needs it and wants it. Thank you very much.
All right, thank you. We can do it either way with the commission. I'd like to have all the community outreach people come forward first, and then we go back and cover, because sometimes you get duplicate answers. So next person for community outreach.
Jane Gentile, Youth Plantation Bay. Charlie, it was great knowing you. Hope to see you around and the doggies. And congratulations, Commissioner Sullivan and Commissioner O'Brien. You're going to be hearing an item later today on the gardens. I'm not bringing up that item. I won't be here. I don't live there in that area. I admire the work that everyone is doing. Barbara Revels wrote a superb editorial in the Observer, which I hope you all read. Today I'm here to address my umpteenth request to this commissioner to fire whom I think is the most incompetent government attorney that has ever been hired. Today, after spending $74,000 to date to Bell and Roper Law Firm, the judge denied Flagler County's request for summary judgment against Captain's Barbecue. I think Judge Perkins is superb. I watched him on Zoom. Al Hadid wasn't there. I don't know where he was, but his attorney was there. Now there's going to be depositions. That should be very interesting. This goes on and on. The same law firm has been paid by Mr. Hadid, through Mr. Hadid, $184,000 in the past couple of years, 2 years, Bell and Roper. Al Hadid gets a budget of $800,000. Al Hadid doesn't defend the county in court on any lawsuit. Captain's lost lease should have never been signed in the first place, but Al Hadid approved it. Al Hadid also has slandered me, a constituent, by saying he had no idea that there was a problem with Commissioner Mullins threatening to sue me, to put me on a train, to get gag orders, etc. But according to Julie Murphy and a public search, Mr. Hadid was copied on all 47 threats sent to me by Commissioner Mullins using county email and threatening me and signing as a commissioner. I prepared a resolution for this commission to pass to prohibit any elected official or county employee from insulting, harassing, or slandering an individual, but it went nowhere. Your county attorney has also violated your own Flagler County Rules of Civil Procedure, which does not allow him to slander a constituent. I will let it be known whether I am a commissioner in the future or not. I'm the same Jane that I was 18 years ago, and I love Flagler County, and I spend my money and my time and will continue to do so. I'm not desperate for a commission seat. I have a wonderful husband, a lovely home, 2 doxies, and a bird, and lots of friends. I think you need to fire Al Hadid. He has cost you a bundle, and he cost you more today when he lost a stupid thing in court for no reason. Ignore him, what he says anything about the gardens. Ignore him. He's going to try to set you up for a lawsuit again with the gardens.
Thank you. Next. For public comment.
Mark Yu, Plantation Bay. Again, I'm here to talk about several people up here. First being Mr. Hadid. Shame on you, Mr. Hadid. You made a comment, I believe, that my wife will do anything to get elected at a commission meeting. Shame on you. That's disgusting. Disgusting. Second is Mr. Mullins. Again, his rhetoric is out of control. It's the second time now, I believe, one of the commission meetings, and also may have been a budget meeting, he made 2 statements in public that my wife is unhinged. No, Mr. Mullins, you are the one who unhinged. Now, I'm also very, very disappointed that the chair does not call out Mr. Mullins when he makes these derogatory comments. You should be doing that. You should be doing that. I'm sorry. I'm sorry you got to hear this, Charlie, but you, Mr. Mullins, you need to keep your foul mouth shut. You got it?
Next. Next for comment. All right. I don't see anyone else coming forward at this point, so we'll close the community outreach session. There was one question that I think that Mr. Hanson would like to respond on.
Yeah, the issue on that grant money involves not the hammock, not the entire hammock, involves 4 streets. And I'm working with the people that live out there, and our goal is to not pave the first 2 streets and pave the second and third and put in a drainage pond and along First Avenue, and then drain that into the Malacompra Canal. So I think we've got a handle on that, and we're trying to preserve as many trees as we can. And it's my goal not to pave the first 2 streets in that, and I'm working with Ms. Faith Akatib to get that done. So a little criticism too, a little premature.
All right. I think that was the only additional question. So at this point, we'll go on with item
Chair.
6. Okay, Mr. Hadid.
I mean, that was a laundry list of things that were mentioned by Ms. Yude. What the judge did today, and which I will report to you on, is that the judge denied the motions without prejudice to allow discovery, evidence discovery to go forward because captains did not provide any evidence. And they asked for the opportunity to conduct depositions, et cetera. So they were denied without prejudice. Also make this point that where you have a contract, a lease that is substantially amended, there's no resemblance between the 2011 and the 2018 lease. We have an obligation to make sure that that 2018 lease complies with Florida statutory law. We have an obligation to present those arguments today. Justice will decide about those issues as well as many other issues in that case. So I'm not going to address it further. You all are very familiar with the efforts we've undertaken. As to the law firm we're using, Bell and Roper, they are the law firm that are pointed to us by our insurance carrier, our liability insurance carrier. We've been using them many years. They're very accomplished lawyers. We use them because we have had experience with them. I will remind the board of one case. I'm trying to think if, Mr. Erickson, you were on the board. We had a damages case, a serious damages case, where somebody died and another person was severely disabled as a result. We were defendants in the case. There was a sod company that was a defendant, and they sought like $8 million from the jury. The jury rendered a verdict against the sod company for about $6.5 million. The verdict against us was 0. So that tells you a lot about the capability of that firm. Now, the comment about me not doing, and I'm not going to try to go point by point, but the comments are so beyond the pale. I know that Mr. Erickson will remember this, and Mr. Hansen will remember this. I litigated the short-term vacation rental case where they asserted $22.7 million in damages. And what was the result of that case that I handled? 0. Recently, I represented the sheriff and the county in a class action federal civil rights suit concerning rules concerning inmate mail. In another county that had the same suit, they ended up having to pay $300,000 in a suit that they used other lawyers. I represented the county and the sheriff with no other lawyers, and the case was dismissed. Our liability was 0. I've litigated many other cases. I'm not going to bore people with that, but I've done my share of litigation. And I think, commissioners, you know that often I'm asked to speak at continuing legal education seminars for other lawyers on how to properly conduct a case. Now, as for the other assertions, I'm not going to take the board's time. I'm very sorry that Ms. Yude is so angry at me. It's very obvious. But I want to place it in context. You remember when she had the political sign dispute, when she was running for office. Her sign was in the right-of-way, and it was removed, and she came to the board and wanted to be paid $200 in damages. And I advised the board that based on the law and the facts, we were not obligated to pay that amount, and I explained that we should not begin paying nuisance claims because then other people would come behind that. So I know she's angry about me at that. I know she's angry about me because of the litigation against her friend, Miss Weeks, where right now she is under litigation by the Attorney General for about $120,000, $130,000 that she owes us, Miss Weeks, who's been removed from office. Well, who resigned from office. She did resign and was indicted and convicted. Only within the last couple of weeks, Ms. Yude went to Mr. Erickson and attempted to get him, impermissibly I might add, to sign a release of the county's claims that are being prosecuted by the Attorney General in Tallahassee. Now, not only did she do it, and I know she got mad because I brought it up, I reported it to the Attorney General, but then she repeated that behavior before our last meeting. So I'm sorry, I don't mean to put all this on, but we can't.
Please,
we
no
can't-
comments in the audience.
We haven't been able to have a county commission meeting in I don't know how long with Ms. Yude coming to the mic and asking that I get fired. And of course, the public may not know this. My contract is meeting to meeting. If today you decided to terminate me, I'm terminated. The next meeting, you can terminate me, meeting to meeting. That's as long as my contract is. So if you don't have the confidence in me to provide you legal advice and guidance and to represent you to figure out how these cases ought to be handled, then believe me, I would understand, and if you lost confidence in me, then I would urge you to get another lawyer. Thank you.
Thank you, Mr. Dean. I would mention that this has been brought up, some of these issues before. We did get a sense of the commissions, all 5 strongly supported you, and there was no indication of any desire to do anything but that. Thank you.
I would also like to reply. I've said to myself I wasn't going to even respond to this stuff anymore, but what she's failing to leave out is the continual email attacks, and I reply to them. I reply, and she asks a question. I reply. If it's not what she wants, she then goes and is unhinged and starts getting upset and starts throwing attacks. I don't know how to answer. I don't know how to say, if you want the truth, then I'm going to answer you. If you don't, then I won't. But I've continually had my child said things about from her, made comments about her hair, made personal attacks, many ethics complaints that have fell frivolously. I've had to address her through my attorney, and just said it's got to stop. I normally am very, very conscientious about replying to every email that I get. And I've had to make it a point, this one situation I do not reply to anymore because you cannot answer right. And I'm not going to take someone attacking me, attacking my business, attacking me personally, and attacking my fellow people that are serving and staff that are working. Just a month alone of July 15th to August 15th, there were over 180 emails, 180 emails from her that keeps staff, Mr. Cameron, it keeps you guys very busy, does it not?
Commissioner, we have to answer every public records request, and it does take a considerable amount of time to do that for any public records request, and we try to avoid charging for it because we feel the public has a right to those. But yes, any public records request or email comes in, I try to get it answered.
Is 180 normal from one resident?
No, sir.
My point is I almost want to see what it was since January because I am seeing a pattern here, and I'm told it's even more since I brought this up. I'm concerned about staff. I'm concerned about their fear of doing their job. I'm concerned about the direction we're going in, all off one resident that I'm not sure what the agenda is. I've tried to figure it out. I tried in the beginning and was warned, do not try. And I tried, and when I didn't agree, this is where it went.
But when it comes to public records requests, the state law requires us to reply to those.
All right. Mr. Deed, you're good? Okay. Community outreach period is done now. We're going to now go to item 6, which is the consent agenda. There's item 6, all the items there, and 7. So I didn't hear any specific comments from the public about those. Back to the board. Mr. Erickson, any items in the consent agenda that you would like to pull?
None for me.
Mr. Chairman, I have none.
I have none.
None. I just had one item, item 7L. I'm looking for just some additional information. I got a little confused when I read exactly what was being done there as far as the movement of the money from reserves as to what the actual, if somebody could give me just a quick explanation of that.
We are having to true up all of those accounts for the transfer to FGUA, and that is part of that true up and paying off loans and recognizing revenues from assets and so forth.
I guess my one question is, how much money will come out of reserves to cover that, if any?
Ultimately, about $500,000 if we don't recoup that, as we discussed in an earlier meeting.
Right. Because there's a $3 million number, then a 1.7 number, and a 500 number, and that's what, okay, I think I understand
Yes.
what's going on.
Okay.
there. All right, thank you. Bring it back, no other items to pull from the agenda. Bring it back to the board for a motion concerning the consent agenda.
Mr. Chairman, I move that we approve the consent agenda.
Second.
We have a motion and a second. Any comments from the public concerning that motion to approve the consent agenda with the one explanation? Seeing none, at this point, sometimes I miss our lawyer because he's over there, or I can't see him. But, all right, we have a motion and a second. Back to the board to approve the full consent agenda, all of items in 6 and 7. All those in favor signify by saying aye.
Aye.
Very well, it's unanimous. There are no noes. We approve the consent agenda. At this point, okay, at this point, we'll go to general business. And the presentation is limited to 15 minutes, with public comments limited to 3 minutes per speaker. It's item 8A, approval of assignment and assumption agreements related to future utility service by the Florida Government Utility Authority. Approval of the assignment and assumption agreements subject to legal review by the county attorney. Al, were you going to speak to this one?
Yes, sir. Very briefly, Commissioners, this is another step in the progression to transfer all of the county's utility assets to the Governmental Utility Authority. And what this agenda item does, it takes our existing agreements that we have with the City of Palm Coast, the City of Beverly Beach, and the Plantation Bay Country Club. They each have different agreements, and what we're essentially doing is assigning those agreements to the Florida Governmental Utility Authority so they can actually operate the utility after we give it to them. Just briefly as to the four assignments that are here. One is, as you may know, on the Barrier Island, the wastewater service to our customers in the unincorporated county and in the city of Beverly Beach, the town of Beverly Beach, are served by Palm Coast. We have got a master pump station down at Beverly Beach that pumps the wastewater up to the Hammock Dunes Bridge, where there is a master pump station constructed by Palm Coast, and then the wastewater is sent inland, by the way, safer, outside of potential hurricane zones, to be treated. So we take the waste off. So that agreement is being assigned to the Florida Government Utility Authority. Also, within that same area, we have potable water customers. And that is based on an agreement that we have with the City of Palm Coast. They've been serving us bulk water, and then we sell it to our utility customers, our residential and commercial utility customers, collect that money and pay Palm Coast according to the rates that they charge us. That agreement is also being assigned to the Florida Governmental Utility Authority. The third agreement, as you know, I've just mentioned that we operate within the city of Beverly Beach. Since that's another government, we received an interlocal agreement that allows us to operate utilities, to have utility assets within the municipality. So that consent is being transferred to the Florida Governmental Utility Authority, as they will be the operators of those systems after we close. And finally, it's a non-governmental entity, the Plantation Bay Country Club. We have an agreement with them that originated in 2013 to the city of Bunnell, then was assigned to us in 2015, and we now have it. It is for effluent disposal, to be able to use effluent water that we produce from our plant in terms of irrigating the golf course. So because the Florida Governmental Utility Authority is going to be implementing that function after closing, we're assigning that agreement to them. So the governmental agencies are agreeing, that is the ones I've mentioned, City of Palm Coast, Town of Beverly Beach, and the Plantation Bay Plantation Bay Country Club have all agreed to assign a consent to the assignment to what we call the FGUA. That's the acronym, Florida Governmental Utility Authority. So for that, I'd ask, unless you have any questions, I'd ask for a motion to approve these assignment and assumption agreements related to the FGUA transfer.
I would just add that in going through all that, it's interesting to see the names of the earlier commissioners who signed off on a number of those things. Goes back a long way.
Goes back to the early 90s.
On this item, 8A. Seeing none, I would come back to the board for a motion to approve item 8A, approval of assignment and assumption agreements related to future utility service by the Florida Governmental Utility Authority.
Mr. Chairman, I move we approve item 8A.
Second.
Second from Mr. Erickson. I'll open it up for public comment concerning this item. Make sure, looking at everybody. I don't see anyone coming forward. I'm going to bring it back to the board for additional comments or vote. So I'm going to go forward. All those in favor of approving the motion 8A, approval of assignment and assumption agreements related to future utility service by the Florida Governmental Utility Authority. All those in favor signify by saying aye.
Aye.
Aye. There are no noes. It carries unanimously. Thank you. At this time, we'll go to item 9 on the agenda, and we're beyond the time where we had to wait to start. This is a quasi-judicial process part of the agenda. The audience should refrain from clapping, booing, or shouts of approval or disagreement. To avoid potential legal ramification and possible overturning of decision by the courts, a public hearing must be fair in 3 respects: form, substance, and appearance. Time limits will be observed. Staff, 10-minute presentations. Applicant, 15-minute presentation unless time extended by consensus of the board. Public comment, 3 minutes per speaker. 5 minutes is speaking on behalf of a group. And applicant rebuttal and closing staff comments, 10 minutes each. The first item is a continuation of a December 14th, continuation to December 14th, 2020, at the request of the applicant's attorney, Jay Livingston, and what that would have been was a request to amend and restate the Renaissance Hammock Dunes PUD. So we're asking, back to the board, we're asking for approval of the continuation until December 14th.
Mr. Chair, I move that we approve the movement of item 9A, application 3224, to December 14th, 2020.
Do I have a
Second.
We have a second by Mr. Erickson. Public comment concerning that? Seeing none. Back to the board. Comment and vote. All those in favor of the continuance for item 9A concerning the Renaissance at Hammock Dunes PUD signify by saying aye.
Aye.
Aye. That passes unanimously. Item 9B, and I'll ask before we, this is the consideration of a resolution amending the fiscal year 2019-2020 budget in the amount of $3,374,156. Back to the board. This is a quasi-judicial item. Anything to bring forward concerning your, information on this?
I've spoken to no one.
I've had no interaction at all.
I've had no interaction, Mr. Miller.
none.
None. Okay, there he is, Mr. Bauer. Bauer, please come forward and speak on
Mr.
this
Chair,
item.
This item is for fiscal year 1920, the previous fiscal year. This is part of the regular business to adjust and amend the budget for items that needed a public hearing to amend the budget. This item here, we're just asking you to approve a resolution, and I can read the resolution title, and just a motion to approve that would be sufficient for this. Of course, we'd have to do public comment on that as well. Let's proceed.
Right. Okay. Coming back to the board then for motion for item 9B, consideration of resolution amending the fiscal year 2019-2020 budget in the amount of $3,374,156. Do I have a motion to approve that item?
Do we want to hear the resolution before we vote on it?
Sure, we can have Mr. Brower go forth, and did everybody get, in addition to that, everybody's had a chance to
Right.
look at the background on this, okay. Go ahead.
You'd like me to read the resolution, Mr. Chair?
Read the resolution, it will have to.
Whereas the Board of County Commissioners may, by official action, exercise its power to amend the adopted budget of any fund pursuant to Section 129.06 Florida statutes. And whereas the board finds the following supplemental budget amendment is necessary and proper within the funds contained in Schedule B, attached hereto and incorporated herein. Now therefore be it resolved by the Board of County Commissioners of Flagler County, Florida, Section 1. Attached hereto and made part hereof is an amendment to the budget of Flagler County for fiscal year ending September 30th, 2020, marked for identification as Schedule B, which said budget amendment is hereby approved, adopted, and accepted in all respects. Section 2, if any section, subsection, sentence, clause, or provision of this resolution is held unconstitutional, inoperative, or void by a court of competent jurisdiction, such holding shall not affect the remainder of the resolution. Section 3, this resolution shall take effect upon adoption. Adopted and approved this 16th day of November, 2020, by the Board of County Commissioners, Flagler County, Florida.
Mr. Chairman, I move that we approve item 9B.
Second.
Second by Mr. O'Brien. Public comment concerning this item 9B. Seeing none, we'll go on. Back to the board. All those in favor of the motion, 9B, consideration of a resolution amending the fiscal year 2019-2020 budget in the amount of $3,374,156. All those in favor, signify by saying aye.
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 Aye, it passes unanimously. Next item is item 9C. Again, the question is concerning the quasi-judicial process, any information that you received, which we would have to bring forward at this time. Mr. Erickson.
No, I have none.
I have none.
I have none.
None.
And Mr. O'Brien.
None.
Yes, Brown, go forward with, I do have a question on this eventually, but go ahead.
Yes, sir, Mr. Chair, John Brower, Financial Services. This is the same thing as you just passed for FY20, although this is for FY21. This is what we would consider to be our carry-forward process, where we're bringing items that were unexpended in the last fiscal year to this current fiscal year, mostly grants and capital projects and additional fund balance.
Yeah. My one question, again, we'll probably need to have the resolution read, but my question here is that when we approved the budget, of course, this wasn't in there, so our budget was in the neighborhood of $200 million. When you add all this back in, it pushes it up towards what I thought from the previous year, up around 250 to 270, actually 270 now, I think.
About 250-ish. We're about 196, 196.
Okay, I thought, okay. Anyway, that's what this does, basically, is all the carryovers and grants, carryovers, basically.
That's right.
So that's what this is. Just in case somebody's, well, that's a big jump.
A big chunk of money.
It's a big jump. I just want to make sure that was true. So you might, if you want to comment on that, fine.
It's absolutely true. It's a previous budget for projects and grants and those types of things are being brought forward that are still available for expending. And additionally, the fund balance increase is primarily due to COVID-19, lack of training and travel and those types of things. So it's a little larger
So
this year.
do we
than
have
year past.
a final budget number now for 2021 at this point?
The adopted budget remains the same. This
Right.
will amend the budget, so the amended budget will be, I don't have an exact total. Actually, I do, I'm sorry, $256,201,456.
All right. And is there a resolution that you could, it's not here in front of me, could you just, if it's, go ahead and read it.
Mr. Chair, yeah, it's the
All right,
same,
with
it's a very similar resolution as the previous one I
Okay,
read.
but I go ahead and read it, just get it in the record that we heard it.
Whereas the Board of County Commissioners may, by official action, exercise its power to amend the adopted budget of any fund pursuant to Section 129.06 Florida statutes, and whereas the Board finds the following supplemental budget amendment is necessary and proper within the funds contained in Schedule B attached hereto and incorporated herein. Now therefore be it resolved by the Board of County Commissioners of Flagler County, Florida, Section 1, attached hereto and made part hereof is an amendment to the budget of Flagler County for fiscal year ending September 30th, 2021, marked for identification as Schedule B, which said budget amendment is hereby approved, adopted, and accepted in all respects. Section 2, if any section, subsection, sentence, or clause or provisions of this resolution is held unconstitutional, inoperative, or void by a court of competent jurisdiction, such holdings shall not affect the remainder of the resolution. Section 3, this resolution shall take effect upon adoption, adopted and approved this 16th day of November, 2020 by the Board of County Commissioners of Flagler County, Florida.
Mr. Chairman, I move that we approve item 9C.
Second.
Second by Mr. Erickson. Open it up to public comment if you desire. A lot of money. Okay. Back to the board for a vote concerning item 9C, a motion on the floor to consideration of a resolution amending the fiscal year 2021 budget in the amount of $54,575,524 and we're requesting your board approval on that. All those in favor signify by saying aye.
Aye.
Aye, passes unanimously. We go on to the next item, next legislative item in this case, 9D. Again, I'll ask each of the board to comment concerning quasi judicial or any information you may have received that you would like to let us know about. Concerning item 9D. 9D.
B.
Mr. Chair?
B.
I don't think we have to do that for a legislative item.
Legislative, it's not quasi-judicial.
Well, yeah, they put it under the quasi judicial part of the meeting, that was all. That's okay. I think we've already discussed this too at a previous meeting, most of this. So in any event, if there's anything anybody wanted to talk about as far as what they've been heard or done on it, I just wanted to go through it just in case.
I have nothing.
I have none.
Nothing. Okay. All right, okay. Go forward then, Tim. It shows it's Adam, but you're here as a substitute. Go ahead.
I'm going to take the lead on it. This is Tim Telfer, Resiliency and Resource Stewardship Manager for Flagler County. This is an item that was previously discussed with the board on October 19th at a workshop, and it is also necessitated by the purchase and sale contract that the county has executed with FGUA. What we are doing here is providing FGUA with the effluent disposal site that was discussed earlier. If you look on the map here, the effluent disposal site would be within the property that's labeled WL residential property. The county owns the land to the south of it, and really we're facilitating an exchange of land here necessary to provide that effluent disposal area. The first item that the board's going to be asked to consider, there are 3 in total, is a resolution which would amend the Plantation Bay DRI development order, which would remove a park designation from that county property down there. I want to let the board and the audience know that this does not add any units to the Plantation Bay DRI. It simply removes a DRI designation that would prohibit development after that exchange is completed. So that's the purpose of that first resolution that you're asked to consider. There's 2 more. The second is also a resolution. This is in accordance with Florida Statute 125 that requires the county to provide a resolution to facilitate an exchange of property. And the county is authorized under statute to exchange land without compensation if it's determined to be in the best interest by the board. And then the third one is an exchange agreement, and it's just exactly what you think it is. It spells out the terms for the exchange between Flagler County and WL residential land. There's no money being exchanged here. This is simply a land swap necessary to provide that effluent disposal area. And that's it in very brief summary. We can go into it in further detail if there's any questions.
Right, just a reminder, we went through this in fairly much detail at a previous meeting.
We did,
So,
October 19th we did.
If there's any additional comments, and then I'll open it up for a motion concerning item 9D.
Do we just need, Mr. Chairman, do we need just one motion to pass this?
For all 3, Al, is that correct? Just one motion to pass this item for the 3 items involved?
You can, that's called a compound motion. You can do that if it is clear in the motion that you're asking for approval of all the different documents, the different instruments.
Okay, we'll go ahead and do that.
Okay, Mr. Chair, I move we approve all 3 pieces of item 9D, the exchange of property within Plantation Bay Development of Regional Impact.
Second.
We have a motion and a second concerning item 9D, the exchange of property within Plantation Bay Development of Regional Impact related to transfer of Plantation Bay utility system to Florida Governmental Utility Authority, FGUA, the 3 items. Bring it back to the board. At this point, if there's any public comment, I would offer that possibility. Seeing none, come forward. Bring it back to the board for approval of the motion that's on the floor. All those in favor signify by saying aye.
Aye.
Aye. Aye. Aye. It passes unanimously, and we'll go on now to item 9E. 9E, and I agree, this one does not really need a quasi-judicial response. So item 9E, it's requested by our county attorney's office. Mr. Adid, did you want to address this item? Item 9E.
Yes, sir, Mr. Chair and members of the board. This is an amendment to our utility regulatory code. And essentially what it does two things. One is it exempts the Florida Governmental Utility Authority from your regulation of rates. So as a governmental entity, it would ordinarily not have its rate reviewed by another governmental entity unless expressly directed by law. So what we're doing here in order to facilitate our transaction is we are exempting them from our utility regulatory ordinance, our code section. Now, if you all recall, in the transaction structure, FGUA, which is a governmental agency, special purpose governmental agency, all of the local governments, in fact, any governmental authority that uses them for utility delivery service, that entity gets a seat on their board of directors. So the board of directors obviously runs the entity, the authority, FGUA. So if you recall, we designated the county administrator or as designee, because they do not permit elected people, because you can never be certain what their terms are. So that is our input into the rate setting process. Plus, the agreements that have been approved, actually one earlier that you approved on your consent agenda, the rates are capped for a period of time. So that is how we have traded out our utility regulatory authority, continuing control over FGUA with the protection of our county ratepayers. As I said, this ordinance does two things. The second thing it does, one of the problems that have been noted by the board a number of times is the proliferation of septic tanks on the barrier island. They tend to be older, and even the newer ones that are put in, they present a risk of contaminating soil and water and property during significant storm events. So we have taken that opportunity to amend this utility regulatory code to allow an HOA or other cooperative where they have their own utility system, a centralized utility system, to extend their service outside to non-member properties where you have approved the extension and where it provides an environmental benefit. So we have granted that authority in this utility amendment.
Okay, and this is the first reading.
It's actually your first and only reading.
Okay.
It's not a two-reading kind of ordinance like a land
Okay.
development code.
Just said first reading, okay.
Mr. Chair.
Mr. O'Brien.
Mr. Deed, have we not, with respect to the non-member approval, have we not done that in the past?
No, because it's not prohibited, it's not allowed under our current utility code.
So, just trying to understand it, so we don't have any of those communities up in the hammock that are getting services from,
An extension?
yeah,
No.
okay.
So in other words, right now, sir, the Lakeside by the Sea, Surf Club, the newer communities that have been built next to Lakeside,
Yeah.
and Sea Colony, they are all on the Matanzas Shores utility system. It is a centralized system. So they can only, under our current law, state law and our current law, they can only serve their members, their HOA members. This would allow the board to consider on an application the ability of that system, for example, I hate to mention a neighborhood because then that might create issues, but it would allow them to extend their central wastewater line to serve other people and take them off of septic tanks. That they become customers of the Matanzas Shores utility system. That would be the example.
So, the development that we approved earlier this year along Jungle Hut Road,
Oh,
okay? Where are they getting their services from?
Beach Walk. They're actually getting them from the city of Palm Coast because they agreed as part of their development approval
Got it.
that they would extend the central wastewater line.
So this would be a new addition to our,
It
to our
would give you
code.
another
Yeah.
tool, it would give you another
Right.
tool in those areas that where there is no general centralized service, where we don't have the master line running up the
Right.
barrier island to marine land, it would provide an opportunity to have more people taking off septic tanks, provided you are convinced that there's an environmental benefit, that it's structured properly in terms of the member and non-member relationship, be subject to your approval.
Right, so we're
They'd
not
have
giving
come
up,
before you with an application.
we're not giving up any authority, we're putting this in code and we have the ability to approve or not approve.
That's right, you're defining yourselves new authority, should you wish to invoke it, because this issue has come up about the septic, we hear about it
Right.
and when the hurricanes come, and the septic systems get overwhelmed. And
That's all I
another
have.
major
Thank you, Mr.
All right.
rainstorm.
Before we do any other comments before we ask for a motion? So I'm going to come back to the board, ask for a motion concerning this legislative action, first reading and adoption of an ordinance amending Chapter 30 of the county code related to regulation of utilities.
Mr. Chairman, I move that we approve the first reading and adoption of the ordinance amending Chapter 30 of the county code.
Second.
We have a motion and a second. I'll open it up for public comment concerning this particular item, ordinance that's being adopted this evening if we approve it. Seeing none, no one rise. Bring it back to the board for a vote or further comment. All those in favor of item 9E, first reading and adoption of the ordinance amending Chapter 30 of the county code related to regulation of utilities, signify by saying aye.
Aye.
Opposed? None. It passes unanimously. At this point, I'm going to call for a short recess to give everybody a chance to do what they have to do. Right now, it's about 6:24. We'll try to reconvene for item 9G in about 5 or 6 minutes, and I'll bring us back to order at that point. All right, we'll get going again, so the recess is off, is completed. Before we get on with item 9G, I wanted to read the item into the record. Quasi-judicial application 3209, request for modification of a PUD site development plan in the PUD, Plan Unit Development, District for the Hammock Beach River Club, PUD, located south of State Road 100 East and lying east and west of John Anderson Highway, parcel number 13-12-31-01010-01010-0000, 824.13 plus or minus acres. Owner, Palm Coast Intracoastal LLC, applicant Ken Belshi, project number AR 000-102-2019. There are some preliminary issues to be addressed. I'd like to recognize County Attorney Al Hadid to do so.
Yes, thank you. Thank you, Mr. Chair and members of the board. As I advised you in my memorandum, which was also furnished to the attorneys that are involved in this case, we have two entities and individuals that want to establish standing to have the right to be able to present competent, substantial evidence, asking for additional time in order to do so, to be granted a status different than an ordinary member of the public held to 3 minutes. Okay, so you're aware of that. We have the city of Flagler Beach that would like to establish its standing and party status in order to be able to present its case to you, which includes expert witnesses. I'm not sure exactly how many, but we can find that out in short order. And Mr. John Tanner, who's representing Preserve, Flagler Beach, and Bulow Creek, Inc., and, six named individuals who are residents within the area. He wishes to establish standing for them. Now, there are two ways procedurally that we can do this. I'm going to tell you them both, and I'm going to tell you what I think is the preferred route, but you're free to make any judgment at all. This has to do with how we order the proceedings. We're not deciding anything, but the sequence. We're talking about how to order things. So oftentimes, standing is taken as a separate issue. In other words, the parties will just argue standing, call that Roman numeral 1. And then you decide the standing, and then you go to Adam. Adam is standing there. Right now, it would be like segregating the standing issues and deciding them first. You can do that. The alternative is that you can allow the parties to present their standing arguments as a part of their presentation of their main case. So in other words, you're embedding, the word I'm using, their standing arguments into their main arguments about, I don't know what their arguments are, development order should be denied, should be modified, whatever their positions are with respect to the proposed development orders, the amendment of the PUD and the approval later in another hearing of the preliminary plat, if you approve the site development plan that's before you. Okay, so those are two distinct approaches. You either do the tranche of the standing issues, or you put it later. I believe, I've talked to the lawyers, I've tried to get them to come, the attorneys for the parties. That would be, by the way, Michael Chimento, so I'm being very specific here, who represents the applicant, Drew Smith, who's the city attorney for Flagler Beach, as I'm sure you know, and John Tanner, I'm sure you know. He's the counsel to the Preserve Flagler Beach, and that's what I'll call him as a shorthand reference, and also to the 6 named individuals. And for the purpose of the record, I'm just going to, because we need to capture who is attempting to be a party, and I have their addresses and so forth, and I'll pass this piece of paper out. Steve Noble, Suzanne Noble, John Goebbels, Ann Lohman, I don't know if I said that clearly, Deborah Martinez, and Charles Meekins. So those are the individuals that Mr. Tanner represents in addition to Preserve Flagler Beach. So you can choose to let all of this roll into the main presentations. Now, here's the issue, regardless of which choice you make, Plan A or Plan B. You have to figure out how much time. And that's where that's where I'm having the trouble getting the lawyers to agree. I think all the lawyers agree to let's roll all the standing arguments into the main presentation. They just as soon get up one time, they argue standing, and they argue their issue on the merits. Follow what I'm saying? All in one presentation. But they want more time than Mr. Chimento. I don't want to speak for their particular positions, but Mr. Chimento believes that the amount of time they should have should be shorter. In a normal situation, we do not have parties seeking standing. You think about it, you know, some of you have been on here, you may have never had experience when a party has requested standing, okay? So it's proof. I gave you those legal standards, and I did a short bullet, one-page outline, so you have it very conveniently. Previously, I wrote you a memo. So I'll distribute that again, so you got that in front of you when you consider that issue. There's evidence that they have to put on to prove standing. You just don't get up and say, I think I have standing. You have to do more than that. So you need to give them a fair opportunity, and that's decided by you based on their entreaties to you, a fair opportunity to present that case. They also have a fair opportunity to present their main case about why the project should not be approved or why it should be modified, et cetera. So if the board can give me an indication of which of the two alternatives, then I can ask the council to come up and very, 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 very briefly, they already know that I have talked to them about this, to explain the amount of time they want and whatever their arguments are as to why you should grant them that amount of time. Yes,
All
sir.
right. I understand. So we have two possibilities right now before we get started. The issue really comes down to if we do something first to determine standing, which would be the first part, what you call Plan A, we would have to, before we started, come to some agreement among us as to how much time would be allotted to each of the people. Now, one of my questions is, we have Mr. Tanner representing the city of Flagler Beach, as I understand, the six.
Yeah, preserve, yes, the 6 individuals and
Do
preserve
they each
Flagler Beach.
do they each get time? Or would it
He
just
has
be
to-
Mr. Tanner?
He has to figure out the way he's going to present his case, but he would need, in order to establish standing, he would need these 6 individuals and his organization to testify.
Chairman, maybe I can help with that, if that's.
Well, wait, just wait one second. I'll let you, but I don't want to let you have to say anything yet. So back to the board, I want to make does everybody understand where we are right now? We can go forward and have all this done within the full, what you call Plan B. However, time then becomes an issue. We don't want to force everybody to just talk about standing and not talk about.
Oh, believe me, they will talk about both aspects, the standing as well as.
But we haven't
the merits.
determined the amount of time.
That's correct.
So my guess is that there would be a shorter period of time for each party if we do Plan A to get the standing agreed to. If we go forward to the rest of the meeting, I mean, will we just do first standing in that part and then do the rest?
Correct. In other words, you would hear the standing arguments, and whatever evidence they have, you would deliberate. You could choose to decide it, or you actually could lawfully say, you know what, we want to defer our decision about standing until the end or till some other time. So that's an option thing you have.
Right, I'm just trying for the rest of the members to understand what we're doing here. So my first question for consensus would be, would you rather go Plan A, which would be determine standing prior to the major part of the presentations, or do you want to wait and do it all together, for instance, after Adam gives his introduction? So, I just ask you for thoughts on that.
Mr. Chair, just a question. The difference between standing and not having standing is just a matter of time, is it not? The amount of time that they get to address us. Is that fair, or is it?
It's a little bit, Mr. Commissioner Hanson, if I can, it's a little bit more than that. It gives them a legal presence in the case different from a member of the general public.
Okay. Right.
Now, I don't know what the lawyers have in mind. Obviously, I don't really know how this, I mean, I got a conception of how this hearing is going to go, but I can't know exactly. So, for example, a party is permitted to say, look, I'd like to cross-examine somebody who just testified. Now, you do not have to allow, the rules are such that this is not a judicial proceeding. That's why it's called a quasi-judicial proceeding. It's less than a court proceeding. So you can fashion your own, you could, for instance, say, all right, we're going to grant standing, but nobody can cross-examine. You can choose to do that. Or you can consider it as people come forward, as they may ask. So you're shifting to a place where there are three parties.
Right,
If you grant standing to those requesting it, you'll have three parties.
That's one of the questions I had. So there are three possible people requesting or parties requesting standing.
Like,
Well, the city of Flagler has. Yeah. Well, no, but they said, but he already has standing.
He has standing.
Right. But what about, you mentioned Mr. Tanner, but what about Flagler Beach?
They want to come up and make their presentation and have.
Do they
standing.
want standing?
Yes, sir.
Okay.
Yes, sir. They have communicated that.
Yeah. Right. So, other comments from the board before, and before we go further now, since we're getting ready to start, I have to go back on the quasi-judicial. Any information you'd like to put forward concerning this issue that would keep you out? Okay, I have nothing to report.
Communications, these would be communications you've had.
I've had communications.
Outside of this.
But not anything leading to a decision.
Mr. Chair, I didn't, I apologize, I wanted to.
Okay, but let me get to quasi-judicial.
No, I wanted to ask a question before we do that.
Oh, okay.
I wasn't ready to give up on that
Okay.
earlier discussion.
Yeah.
Do we even have to have a request for standing? Can we make a motion to deny that right now without any conversation?
That's a good question.
That would be fraught with risk because they have a due process right to ask you for standing.
Okay.
You can choose to deny it based on finding their presentation insufficient, but no, you would not have the option since they have made it quite clear in our record that they want to seek standing.
Okay, thank you.
Okay, so back to, I want to get to quasi-judicial. And Mr. Quasi-judicial information would have to be put forward?
Well, I've received many emails and many conversations in the public with folks on both sides of this issue. I received a briefing from Mr. Belchi well over a year ago on the project. And I think the rest of it's public record in terms of my email.
Right.
Yeah, Mr. Chairman, I'd like to amend I said nothing because nothing's different, but in the same boat with Mr. O'Brien, I've had tons of emails, some of them not very nice, and have met with Mr. Belchi and his attorney.
I would say the same.
The only additional information I've had from Mr. Tobin called me today and gave me his opinion.
And I've responded to emails, but only that I would look into what they're saying, and have not had very little conversation with the other side. Actually, I don't think I've had any since I've been elected.
I'm trying to just get through this first part. And you
And Mr. Chair, but to conclude this first part, so I would like you, since this is we've got attorneys involved in this case right now. You've stated what information you've seen, and I just have to query you. Will you be making your decision based on the evidence that you have seen or heard in the context of this hearing and the prior hearings that we had on this matter?
Yes.
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 Thank you.
Okay, but before we go on, I think that the issue right now is, do we do the standing decision before we start the full part of the meeting, or do we do it as, what you explained it as A? Does anybody want, it'll have to be a motion, right?
You can decide it, you
Just
can
by
decide it by consensus. It's,
All right.
I would go with Plan A, get it out of the way. That's what I
Carly,
think.
any thoughts on that?
Let's do that.
Plan A. Plan A is do it first. First. So we have 4, and I make it unanimous that we do, and before anybody says anything else, that we do Plan A first. Now, Mr. Hadid, the next item is how much time do we give people during the Plan A part of this
correct.
Plan A?
And for that purpose, I would just have the council approach and each one state what amount of time and why they think they need that time.
Well, I wouldn't think they would need much time because they're going to come up and give us their bona fides. They're not going to come up and make their case, correct?
Well, actually, there will probably have to be some evidence taken in order for you to make the standing decision.
Okay, I'm going to give a general thought, that it's not a half an hour, and it's not more than 15 minutes.
Give 'em 10.
But I'd like it to be less. But I guess we can start into that at some point. But this is not the full rendition of everything involved here. It's purely for standing status. So with that, how do we want to order the people to come forward?
I know whoever's closest to the mic, Mr. Chimento.
All right.
You mean to tell you about how much time they need?
Yeah.
He's already got.
Well, but he can talk about it. He can talk about the others.
Commissioners,
Why
good
do you
evening.
need to talk?
Good evening. Yeah, but obviously, we are a party,
Right,
correct?
yes, right, you are a
and
party.
We have standing, so we're here to do this, but, anybody seen this?
Put a
book
clock
before?
on it just so we have.
Anybody
some-
seen this book before? It's called the Flagler County Board of Commissioners Rules and Procedures. And you go to page 6 through 8, it has your quasi-judicial process and procedure. It doesn't talk about standing, it only identifies us as a party. But, you guys can do whatever you need to do. We're here. We object to, for the record, in the event that there's appeal to, that they do have standing, and that they are a party. Haven't seen any case law come from the county attorney to support this or the other side.
Say
We
they
have our
do
side.
or do not?
We do not agree with that they have standing, that they are party. But I do want to draw to your attention about a month and a half ago, and I sent you all an email at 3:20 today that you could probably pull up on your phones. I don't know what we're doing here today, because if you recall, we had 7 minutes apiece at the prior hearing as to whether Mr. Tanner had standing. And this issue's already been litigated. I mean, it's on your video, it's on your website, and it was a unanimous decision that no, he doesn't have standing. So I don't know why we're here again today, but we'll defer to your judgment. I know you have a larger picture that you have to deal with, and we're here to rebut any evidence that they put forward, sir.
Okay. Thank you. You'll have more time if you need it. Who's next, Mr. Tanner, or who's speaking for Flagler Beach?
Bruce Smith on behalf of the city of Flagler Beach. I will be as brief as I can. I think I can fit it into 3 minutes. But I am going to start with a story because it's a story that's important on this point. It's a story that's guided my career. And one of the hearings on this matter, I hear stories when I go to my city. I heard that the deputy county attorney was asked questions by respondent's attorney. One of the questions was, where were you in 2005? How old were you in 2005? Well, I can tell you where I was in 2005. I was defending a plan development approval in one of our Orange County jurisdictions. It was the first major litigation I was involved in. It has guided my career because the main issue in that case was the final hearing on that development had occurred the week after Hurricane Charlie had come through. The appellants, their main argument was that they were denied the ability to come and present their evidence and testimony because of the impacts of Hurricane Charlie. These were just neighbors. Their interest was, we're neighbors, we'll be impacted more than people who live further away. We live right here in this development that's going taller than we're used to in this city, will impact us more. Just neighbors. We won the lawsuit. We proved that Hurricane Charlie did not prevent them from coming to that hearing. They prioritized getting over Hurricane Charlie more than that hearing. And the judge ultimately agreed in 2007, on the eve of 2008. We all know what happened between 2004 and 2008. The delay of litigation has killed more projects in this state than adverse rulings ever will. When you don't let people come and present evidence and testimony, you are putting a bright silver fishing hook out in the water for an appellant to latch onto and for a judge to latch onto. Because not all judges have heard a lot of land use cases. They all know due process. And they all know a right to a fair hearing. If you deny that, you are putting a silver fish hook in the water. Introductory remarks. As the City of Flagler Beach, I'm going to ask for judicial notice on these, Al. We are the water and wastewater utility provider. I don't think there's any dispute about that. We own adjacent property. We are the adjacent, or actually in the county, adjacent jurisdiction to this development. It will impact our services. It will impact traffic in our part of the county. Good, bad, or indifferent. I'm not saying it's a bad project. I'm saying it's going to have an impact that we're going to have to account for. It's going to impact police and fire protection because, as you all know, we have a shared services agreement, mutual aid agreements. There will be impacts. I don't think there's any dispute or controversy about that. I don't think I need to ask Mr. Torino to testify to it. That's why I'm asking for judicial notice. I believe the city fairly, really hands down, should be a party and have that opportunity in this case. Thank you.
Thank you. Well, Mr. Tanner.
The assertion of standing is usually an attempt, sometimes successful, sometimes not, to not allow someone who believes they have an interest to participate in litigation or in the issue. And here, this isn't litigation, this is quasi-judicial, which is kinda. To deny standing to, first of all, preserve Flagler Beach, Beulah Creek, Inc., call them preserve, would deny a large number of citizens. I think we had hundreds, I think it was probably in the neighborhood, a little over 1,000 petitioners. And we have 6 individual citizens in addition to preserve. These individual citizens and the citizens, many of whom are Flagler County residents, many of whom live on John Anderson Drive, many of whom receive the notice, what the citizens are concerned about with regard to this project is loss of quality of life for them, a total change in their way of life. When you take a 300-plus housing development on 50-foot lots and almost like a starship, you drop it down in a small town, community-type neighborhood, you totally change the dynamic of that neighborhood. And this is, in effect, a proffer. Here's what my witnesses would testify to if they're given standing. Now, granted, after you make this decision one way or the other, they are still going to have an opportunity to make public comment. And the reason I kept saying that, Mr. Chairman, I thought I had something that would be helpful with regard to the standing issue specifically, and that is, rather than me put on my witnesses with regard to standing, because I believe due process would require that, or at least the board accepting a proffer as to what they would testify to. If we weren't allowed to put on witnesses or make a proffer, and I'll join Mr. Smith, I think it would be a setup, so to speak, for the board to be appealed and to lose the issue. I mean, I know that you know due process. We have lawyers in the group. We certainly have good common sense businessmen, and you understand what's fair. Due process in this context really means a sense of fairness. But I have witnesses, I have individual clients. These 6 aren't a group, they're each individuals. And they will not necessarily all testify to the same thing, but among the things they would testify would be loss of quality of life, a loss, and this is if this project is allowed to go forward as slated, loss of property values, a loss of the small neighborhood atmosphere and community harmony. Some of them are,
Keep going.
I'm sorry?
Keep going.
Some of them live down along the water on Palm Drive. And the flooding issue, they fear, and rightfully so, enhanced, if that's the word, certainly heavier flooding than they would experience otherwise. The road traffic increase is significant, proposed. 300 plus homes, and I don't believe, I don't have the numbers, that whole Palm Drive and those little, a couple little subdivisions right in there, and mostly, one subdivision actually, mostly individual homeowners are all right in that cluster, and they are suddenly going to experience not only tremendous increase in traffic, and they've been seeing that with Seaside Landings, the dump trucks and all that goes on, but the planning, it looks like the planning of this, if this proposal is passed without requiring the bridge, they're going to lose their front yard, some of them.
But I think you're getting off the subject of just the
Yes,
pure-
sir. Yes, sir. Well,
So if you could wrap up the standing.
all right, loss not only of property value, but actual physical loss of their yards by the expansion of the roadway is a genuine harm that they individually will be experiencing. The loss of fragile natural resources. This is a causeway for deer and turkeys and gopher turtles. And the slaughter rate would go probably triple with regard to this development being plopped right in here with this massive amount of population. Enhanced danger during the evacuation process. There is only one way off John Anderson when the hurricanes come. In fact, just when we get a storm, you can't go south. Walter Boardman's closed and High Bridge closed. There's only one way out, and that's north to 100. You put all 355 homes, or 333 homes in there, and add that to the residents who are here now, Adams Seaside Landings, and you're going to have a tragic, perhaps, incident right there at 100 because of people evacuating. It's not just hurricanes. It wasn't too many years ago we evacuated John Anderson because of the fires when they were burning the country up.
No comments in the audience on anything anybody says. None, or
So-
you'll have to be leave.
Thank you, sir. So the enhanced danger during evacuation times is clear with this plan. It also creates an aesthetically unattractive or displeasing tract home type environment. And finally, it's disorderly, is not consistent with the community, and it's abrupt total change. That's a proffer of what the witnesses would testify to if they were allowed to testify as to standing. I also have several experts that would testify with regard to the standing issue, and these clients of mine, the individuals and the group, want these experts to be able to at least give their testimony so this board can make a decision. We're not trying to hide things from you. We want you to have it, but so you can make the right decision, let us inform you. We're not going to take up too much of your time. We'll do the best we can to expedite it. Thank you.
Thank you. Mr. Chimento, get her to speak.
Thank you, gentlemen. Again, I'm not sure what we're talking about here, standing. I mean, what do they have to prove to you all in order to demonstrate standing? I mean, that hasn't even been briefed to you as of yet. I do recall last time when we talked about that group that he represents had to show some unique injury that was so unique to that one individual and not that to the general public could get them standing in court, but that's different. So, you know, we're here again talking about the same thing we talked about last time about change in the community, traffic on the roads, turkeys being slaughtered apparently, aesthetics, tract housing. These are all things that are what the public is affected by, not the individual lot owner. There was a comment made about their individual people on Palm Drive. His representation to your city or county attorney tonight is he's not representing anybody on Palm Drive. So just lots and lots of confusion, but really it boils down to one thing, and we want to give everybody an opportunity to be heard. I think the 7.5 hours that we were here before certainly was a lot of time, and we're here to sit through another 7.5 hours if that's what you want. But this standing thing is a unique legal precedent and what they're able to do. We have no problem with them having time to present their side, to present their evidence, but to give people or organizations standing in a site plan. This isn't even a PUD. The PUD was approved 2005. This is a site plan, whether the site plan is consistent with the PUD. Standing to debate that, you all are going to set an incredible precedent that someone may say, I have standing, and derail this whole process. So if you all want to grant standing, that's at the discretion of the board. We certainly, for the record, object. There is no such thing as standing in a quasi-judicial hearing on a site plan. In this case, they're not a party. There's no unique harm, but we are more than happy to not object to them having additional time, as your rules provide at the discretion of the commission to present their evidence in which you all base your decision. Lastly, in closing, this isn't a whole new rehearing. When we had the last 7.5 hours when we were here, the commission said, we want these 3 or 4 issues addressed. We're not going to relitigate this whole thing again today, I hope. So we're here at the request of the commission to brief you on what we've done to address those 3 or 4 issues in which you can base your decision on. So, thank you.
Chairman, may I offer?
Come forward if you're going to do it, but you have to explain what you want. I mean, basically, it's a 3-minute thing. You've had 5 or 6 so far.
Yes, sir. I just want to introduce some reports from our experts that we would be calling as a part of our proffer.
But does this have to do with standing?
Yes, sir. Are we going to be able to present our experts in our case in chief? Do we have to wait until the public comment time? We have 4 experts that we'd like to at least file their reports, so if there's an appeal, or so this board can look at the reports briefly and see if this is the type of information that will help this board make the right decision.
I'd ask our lawyer just to give me a little guidance here. I'm not a lawyer, and not telling me which way to go. Just give me some thoughts on where we go at this point on the standing issue only.
And I'm just seeking, Mr. Hadid, a proffer of the testimony that would be offered in support of standing.
I understand, Mr. Tanner. Okay, standing is a part of due process and land use. If people have standing, we have to recognize that because they have to establish the facts here if there's any possibility they're going to be in court. If they're going to a reviewing court where they're not permitted to submit new evidence, they can only argue the evidence that's here, they have to put their standing facts and determinations into this record, this proceeding. So yes, our rules of procedure don't mention standing, but that's because it only occurs when somebody comes forward and presents that for decision. if we grant a party standing, it gives them more legal status in the proceedings, gives them the ability to take more than 3 minutes, for example. Now, let me tell you that there's, the expression, well, no, I don't want to use it. Well, there's a lot of ways to do the same thing. I was going to use a popular phrase, I've decided not to. I don't know what the board is inclined to do, but I want to make sure that I'm giving you all the options for you to consider. You could say, you know what? I don't want to decide they have standing, but I'll give them the extra time to present their experts. Okay? I don't want to give them standing, but I'm willing to do that. So what that does is it minimizes the prejudice, it minimizes the due process, because what is due process? Fairness, giving them an opportunity to fairly present their case. If a commission said, we're going to give you 5 minutes to present this case on why this development order shouldn't be approved, whatever, that would clearly be a violation of due process. You can't make that argument with facts or in legal argument in 5 minutes, okay? 3 minutes is typically left for public citizens, not experts, not people who are certified and licensed, okay? So I have made extra copies if you want.
Well,
It's,
might as well give 'em out.
you tell them? Okay, I'm going to walk up there so that people can see the standards and you can see the standards. These are the standards that apply. This isn't made up. This is from the case law.
It's not on, we're not seeing it. I think he's. There, it's coming out. Okay, just kind of.
Okay, we're going to just alter the stuff here just for a minute. I don't know if everybody can read that, but those are the standards. So that should be on your monitors, right? You're seeing it on your monitors? Okay. So I'm sorry that it's complicated. This is what the courts have done, okay? So the courts, to make it, you think that you have a challenge here, the courts establish different standards depending upon the kind of claim you're making. So the first is, and I'm not judging exactly what they will do, but these are things that they could do in this case. They could say that the proposed PUD modifications violate the county's comprehensive plan. In that situation, the courts allow greater liberality in granting standing. So this is what they have to show. I've highlighted it. And by the way, that's quoted right out of case and statute. They can talk about health and safety, police, fire protection, densities or intensities of development, transportation facilities, healthcare facilities, equipment or services, and environmental or natural resources. What they have to show is that those issues affect them more in degree, in impact, than the general public, okay? So that's what you have to do for a claim based on a comprehensive plan violation. Now, Roman numeral 2 is much more difficult. That is much more difficult to establish standing intentionally by the courts, intentionally. And so if they are going to argue, the challengers, any challenger is going to argue that the modifications violate the PUD ordinance, you've heard people talk to you, I've seen that in emails, or if they argue that it violates the land development code, and we've seen that in emails, right? Then they have to meet this standard. And that is they have to show that they've suffered special damages, which are different in kind than those suffered by the general public. Now, I can't tell you what that is. You hear what they have to say, and you make the decision. You're applying these standards. And again, there is, as I said, there's another option where if you find it difficult or you don't want to make the standing decision, but you're willing to grant them the time to put on their evidence, to put on their experts, it's like allowing them to do that, but you're not granting them party status. That'd be an option for you. I'm not suggesting it, I'm just letting you know what your options are. But this is what governs. This is not mentioned in our rules of procedure. Can you imagine if we had to put this in our rules of procedure and explain it? It only comes up when people ask for standing, party status. That's why our rules of procedure that were adopted in 2016 don't call this out. We deal with it as it comes up. That help? I hope
Yes.
that helps.
All right, thank you. Before we, I just wanted to come back to the board. We could go on back and forth on this all night long. So I think I need to get some feeling from the other board members as to kind of which way they have feelings on this. I want to avoid, as chair, saying anything right now. I'd like to get your opinions, if you want to give them, on what on this part of the hearing or the event tonight, which the way you feel. Charlie, do you have any thoughts at this point?
I don't have a comment at the moment here. Still thinking.
Yeah, I got a comment. I think we should just avoid the issue of standing and give everybody a fair shot. If you as chair make sure that everybody has a fair shot to come talk to us and present their evidence, I don't see this standing as an issue. I think we should not do that.
Brian?
As you know, I made the motion to deny standing at our last meeting.
Right.
Or the meeting that we had this on the agenda. But I want to make it real clear. I feel like Commissioner Hanson, I want to make sure that I hear from everybody. I'm not in the business of wanting to deny anybody due process. But if, as a compromise, if we wanted to give some extra time to expert witnesses, I'm totally amenable to that. Or whatever, maybe changing of our specific rules we have, that's fine, but I wouldn't want to move off that original position that I had about standing.
I'm in agreement with that, too. I think the big issue here is the time and being able to present their side. So, so we're not doing a redundant thing where it's the same thing over and over. We need to get to the decision on this today. So I'm in agreement with them.
Okay, at this point, one of my feelings was to do this first part first, so that we don't have to go back over all the standing stuff when we actually go through the issues that are involved. It appears that at least 3 of the members of the board feel that the decision should be basically an in-between decision, which is to give the parties that are involved, not do official standing, but give them sufficient time. We could call it equal time, or we can come up with a number ahead of time, Al, to give some idea for the first part, before the public speaks, when the 3 parties involved would have a certain amount of time. And I'm guessing that, I don't want to say it, but I'm guessing maybe in the neighborhood of a half hour or something like that for each of the 3 groups to speak. Now, I don't know what else to say on that, but I would like to do both, come to some agreement that everybody will be given essentially equal time, and with some idea of how much time that actually would be. Does anybody differ on that, or is
No, I go along with that.
that about what you're thinking?
I don't know if they need that much time. I don't know.
Well,
It seems like a lot of time, but.
Well, they
but-
have the experts that they
Yeah.
can. And they don't have to use all of it. I'm just saying that we have to have some limitation. And so that's kind of where I would come down. I mean, so we've all,
Score points for brevity.
So if somebody, everybo's allowed to speak. I'm 20% of this.
No, I think a half hour is probably a good start. It's a good, I don't think they need that much, but,
Well,
yeah, it's there for them if they need it.
Maximum.
we're not doing official standing. We're saying equal time during the presentations. Is that kind of with each party involved, 30 minutes or less? Does that make sense?
Yeah.
Yes?
Yes.
Yes.
Okay, that's our decision. Well, that's our recommendation, I guess.
Well, that's how you're going to proceed.
Right, that's our
And I
proceeding.
think that the lawyers understand that they need to present their cases efficiently as they possibly can and minimize the duplication of information. So we can get through, everybody has the same interest. You want to hear all the information, but you want to do it in an efficient way so we get out of here at a reasonable time. Correct?
Fine with me. So do you need any other guidance? So that's the way we'll proceed at this point.
Then, Mr. Chair and members of the board, then you revert to the normal order, which is you have Mr. Mengel come before you and present the case. And then you would hear from the applicant, and then you would call upon the city of Flagler Beach, and then you would call upon Preserve Flagler and the individual citizens who petitioned you for standing.
Okay? Yes.
Clarity for the record, point of order. Are we going to start all over and do the presentations? Or are we here to continue what we talked about for the 7 hours and address the issues that you want?
My understanding is there were basically, the city of Flagler Beach wrote a letter
Correct.
to us, and I think they addressed 4
Correct.
topics. And I
Agreed.
would hope that those would be, looking, before I say something I shouldn't say, I would think that that's why we're back here. We had 7.5 hours.
Right.
We talked about lots of different things. We want to go back over what the board, and then supported by the city of Flagler Beach, thought were the significant issues to discuss.
Excellent, thank you.
Does that make sense?
Yes, sir.
Adam?
I get 30 minutes.
Floor is yours.
Hot dog, 30 minutes. Yay! Adam Mengel, Growth Management Director. I'm going to skip through a couple of these here at the front. This is the property. This is the property's future land use designation, the future land use designation in Flagler Beach, the property's zoning designation for us, plan unit development, and the nearby zoning designations in the city of Flagler Beach. Our flood zone map that we had, soils map, then wetlands that we have that we're dealing with on the property. And this is that conceptual plan, the 2005 conceptual plan. This is what accompanied the 2005 Planned Unit Development Agreement. And this is that language from that, the general notes and my highlight from last time. And I'll say it again one more time after this. Entitlements include 453 units. 150 of the 453 may be multifamily, distributed, clustered within noted use areas. And then we had the 2006 site plan. This is when we started putting meat on the bones. So this is our more specific one. Here's that detail from the top, that 2006 plan, the bottom. And then that development program that they listed with the 453 units. And so this is what was approved. And then this moved forward, that 2006 site plan became the 2006 plat. And so that plat was for the entirety of the development, both sides, east and west, of John Anderson. And then that's the actual area there on the platting, the detail that shows what was happening. You had the detail on the east side with the 219, 220 lots that were platted as part of this, and the rest of it in future development tracts. Along with that, our public lands tracts that were part of that discussion. And so here's that part I wanted to emphasize on entitlements. And so the note again from the site plan, 453 units, distributed cluster within noted use areas, and then our commercial within the mixed use area. And then in the PUD itself, land uses including residential density. And what I wanted to emphasize with this, and this part of the presentation, is what I had gotten a little flustered about last time, where I think everyone was being a little loose with the language. And what I'm intending to convey to you here is the mays, the shalls, the wills from the PUD site development plan and the different agreements that are here. We'll also touch some of the settlement agreement in just a few moments. So the land uses, including residential density, may be distributed throughout the property as depicted on the conceptual site plan, that 2005 conceptual site plan. Development of the property as provided in this agreement is consistent with uses, densities, and intensities allowed under the comp plan. You had that established in 2005. For us to debate it now is not correct. The determination was made by the board in 2005 for the PUD that it was consistent with the plan. And so that site plan, that conceptual site plan, that 2005 conceptual site plan, labeled these areas just as you see here: single-family attached, single-family detached golf course. Pretty big range of possible things you could put there. Some specificity. Again, 2006 site plan, actual PUD site plan, added more specificity to that, led to the final plat. Also from the PUD Development Agreement 2005, 4.7, modifications to conceptual site plan. Skipping down here to the part that's highlighted, well, actually up here at the bottom, at the top, may be appropriate during development review. So you could do changes to the conceptual plan. Modifications that comply with the general land uses and applicable development criteria contained herein do not require amendment of this agreement or the PUD zoning approval where no conflicting provisions exist. I'd venture to say in your quasi-judicial role tonight, that's what you're trying to determine, is if there's a need for those changes to occur to the PUD development agreement. This is the PUD development agreement text, what I'm reading from here. 4.8, and this is fairly standard, where conflicts exist between the two, between your PUD site development plan and the PUD development agreement, provisions of this agreement shall prevail. Shall prevail. And then move forward then to 2012, and what I ended up bringing forward, I was here then. We did have some discussion, and maybe I'm going to make a little bit light of it there about who was here and who wasn't back in 2005, 2006. I came in just at the tail end of some of this happening and missed the plat, but did get to enjoy the plat vacation. And so the language here is from the site plan. My emphasis is my own language, not anything in any approval of, other than this is just what I came up with, and it's been cited a couple of times. Any future development of the subject property must be consistent with the PUD development agreement for Hammock Beach River Club PUD. This request makes no revisions to the adopted PUD, and subsequent requests for plat review and approval would be required to demonstrate consistency with the approved PUD or seek to amend the PUD to achieve consistency with the proposed plat. So there was some question, and you probably saw some of that correspondence about the bonds. And so I did address it the first time when we came through the first hearing, and in greater detail this time. The bonds did include the overpass, that portion where John Anderson was elevated above the under connection then for the development. There was some changes that I believe had happened that really weren't reflected in the testimony, but I think were consistent with the PUD site development plans, PUD development agreement language that you see here. Remember in 2005, we had this language that you see in front of you, 5.5 access. This section in its entirety was not presented to you last time. I've added the emphasis where needed. I'm going to read it all into the record. Access to the property shall be provided from the following public ways as generally depicted in the conceptual site plan. State Road 100 and John Anderson Highway. Signalization access management plans consistent with the requirements of Flagler County or Florida Department of Transportation shall be permitted at these public access points. Precise location of these connections will be determined during preliminary plat and development review as applicable. The developer may also provide below-grade or aerial crossings over John Anderson Highway for internalization and circulation of traffic and services, including roadways, drainage, utilities, golf carts, emergency vehicles, member vehicles, and/or pedestrians without an amendment to this agreement or the conceptual site plan. This section concludes, developer will voluntarily widen the existing John Anderson Highway pavement width to two 12-foot travel lanes along the project boundary limits that coincide with the John Anderson right-of-way. And I'm going to touch on this real quick. So I look back at the minutes. We had some testimony about the minutes and what was said, and I still conclude that the minutes are just reflection of history. This is your guiding document. This is the ordinance.
Please, no comments. Any comments, you'll have to leave.
And so this is our adopted ordinance, best I know. Didn't know it's been amended. I guess somebody else must know that. And so your minutes that are there that said, in the record, please, board, take away that may. That wasn't taken away by the board. You also then had, at that same time, discussion, I believe in that same meeting, I believe I'm saying it accurately, discussion from GIN representatives that said, you know, we want some exclusivity with this. We're probably going to do this thing. And then by that time, 2006 site plan came up, that thing became separated crossing. They wanted that exclusivity. That was definitely incorporated into the plat, definitely into the PUD site development plan. It shouldn't be subject to dispute. One of the folks that I think we normally see, which he's missing tonight, had sent me several interrogatories saying, what about these bonds? The bonds were released when we vacated the plat. The bonds did include all the improvements. They included every bit of horizontal infrastructure. They included the connection on 100. They included then that overpass, our John Anderson going over the project linkage. There was not only vehicular linkage, but also for golf carts. There was an agreement that the board at the time had also entered into with the developer, 2006, same time as the original plat, that allowed for effectively a license, an agreement between the developer and the county for usage of John Anderson to provide that overpass connection. Remember the conceptual plan that I showed you before.
Excuse me, Adam, just clarification. So the bonds are null and void with the vacation of the plat?
Yes, sir. And so this is that graphic from the conceptual, 2005 conceptual plan. This is what was adopted as part of the PUD development agreement. And then this is that same area by 2006 in the 2006 PUD site development plan. You had the specific reference, John Anderson Highway overpass with underpass for Hammock Beach. So again, that conceptual, here's what it was approved as eventually. Some discussion about evacuation routes, and wanted to make sure I had some clarity on this, and this leads into another point that's come up very recently. And so this is from our adopted comprehensive plan, and the point here is that in that light green, that kind of electric green color, those are our evacuation routes, and John Anderson isn't one of those. And for good reason, because everybody's talked about why it shouldn't be, so it's not. And so we're not going to depend on John Anderson to evacuate anybody out of the county. No doubt people are going to need to get on the road to get someplace, but it's not an evacuation route. So others had said, well, it is. No, it's not. And then the discussion then about what I had put into the agreement, into the staff report this time, about level of service. And we have some language in our plan, our 2010 plan, that talks about peak hour level of service by 2035. If you can't see it there, the entirety of John Anderson south of 100 is labeled as level of service D for your 2035 peak hour level of service. At the same time, the vehicle trips per day were expected by 2035 to total 12,360 trips with that level of service D. And that would then be a failure. And so what we had put into our comprehensive plan, and others had seen it and come back and provided some commentary, and you even heard it mentioned just now, is that our comprehensive plan labeled 4-laning of John Anderson to occur by 2035. And what I'll submit to you is that John Anderson doesn't have enough right-of-way. At its north end, when you get there, you're either going to be asking for land, you're going to be buying land from a willing seller, or you're going to be working out a purchase through eminent domain. That's how this stuff works, and that's if you choose to widen it. The other thing you can do is you can make a choice, very much what Volusia County had done, and you can say it's constrained. Walter Boardman at the south end, maybe I'm embellishing it a bit, but they just said it's constrained. There will be continuing traffic that will be on there. It will degrade. It is constrained. We have made, our board had made a similar determination on A1A. We wanted to have it stay 2-laned. Previous board had come back and said it's constrained. We're going to leave it at 2-lane. That could be a decision here also. This is in your adopted plan to 4-lane it. I didn't remember it. I'm looking at it. I don't think it's possible to even do. It doesn't make sense, and especially at its north end, and especially with the scenic highway designation. For utilities, and that was more of a direct question I think that we had that came out of the last meeting, this is the language from the PUD development agreement. I was a little upset with the looseness that came with how this was discussed. And so again, in that same frame, I've included here the wills, the shalls, the may. So under that 5.0 in the development agreement, project will include infrastructure to support the proposed uses, including potable water, fire protection, reclaimed water, irrigation quality water, and wastewater service, drainage, roads, access, and transportation to meet concurrency requirements. Will. 5.1.1, project is located wholly within the county limits and is within the Bureau service area. All proposed permanent uses within the project will be served by central water and wastewater services, except as provided herein. 5.1.3, irrigation and other consumptive uses. Project will incorporate reclaimed water as the primary irrigation source, but may include supplemental private irrigation wells for golf course irrigation, residential common area irrigation, other appropriate consumptive uses. Project may include a master irrigation system, residential and common area landscape irrigation, and golf course uses. This was important here for me, and part that I didn't know about that I learned after this, and I'm hoping that somebody can maybe shed some light on it, was that this property was initially subject to an annexation request in the city of Flagler Beach. So before it was ours, it was the city's, or at least potentially the city's. The referendum on it that's required by their charter before the annexation occurred appeared to have failed. I'm a little worried that that wasn't mentioned before. And so think about the situation, 0405, city's considering it, it doesn't happen. That's not to blame the city officials, it's not to blame the voters either, it just didn't happen. Well, then the developer comes to the county, and then it becomes a system provided by the developer. Before, it was going to be connection into the city's utilities to help the city. Then it becomes the developer providing that system to us. And then it would then become a county system. Well, then Flagler Beach, maybe inexplicably, objected to that and was a party to the settlement agreement and brought us into the water wars because it didn't happen like they didn't want it to happen. It didn't happen because it failed on the referendum. And then the developer came to us, and the county was going to provide it, but then the Flagler Beach came back and said, we don't like that because it's right next door to us, which doesn't make sense, but the deal couldn't be struck in Flagler Beach. And so Flagler Beach then objected to it. It's weird. It's odd. And so here's a settlement agreement language. And I'm going to pull out just that one part. Flagler Beach shall provide reclaimed water directly to the POA for use in the project known as the Gardens at Hammock Beach PUD. And we also recognize then, let's see, the next sentence down, and the POA reference here, by the way, read in there the developer. That was the Property Owners Association for GIN. The county and the POA shall not build water or wastewater treatment plants to serve John Anderson corridor, provided, however, Flagler Beach is unwilling or unable to timely expand capacity for county needs, including the PUD property. County may build or expand. POA shall design, permit. This was back in the heyday again. Remember the timing. This was right at the end of 2006 before the bubble burst. We have other regulatory matters that were included within this. Utility asset transfer agreement that was going to happen. This section here, 4.3 subpart 1, deleted the requirement for the POA to convey the utility site to us. Because as part of that unraveling, the utilities now were going to be provided by Flagler Beach through the settlement agreement that settled our water wars. POA was going to design it, construct reclaimed water treatment facility capable of producing 1.0 million gallons per day of reclaimed water, meeting FDEP requirements, at its expense to be located on the Flagler Beach wastewater treatment plant site, conveyed at completion of Flagler Beach. And in exchange for that, this was kind of left out some too, there were ERCs, equivalent residential credits, equal to 865 ERCs that were due to the POA for that exchange. So you build it, this is what you get in exchange. And that's not only on just the wastewater side, but I think it also tells you on the water side. And so that's the quid pro quo that was outlined in the settlement agreement. I think that was lacking in some of the discussions that I had heard. And so, to me, this is the telling parts that you had asked us to look at before. I'll convey to you, and you saw it in writing. I didn't pull any slides about it because I don't really want to draw attention to it. We have situations just like Flagler Beach does in Custer's, in those two subdivisions there on Palm Drive, where at the timing when they were brought forward, there's some very ambiguous language about who's maintaining what. There was an HOA that I think was formed maybe for a year, maybe two. The HOA went away. HOA didn't maintain anything in the end. The city doesn't look like they maintained anything either. And again, I'm going to say they're not alone with that. You'll see when Relay Ridge goes back, we have this same situation coming back for us to be able to discuss. And again, it's because of the timing. It's when those plats came through. It's when the Water Management District had its set of rules. They met the requirements at the time. And so not to place blame, not to find fault, but just to look back now and say, it's a fix that needs to be done. If there's something remedially that needs to be taken care of, then it's something that needs to be decided and be done in an equitable fashion. And I think that's something that's fair for everybody to acknowledge, but also to acknowledge at the same time, it's not the gardens that caused those problems to happen. After our meeting, I was contacted, full disclosure, by staff from the Water Management District that shared with me that they took offense to the idea and the concept that there would be harm that would be caused by development that would be permitted through their regulations. I agree with them on the face of it. I understand other emails had come in and said, this is a problem. How should I trust the government? What possible role do they play with this? It is their role and their singular role. And so my lesson for all of us is that no doubt we can be more restrictive, but at this moment we cannot be. The Water Management District maintains authority over stormwater, and their rules say, here's the requirements, you meet the requirements, you're able to proceed with your development. And I think that's where we should leave that issue. To me, it still boils down to the three decisions that I had come back to you before. And this is through the new PUD site development plan that's being presented to you. I think your issues are the 335 lots east of John Anderson versus the 219, 220 that were shown on the 2006 plan. Remember, the 2006 PUD site development plan is what I'm talking about. The at-grade intersection driveway with John Anderson versus 2006's John Anderson Highway overpass with the underpass for Hammock Beach and the entrance at State Road 100 being slated to coincide with future phases. And then the final part, which I think we've more or less settled, utilities provided by the City of Flagler Beach versus 2006's on-site utility system in Public Land A, the dedicated public utility site. I've got graphics here that show the site plans being proposed now. And then this site plan for the east side becomes that basis for the future preliminary plat that you have as item 9H on this agenda tonight. And so think of it, there is development that's being proposed on both sides. The site development plan is approving development on both sides of John Anderson. The only part that's being platted or proposed for platting tonight is only on the east side, the 6 phases on the east side of John Anderson. And there's no requirement for them to go through and do anything more at this point, but if they were intending to develop that in the future, they would have to come back with a preliminary plat application for us, for our review. One final point about Flagler Beach, and didn't mean to take offense. I did enjoy my attendance at their workshop, and I do enjoy the cooperative relationship that we have with their staff, with their elected officials. I did take a little bit of offense that there was a notion that we didn't include them in our processes. And I'll be very quick to counter and say that, in fact, the first TRC meeting that we had after we opened back up, they had a bit of a technical issue with one of their staff members who didn't have a microphone to participate with us on our Zoom meeting. And so there was actually email correspondence that's reflected in the public record that I placed online that reflects this. And so there were opportunities to participate where we had asked for that participation, we had requested it, we had sought it out, and they had in fact participated. And so I want to make sure that everybody knows that we had done our part, and I believe they also had done theirs. I think if I could defend their staff, and I'd be happy to do so, and I looked in the audience, my little chance at humor here, if I can get one more minute. I think I have the Flagler County Planning chapter that's present. I noticed something that the planners, we all have either gray hair or no hair, and it's nice to see us all together, and we don't usually get a chance to come out together too much. But I do consider them friends, despite what bad things they may say about me in a few minutes. We'll still be friends after this meeting. But with that, please consider where we are from staff, and I'm considering that also for my friends at Flagler Beach. Timer? I still have 30 minutes.
No,
The,
you have 7 minutes.
the
left.
feeling
That's
that,
all right.
that sometimes we're enabled to talk and sometimes we're not. And so I'd look for their comments today, and I'm excited to hear about those. And would consider then the 4 options I presented to you last time, but with an addition. First being approval, basically as submitted. You saw the conditions that I had provided previously. The second one being approval with conditions, and then I've added a separate item there, should be subpart E, but that subpart E then would be that you consider Flagler Beach's proposal and add what conditions you feel are relevant from their letter. So that's option 2. Option 3 would be denial. Option 4 would be tabling. In closing, I'd encourage you to make a decision tonight. If anything you do, please make a decision. Thank you very much for your attention.
All right, Adam, very good, and you have about 8 minutes roughly.
I'll yield
if
my
you need
time.
it. All right, you're yielding.
Appreciate it.
All right. I'm just going to hit the head. Go ahead, go ahead.
Michael Sciamento for the applicant. In my 20-plus years doing this, I'm going to thank Adam, wherever he is, for his very, very, very comprehensive approach to this. You guys have seen, I myself have 3 volumes, 4 inches thick, of documents that affect this, and it is very complex. It's not trivial, and the devil is in the details. So with that, I think I have to agree with everything Adam said. This thing has been through your staff for a good year, your engineers, your planners, your traffic people, your fire people, all your experts have put forth what they believe in the staff report and what Adam has reiterated to you. But one of the things that I need to remind everybody here that sometimes we get words confused, and it's very important. This is not a PUD modification. The PUD zoning happened years ago, as we've gone through. All we're here to do is what Adam just said, is to assure that that site plan that we're putting forth for the Phase 1 is consistent with the existing PUD and the PUD concept plan. We're not asking for any modification, despite what people ask and say in the paper. So I was going to go through the history of the project, but there's no need to do that, I don't think, and we'll get right to some of the issues. But before we address the Commission's issues, we do feel it's important that the public have a clear understanding as to what the facts are. That is part of the reason that we have this maybe now 13, 14-hour hearing on a site plan. There have been some things reported in the paper that you might have read that were put out there that are just absolutely fabricated and or false. So let's help the public and you understand. So one of the first things that was said is that we've asked for a modification. As I said, that's not true. This is an existing PUD. We're just trying to demonstrate, as staff has told you, that our site plan is consistent with the PUD and it complies with all your land development regulations, all the state and all the federal guidelines. So that's all done. The other thing that was talked about is that there is a destruction to the environment on this project. Remember, this project was 2,000 acres. It was litigated by the county commission in 2005, and what came out of it was a project that moved all the density intensity to the non-environmentally sensitive lands. We gave over 1,000 acres of sensitive lands to the commission, or to this county, years and years ago, and you still own them. What's left is an old timber farm, silviculture, and that area left on the east side, where I remind you that there was already a golf course being constructed before the recession. And I remind you that there was not this outcry at that time. So what's changed, I don't know, but all the sensitive lands that were in this project has already been conveyed to the community, to the project, to the county. There was indications that we're filling in wetlands and building homes in and around the wetlands. That's just false. That's just false. You know as well as I do that we can't build homes in wetlands. And in fact, what is before your staff, and they're very well aware of, and they have communications with St. John's Water Management, that there's about 2 to 3 acres of wetland impact over the entire project. 2 to 3 acres, and that's for a road crossing. That, in addition, that we're buying wetland mitigations in banks. So those statements by the public are just not accurate. Why they put those out there, I don't know. There was even indications that we're going to be building homes in the FEMA floodplain. You know what I would tell you? That's illegal. You cannot build homes in a FEMA flood zone. It's just not accurate. There are things that we do to modify the flood zone and do those things, but there's no homes being built in flood zones. There was a comment made in the paper that we're building just feet from Palm Drive. That's not true either. We are more than, I think, 75 feet, 100 feet from Palm Drive. So, some of these comments that are put out in the public to rile them up is unfortunate. And all we want to do is get the facts to you today and let your staff have an opportunity to review it. Let the state and federal agencies review it and make their comments to comply with the rules that are put out there. So at the end of the day, we suggest, as does your staff, as the St. John's Water Management District, that the rules that govern development in Flagler County have been complied with. Do they want the community to be there? Is it a change in the community atmosphere? Is there going to be more traffic on the road? Yeah, of course there will be. We all know that. Will there be the water, the reuse water that is presently discharged into the intercoastal be cleaned up? Absolutely that'll be. In fact, part of the process that we put forth, that you go through, is public involvement. We've been through TRC, we've had meetings with city staff multiple times. And I'd suggest to you that because of the process that is there in place, the process that is part of the county rules and regs, the process that is part of Chapter 163 and the community involvement, the project's gotten better. The project's gotten better. I mean, you got to remember, we've conveyed and are willing to work with the county on relocating their fire site. That was all part of the public. We have moved farther away from Palm Drive. That was part of the public and their communications with us. We have impounded so many acre feet of water because guess what we're going to do? We're going to use stormwater for our irrigation up until the city of Flagler Beach can provide us with reuse. Part of that conversation, too, is the developer went above and beyond and added $750,000 in additional expense to provide reuse lines in the ground today with the hope that the city of Flagler Beach can provide it. I do believe that'll happen, but in the hope. So these are things that we have done to improve the project at the request of the community and the public comments that have had. So to suggest that the community wasn't involved or not heard is just difficult. So you'll hear more from the community there shortly. But to get back to the issues, when we left here on this continuation, you asked us to address a few issues, and that was stormwater and flooding, the allegations of flooding. You asked us to address traffic, further address traffic. You asked us to further address reuse. And the last one that I don't think was a specific ask, but was a question, was the school board issue and how that's handled. So we've brought tonight our experts. We had them here last time. We're willing to go into a little deeper dive for you all and discuss those things. So if you will let us go through them one by one, we will. So let's draft traffic. The issue of traffic and John Anderson and the process in which it goes through. Sands Lassiter is a traffic engineer. He's been for you many times before. He's preeminent in our community, well-respected, and done lots of great projects, including those in Flagler and Volusia County. Remember, the process in which every development goes through is regulated by rules. This one, the county has adopted rules in which we and every other developer in our community have to go by in order to analyze traffic. I would argue to you that that has all been reviewed. It is consistent with your land development code. Your staff has approved it. So I'll let Sands come up and talk about traffic on John Anderson and how it affects our community and also how we have abided by the rules. Sands?
Thank you. Thank you. Sands Lassiter, Lassiter Transportation Group, now known as LTG. I'm a registered civil engineer practicing transportation and traffic ops, traffic engineering
for more than 42 years. I'm about to get some of it right. We conducted a traffic study. I think it was stated previously that a traffic study hadn't been conducted since the early 2000s. We conducted a traffic study and submitted that report in January of this year to the county. Those counts, by the way, were pre-COVID. There's been a lot of comments about traffic counts post-COVID, that they are down. We did not do our study post-COVID. It was done prior to the events that occurred in January and February. And we actually produced that report in January after doing the data collection in the latter part of the prior year. That study was done according to the procedures of the River to Sea Transportation Planning Organization, to which portions of Flagler County, Flagler Beach, Beverly Beach, and City of Palm Coast belong to and adhere to their procedures. The procedures are fairly rigorous. We have to identify a study area. We have to get that study area approved. We have to collect traffic counts. We have to then analyze those traffic counts for the existing condition. Then we have to add on the growth that's going to occur in future years, exclusive of the project. Then we have to specifically identify the improvements required by the project in addition to all that. And we did that. Our analysis clearly indicated that a two-lane John Anderson is sufficient. Our analysis clearly indicated they got to make a couple of improvements. Those improvements do include at the intersection of State Road 100 and John Anderson Highway. And they also include, they need to add turn lanes at the project entrances. And the purpose of that is to avoid delay to the through traffic. And that is what we have recommended. But I want to take us back to, if I can, to just a general concept. We're talking about the homes that exist on John Anderson and what we're adding to it. There's approximately 190 homes in Flagler County today, 40 homes approximately in Volusia County, for an approximate total of 230 homes on John Anderson. We're talking about adding to that over 300. That is a two-lane road. It has been improved to actual state standards by the widening that was performed in prior years at the request of the county. Then you go to Colbert. Colbert has 1,960 existing homes on it. 2 lanes. It has, just like John Anderson Highway, 2 routes, north and south. However, it is not suffering any issues with capacity. We're not talking about coming anywhere near that number with this development. We do have signals on both roads, and we understand that. And at signals, you do have to add turn lanes. It is a fact. The signals cut down the capacity of the through movement. You have to add turn lanes at intersections to accommodate the volumes. But clearly, Colbert is 2 lanes. John Anderson Highway is never intended to carry the amount of traffic that Colbert is. And it won't need any more than 2 lanes with this development. Could other development occur which might require more? It's possible. My opinion, probably not, but it's possible. But I guess what I want to leave you with is that Colbert and John Anderson are 2 different roads, but both of them are able to carry 2 lanes of traffic easily. And Colbert, in fact, carries that 2 lanes of traffic from a much higher level of development. That's kind of the end of my presentation. Any comments? I'd be glad to, or questions, I'd be glad to address them.
Is there room at the north end of John Anderson to put a turn lane in without impacting residents there?
Yes, sir, there is. It is not to put a turn lane in, it's actually to extend the existing northbound.
There is one there now, I
Yes,
thought.
but we need to extend it and make it longer. And we need to also modify the traffic signal timing at that location to accommodate that extended queue. But yes, sir, there is right away.
Okay, thank you. Any other questions for this?
Thank you.
Okay, and so that's traffic. Yes, sir. Please.
One quick question.
Yes, sir.
You said you're not modifying the PUD,
Correct.
but your very first quasi-judicial issue is request for modification of a PUD.
No, sir.
That's what-
No, sir. No. This is a
What's that?
site plan in a PUD. Right, this is a site plan approval. We're not, this isn't a
It goes on to
rezoning.
say, yeah,
It's a site plan. You have in your ordinance a PUD, a rezoning, and then your ordinance says, all right, come back after the PUD and give us a site plan. That's where we're at, the site plan, the second step. And then the third step is take that site plan and do all the engineering drawings, which is a plat. So there is no modification to a PUD here. It's never been asked. I think even Adam said that. So the other issue, I mean, we can go back after, okay, that's fine. I understand. And that is the importance of being accurate with you all and to the public. So the other issue that you all really wanted to hear about, you heard a lot of, and we have our notes, and flooding, and stormwater was a lot, is the stormwater issue and how our project handles it according to state and federal guidelines, but also how it addresses the adjacent neighborhoods. I will tell you that we have met with the city of Flagler Beach. We've met with Mr. Bryan, Commissioner Bryan, who lives on Palm Avenue, Palm Drive, and experienced some issues during an event. I believe you met with him for about an hour and a half. So we're here to give you a brief presentation into the public about how stormwater on this project works, and how it complies with not only county land development code, the St. John's Water Management District codes, and the federal government laws. Yes, sir.
Before we go any farther, as this development is being built,
Yes, sir.
at some point, as with the Palm Avenue, which failed miserably, you're going to turn over to the homeowners association maintenance of this whole area, flood waters, whatever, correct?
Correct.
Right. What assurances do we have that when you do that, we won't have another Palm Avenue, what I'll call a disaster, where they turned over to a homeowners association who went, well, we don't know what to do, and subsequently that system that you built has failed. It's failed.
Correct.
And they're flooding back there because it's failed. So what assurances do we have that when you turn this one over to a homeowners association, that there isn't some, I'll use say follow-up, but that we make sure that doesn't happen again?
That the HOA
That
doesn't turn their back.
HOA understands what their requirements are, because that didn't happen in the other one.
I can't tell you what happened with Palm Drive. I knew it was formed. They sold the lots, and then the next owners didn't do anything. And they didn't even renew their HOA, right? This one obviously is much larger. We have a community development district on here. We can talk about ways to
But then the
backstop.
sad thing is that the system that you built, which had they maintained it, they'd be in a lot better shape today.
We agree.
But they didn't maintain it, so I just don't want to see that happen again.
Oh, well, I'll let him talk about the HOA, but just as a backstop, we can discuss with you. There is a community development district on this, which is a quasi-government also, so we can build some stopgaps into that, and some backstops, I'm sorry. Thank you.
Thank you.
Get some help with that exhibit so I can point to it. For the record, Parker Minchenberg, 1729 Ridgewood Avenue. I'm a professional engineer and landscape architect registered in the state of Florida. I have 18 employees, and we design subdivisions for a living. I've designed probably 150 subdivisions in Volusia, Flagler County over the last 38 years. Mr. Hanson, to your comment about Palm Drive, the flooding that occurred on Palm Drive isn't relating, in my opinion, to the failing of the maintenance of the retention ponds. Very simple system there. The portion of Palm Drive that I designed and was a developer on was only 19 lots. It's the very end of the cul-de-sac. Right. Most of the flooding occurs on what was built on Palm Drive to the north, because it's about a foot or so lower. But the stormwater system on Palm Drive consisted of 2 dry retention ponds with basically a 1-foot depression and a berm. And so the flooding that has occurred on both parts of Palm Drive were due to the interconnection of the intercoastal waterway and the wetland behind the homes on Palm Drive. When Palm Drive was extended, there were 2 72-inch culverts constructed that connects the wetland to the west of Palm Drive to the intercoastal to the east. So with the flooding that's occurred, not just on Palm Drive, but downtown Beach Street and Daytona with these high tides and what have you, it really wasn't because they didn't maintain the retention pond. It was because the elevation of the river got as high as the roadway. So I just wanted to point that out. It wasn't really an issue with maintenance.
Well, I understand that, and I agree with everything you just said. But if you go back there and look at the berms that were initially built, they have failed. There are gaps in them. You know, there's big holes in them.
I suspect
and
what
because
happened,
they have not been maintained.
Yes, sir.
That's my issue.
I'm with
I
you there.
understand
I
completely.
agree with you.
Okay.
I suspect what happened there was, in this particular subdivision, and we haven't done this in 25 years, every subdivision that I design now has a master stormwater system. They're dedicated to the property owners or the homeowners association. We have covenants and restrictions that include St. John's language that gives St. John's the right to come in if a system fails and perform emergency maintenance. We also give Flagler County, through easements on the plat, the right to come in if there is an emergency and have access to the stormwater systems. And what Mike said about the CDD, that's another level of maintenance that this project has. So with that, I'll talk a little bit about the drainage. Okay, thank you, sir. This is the stormwater model, and I'm just kind of flashing you the size of it. We have state-of-the-art computer modeling that's accepted by the Water Management District and Flagler County engineer. So every project we do, we come up with a set of calculations like this. And I'm going to read a little bit of the permitting history. There was a previous permit issued when Ginn was developing this property, and that was issued December 12, 2006, Hammock River Beach Club, permit number 80599-2. Then the system, this is what we did, was redesigned to meet the current criteria, including nutrient reduction. So back when Ginn did his design, we didn't have the St. John's criteria for nutrient loading. What that means in layman's terms is in addition to having a lake that treats the stormwater, we first have to run it through dry retention. So I'm going to get to that on the plan here in just a second. The site is currently undeveloped with a steep slope from John Anderson Drive to two existing wetland systems, which are then connected to the intercoastal waterway via ditches. There are no depressional areas associated with the property. Basically, we have John Anderson at about elevation 20. It drops to about elevation 4 to 5 next to the intercoastal. And in between that is a big wetland slough, and I'll show you that in a minute. The site is typically considered woods grass combination in fair condition, so that's kind of the pre-developed condition. The pre-development phase has 11 drainage basins, 1 point of discharge, the existing wetland system. So all the overflow that comes from the treated stormwater systems, we don't put directly into the intercoastal. We send it to the on-site wetland to hydrate the wetland, and then from there it goes to the intercoastal. And then the basis of the design, the retention volumes provided exceed the requirements of St. John's and the county. We actually went the extra mile on this because we're capturing the stormwater. Instead of going with the overflow into the intercoastal, we're capturing more of it, and initially we're going to use it for the irrigation. So it's a low source of water to use for irrigation. We're not doing any fluorid wells as were contemplated when Ginn did his project. The system will function properly when considering the tailwater constraints. Whenever you do a drainage design, you have to look at how high does the water get that you're going to. So we've analyzed the tailwater for the 100-year event. And basically on the FEMA maps, if you look at them, the intercoastal's at 5, the wetland next to the intercoastal is at 4, and the wetland inside the project is elevation 3. So these are the 100-year flood elevations based on the FEMA maps. And the drainage system we maintain and operated by a homeowners or property owners association. We kind of talked about that. Now with that, I'd like to rendering a little bit.
We need to. We got to see it.
No,
Stand up.
something on the bottom.
Yeah, I'm going to have to stand.
There you go.
Test, test. Okay, if you would, Mike. You can see first off at the top of this is John Anderson Highway. So one of the things that I don't think has been really expressed is with the Ginn PUD, there's a requirement for a 50-foot buffer along John Anderson. So you see kind of the green-yellow highlight at the top.
we have voluntarily set up a 100-foot buffer along John Anderson. So that does a couple things. The best drained soil on this site is adjacent to John Anderson. And as you get to the intercoastal, and I experienced this in Palm Drive when I actually put a dock in by hand myself, there's a lot of hard pan cap rock as you get down by the intercoastal. So that 100-foot buffer, which is twice what was required, not only provides an area where the rainwater, goes right into the ground, it also provides tree preservation for some of the nicer trees that are next to John Anderson. And it's going to keep that oak-hammock look as you drive down John Anderson. That really wasn't emphasized at the other hearings, but it's twice what was required. Then below that, there is 2 rows of lots. You can see in white there. And the brown areas are dry retention or recharge areas. So all the runoff between John Anderson and those brown dry retention ponds go into the dry retention areas.
Are those brown areas, is that normally just grass?
Yeah, they'll be sodded.
Sodded,
And
okay.
they can also be play areas for the people that live there. Their flat bottoms are about 2 feet, 3 feet deep. So from there, the overflow out of these goes into on-site lakes. And these are the lakes that are going to be utilized with pumping stations to fire up the reuse system that we put in until the city has reuse available to us. So on this side of the wetland, we have our 100-foot buffer, no development, a tier of lots, and you can see how large these dry retention ponds are. That provides groundwater recharge and treatment. So we have another tier of lots that actually drain back to these areas. They're graded to first go to the dry retention. That's what you have to do with nutrient loading to take out the phosphorus and nitrogen. So if we have a severe rainfall event, when these fill up, they then overflow into these lake systems. And if we're experiencing a hurricane and more water than we can handle, these then overflow into the wetland. And this wetland extends off-site here behind Palm Drive. So there's twin 72-inch pipes. There's a wetland slough right here, and then there's an existing ditch. Currently, this side drains to that wetland and then overflows to the intercoastal. So working further down the plan, we have a single roadway next to the intercoastal. When I designed Palm Drive, they have docks that go out. These will also have docks, potentially. Every other lot will have a dock that'll be shared. And what happens is, instead of the rear of these lots draining right to the intercoastal, they drain to this dry retention. It then goes into this lake, then pops off into that wetland. And what you see in green down here is in conservation.
For that row of houses and the lower, it looks like you're draining uphill.
Now what happens is there's a berm that's built along this side. It's about 2 to 3 foot of fill. And so hydraulically, it builds up, it pops off into there. It doesn't go to the intercoastal. So it doesn't go uphill.
The way the water gets to the intercoastal, show me how that.
Okay, what happens is this pops off into here. See these arrows? That pops off into there. There's a pipe that connects these together. Then this is an existing ditch outfall. Right now, when this builds up, that's how it goes. Then the water goes right through here, and it also connects with the wetland and goes out those twin 72-inch pipes at Palm Drive.
When we get an event like we had recently where the actual intercoastal, not only do we have flooding issues, but where the intercoastal actually comes up and goes over its banks, how do we deal with that in this situation?
Well, what happens is, in this subdivision, there's a berm here. The houses and the roadways are of sufficient height that the water elevation of the intercoastal isn't going to affect these roadways. So,
Have to build them up.
Well, okay, all right, I hear you. How high is that berm? We know that you said that
it'll be
you're at
about
an elevation of
it'll
20
be
feet.
it'll
up
be
by St.
2 to
John.
3 feet above existing grade.
Okay.
Just point out where the berm is along. the
Okay.
coast.
This is John Anderson. This is a 100-foot to remain natural buffer, dry retention, wet detention, existing wetlands and upland buffers to remain. And then when you get down here, the rear of these lots goes into dry retention that ultimately goes to that lake. The rear of these lots goes to dry retention that comes back into those lakes. And then what you see in green is in conservation easement. So the wetland and the upland buffer next to the intercoastal will remain natural.
Park. We're
Okay.
We're running up against clock. We can answer more questions for you at the conclusion of our presentation. Thank you. We talked about reuse. I know county and city staff, as well as elected officials, have talked about what is the status of reuse. The city is interested, I assume, in creating a reuse system to provide us with the utilities, or that utility, which we're putting $750,000 in pipe in anticipation. We will be the first user and probably the only user that will be able to do that. So when they're ready to do it, we're willing to take it. After this step, we will then have a utility agreement with the city of Flagler Beach. They've already provided a will serve letter, meaning they do have capacity for water and sewer, just not reuse at this time. So I know someone from the cities here that can talk about what their visions are for reuse. You know, we have 300 units that'll pay, I think, $7,000 in impact fees or water sewer connection fees. So, you know, that's $1.5 million that our project will give to the city in water sewer connection fees. So there is an opportunity for long-term planning. The last thing was the schools. We have been in contact, meeting with the schools. We're drafting an agreement. We have an agreement in principle. We just got back the final draft that directed my client to execute it, to be on the district's agenda for January, if I recall. So that issue has been resolved. Right now, presently, it has the developer paying not only his impact fees over the course of the project, but also roughly another $750,000 in additional fees to the school district to provide additional seats. You all know that the district is reevaluating their interlocal agreement, and that's a process that's ongoing that they have to deal with too. So those are the 4 issues that I recall you all had. We reviewed the meeting. If there is any others, we'll be happy to talk, but I believe that's the end of our presentation in chief. We'll let the other side do what they need to do and speak, and then we can get up and as a party, do the rebuttal. Okay?
Yeah, we have one more
Yes, sir.
question here.
Mr. Cimento, I had asked you before, does the developer or the owner of the land have any interest in selling at all?
No, sir.
None at all,
No,
at
sir.
any price?
No, sir.
Okay.
Okay. Any other questions for Mr. Cimento?
Okay, we'll sit. Thank you,
Thank
sir.
you. Next. Attorney Dr. Pepperland. Dr. Pepper. Hey, Joe. All right.
Drew Smith, City of Flagler Beach. I'm going to take those extra points for brevity. I'm going to be as brief as I can. I'm going to try to focus on things that we agree on, that I agree with your staff report on, things that I agree with Mr. Cimento on. First off, I'm going to start where he ended, the reuse. I want you all to understand what we're saying. I want the developer to understand what we're saying. We're not saying no reuse. We said, and just like I said in the letter, we stand by our commitments. What we're asking for is for the developer to stand by theirs. After the letter, after everybody's read it, the fact that we're here talking about the letter, I am baffled to hear again the developer say, we put in the pipe, we'll use it when it gets here. The agreement that's in place right now is developer will build it. We're willing to renegotiate that. Completely willing. They haven't yet come to us and said, okay, let's change these terms to something that works for modern times. It's important. And it's important because of the context that we're here in tonight. Things I agree with your staff report on. There's a line in there that the developers agreement from 2005 is admittedly developers focused or developer focused. I agree wholeheartedly with that comment. It is a very developer friendly developers agreement. To add insult to injury, the developer is now here before you to take further liberties, to say, let's take this really generous developers agreement and make it even more generous. At the end of the day, it's your decision. I'm impassioned about it because I'm impassioned for people like you. It's what I do for my career. I represent boards. I represent elected officials. I don't like to see elected officials taken advantage of, and I think you are being taken advantage of. You are being asked to give up authority that you have right now to say no. When you could say, you know what, this is too much. This is too much of a change. Every developer's agreement I've ever worked on has a modifications provision in it. As Mr. Mingle said earlier, it looks like you have the whole Flagler County Planning Association here. There's a reason. There's a reason the planners are here. This is not normal. This does not happen every day. You don't see this kind of revision to a plan development happen like this. A lot of blood, sweat, and tears goes into a plan development. A lot of blood, sweat, and tears goes into a developer's agreement. I spent 4.5 hours at a TRC meeting 2 weeks ago. 2 months before that, we had another 4 or 5 hour TRC meeting, Technical Review Committee meeting, hammering out these things. Commissioner, to your point, one of the things we were hammering out was language for the developers agreement that made sure once it was turned over, that homeowners association it was turned over to maintained the private infrastructure. That was language that was going into that developers agreement to make sure that it happened, to make sure that 15 years later, a developer doesn't come back and say, oh no, this is what we all meant. This is what we meant back then. You got to let us do it. This is what we meant. But it's not what you meant. You've heard tonight about how all of your staff has reviewed this and all of your staff says it's okay. There's one part of your staff that has said, no, I have issues. At least one. Technical Review Committee counsel. That this should be an amendment to the developers agreement. Just like I said in the letter, I can't make the case better than your own legal department has. When the original developers agreement was approved in 2005, sorry, can I see my time? Is it possible to get that up on the screen?
It's on here.
I want to make sure I save plenty of time for Mr. Torino. When the original developers agreement was approved in 2005, it went to the planning board. And this is on the topic of that off-grade or at-grade crossing. Planning board, as part of its finding that supported the approval of the PUD, was because of that off-grade. I have the language right here. The southerly extension of Colbert Lane will provide a controlled signalized intersection and a grade-separated crossing is proposed for John Anderson Highway. That was part of the motion that approved the PUD, approved the developers agreement, approved what happened in 2005. It came to the commission. Again, recognized the motion of the Planning and Zoning Board and included in their own motion, in addition to incorporating Planning and Zoning's findings, the southerly extension of Colbert Lane will provide a controlled, signalized intersection on State Road 100. The grade-separated road crossing on John Anderson Highway results in a marginal number of trips on that segment. Again, the off-grade crossing, essential. It's a fundamental part of this plan. There may be language in the developers agreement that looks like maybe it gives them leeway. It does not, because the motion that was made to approve that agreement made a specific point of that off-grade crossing. It's a house of cards. You pull out the card on the bottom, the whole thing topples down. That finding was the card on the bottom. Without it, none of these conversations even matter. Because if the factual basis for a decision goes away, the factual decision, the decision has to be revisited. That's another thing that judges get. That's another dangling hook in the water if you move forward the way that the developer has asked you to move forward tonight. As to the other items in my letter, stormwater. We raised the question, you raised the question, you heard tonight what happened. Developer got on the ball. Developer went out into that neighborhood, developer went to the city, said, hey, let us help you understand. It's amazing what the power to say no gives you. It can get you a lot of action by retaining that power to say no. That's what the city is asking you to do tonight. Hold on to the power that you lawfully have and use it to the advantage of the county, its residents, and all of the jurisdictions in the county. Not to make the developer's life hard, to make the county's life better. Because developers can do great things. And Mr. Chimento said it tonight. Things I agree with. The community input that's been given when you've been having these conversations have made this a better project. Imagine if you did what you could do and took it back and said, yep, you know what, you're right. Let's go back and renegotiate a developer's agreement. Imagine how much really good community input you'd get, and imagine how much better this would be for the county if you did. You have the right. All we're asking is that you take it. Future development, staff recognizes in their staff report that you're not going to approve any additional density without a rezoning. We're all in agreement there. I think the condition that the city recommended is perfectly apt because it tells the developer right now, we're going to hold you to this. Stormwater, seems like there was a little bit more offense taken at the wording of my condition. Word it how you want. Word it how your staff wants. Put a condition in there if you approve tonight. If you decide to give up some of that authority, but keep a little bit back at least. Put language in there that says, we want you to come back and actually hammer something out with us because you heard an assurance. I think the words were, we can build in some backstops, but if you say yes tonight, everything you hear from the developer, what they will do is a promise. It's not an obligation. Because once you say yes tonight, they're going to build what they want to build. And they absolutely, I am sure, will listen to your input. But a developer who has a possible no hanging over his head always works harder than one that can give it to you if they want to. Keep that power. It's a weird position for me tonight because like I started off, I'm usually sitting over in that chair advising boards. And I do feel passionate about what I do, and I do mean everything I'm saying from my heart. I think you have the legal authority to have more input into this. The city of Flagler Beach is here asking you to exercise that authority because the city of Flagler Beach trusts your judgment, wants to see you involved. Doesn't want you to just make a decision tonight and never see this project again because everything else happens at a staff level, never gets here. Keep control over this. I started off with a story and when we were talking about standing, and now I'm going to finish it. Why I say that case impacted the rest of my career is it taught me one thing. Time at the end of the day is cheap. Developers always say, we have to go down, we have to go now, we have to get an approval now. If you get a challenge to that approval, you better be ready to wait 2 or 3 years. And they know that too. So I've never quite gotten it through my head why they're always rushing so much. Because sometimes, if you take a week, you say, you know what, let's take 2 weeks, let's not have the meeting the week after Hurricane Charlie. The abandoned grocery store that had been there for 20 years prior to the development approval wouldn't have been there the next 10 when that developer walked away because the market had tanked. Sometimes a little bit of extra time, and in this case, I know I'm asking for extra time in the sense of Well, taking it back to a developer's agreement means lots of more hours, hammering things out, but you heard from the developer's own attorney the value of public input. You heard him say the public input we've received in this process has made this a better project. Imagine what you could do if you went back to the developer's agreement and started fresh. So last question I'm going to say, and then I'm going to ask Mr. Torino to come up. I will introduce him. I provided the recording secretary a copy of his resume. She has copies if you'd like to see them. I think you all know Mr. Torino, but the resume is there and in the record if you'd like to see it. Been practicing planning since 1967. Within the county since 2003. I don't think you'll find a more respected planner in this side of the state. So the one question I'm going to leave you with, because I'm going to try my best not to have to come up here again tonight, as you listen to Mr. Torino, is ask yourself this question. Is the project that we're being asked to approve tonight the project that the county bargained for in 2005? If it's not, you have the full authority to say no. You're not killing a project. You're just saying, hey, you know what? We want you to develop what you want to develop. We just want to make sure it fits our community, so let us have that input. Thank you, everybody. Thank you very much.
Mr. Chairman, Commissioners, I thank you for this opportunity to be here this evening, to provide some comments, give some input about this application. Commissioner Erickson, to you farewell. I wish you well in the next chapter of your life, especially with your four-legged friends. I understand that very well. I'm going to take a little bit different approach to this project tonight, different than what I would normally do. And rather than talking about the development itself, I'm going to talk more about procedure. That's the first phase of what I'd like to speak about, is the procedure and the process where we find ourselves out this evening. The second part of what I want to talk about is what I consider a modification to the PUD site development plan. It states here in your application, it states here on the agenda, that the item before you this evening is to consider a site plan modification to Exhibit 2, the conceptual site development plan for the Hammock Beach River Club. So that being said, bear with me. I don't feel I can quite articulate like I envy our city attorney, but I will do my best to convey my thoughts to you, and if you have any questions, please feel free to ask me. We're going to go through some slides. Again, the application before you tonight is a request to modify a PUD site development plan in the Plan Unit Development District for the Hammock River Beach Club PUD. I'm presenting my findings first, and then I will respond to those findings by building my case to support what my findings are at this time. I have two findings that I want to speak to this evening. One is that I find application 3209 is not in compliance with the submittal requirements of the Land Development Code, Article 3 zoning, specifically Section 3.04.03. My second finding is that the modification exceeds the bona fide purpose and intent of the HBRC DA Section 4.7, modifications to the conceptual site plan. The resources I used to do the analysis that I did were threefold. One, obviously, was Exhibit 2 of Ordinance 2005-22, the Site Development Plan, the Gardens Master Development Plan, and the Flagler County Land Development Code application submittal requirements for PUD Site Development Plan review. I want to bring this out up front here is that I did have a conversation with Mr. Cimento. Actually, he called me a week or so ago and wanted to make certain that I was aware that the only issue they were speaking to was the conceptual site development plan. No other maps, since there's been a lot of different maps put out there. But what I had to do in my analysis to make it a level playing field is that the conceptual site plan that was adopted into the ordinance for the Hammock Beach River Club was just that, a conceptual site plan. the Gardens has not submitted a conceptual site plan. They moved forward with a modification to the existing site development plan that the GIN project had also adopted and had approved and subsequently led to the preliminary plat that was spoken to earlier this evening by Mr. Mengel. So understand the process. Conceptual plan, step one. Site development plan, step two. So we're going from 5,000 feet to 2,000 feet to preliminary plat, which is boots on the ground. And as you go through each one of those levels, the plan becomes more and more refined. That being said, I want to first read the definition, just excerpts from it, and not playing on your integrity whatsoever, but primarily for the public that may not really understand what a plan unit development is. That term was founded many years ago. It has been diluted, unfortunately, to the level that it really doesn't make a whole lot of sense anymore, other than with the exception of changing development standards. It's basically a conventional subdivision, unless people get really creative and innovative, but that's a discussion for another day. But what a PUD is, it shall mean, and very important, it's a planned development under unified control, which is planned and developed as a whole. Very important, in a single or programmed series of operations with uses and structures substantially related to the character of the entire development. What that says, in essence, is that the outcome is a known outcome. The final plan, the final approvals, the final whatever is a known quantity and a known quality. The second part of that definition reads that it must be in harmony with the purposes of Article 3, zoning district regulations, and the Flagler County Comprehensive Plan. The design of a PUD shall follow a carefully devised plan of development, which must be prepared in accordance with the requirements, procedures, and approvals herein prescribed. This section is alluding primarily tonight, for my purposes, Article 3, which is zoning and the site plan review process. This first slide that we're looking at here is the submittal requirements. From that section 3.04.03, site development review of a PUD that I spoke to earlier. And what it says is that the site development plan shall contain, not may contain, not could contain, but shall contain the following: a master plan, which has been presented and has been reviewed, but that master plan must show proposed land uses, their location and acreage. Very important. All proposed land uses, their location and acreage, and secondly, a table that mimics those land uses and the acreages that have been assigned to each one of those. I'm going to jump forward now to the master plan. I apologize for the resolution somewhat, but you're going to see here three different colors. Those three different colors represent three different designations. One reads undeveloped, one reads golf, one reads future development. The balance of the plan, you can see how more refined it is, that the lots are shown, the distribution of uses are shown. It's much more refined. Those three designations that I just alluded to shows nothing but some illustrations of golf holes. I ask myself, what does undeveloped mean? Does undeveloped mean that's going to remain undeveloped? It shows some delineation of golf, and then it has a designation of future development. Well, future development, to me, shows more intent than undeveloped. So that, to me, is confusing. That does not comply with your land development regulations, as it states in section 3.0403, all land uses are to be shown, and the acreage associated with each of those land uses must be shown as well in a table. Golf is a land use. Undeveloped is not a land use, nor is future development a land use. This slide here is the land use table from the master plan that was submitted for the Gardens project. As I alluded to in the previous slide, two non-land use classifications are shown. One is future development, one is undeveloped. There is one land use classification shown, it's designated as golf. To the right of that is a table. It summarizes 3 different sectors of the plan in this manner. The first table is a summary of the east side development, which we are speaking here and speaking to this evening. The second set of a table alludes to the west side development, and then you have the bottom, which is the total site development. So Table A, east side, Table B, west side, should wind up in the total site development plan as a cumulative number. Moving forward to the specific land use categories that are shown on that table, we look at, if I can ask you to look at the yellow bracket, if you will, we'll take the single-family lot area. For the east side is shown at 68 acres. On the west side, 29 acres. To the right of the bracket, you'll see that total acreage is 97.99 acres. In the total site development table, which is at the bottom of the screen, it speaks to single-family lot area as 211.7 acres. The numbers don't add up. You look at the undeveloped category that is highlighted in the light red color. On the east side development table, it reads 57.47 acres. Nowhere else does that show up in the other 2 tables. None on the west side, none in the total site development table. What happened to that 57.47 acres? We look at open space conservation area. For the east side, it reads 122 acres. For the west side, it reads 399 acres. That totals 521.09 acres. The total open space conservation area reads 373 acres. The point I'm trying to make here is that when you submit an application and your objective and your requirement is to provide, number one, transparency in what you're proposing to do. Number two, to be accurate in providing the information you're required to submit. I dare say, and I'm looking at this from a factual standpoint, and let me clarify, I'm not opposed to this development. I'm opposed to the process. And saying that, if I saw something like this, doing my cursory review when I was looking for completeness of the application, I would return this application to the applicant and ask for clarification, if nothing else. If I saw on a master site plan undeveloped future development, I would return it to the applicant and say, no, you're not in compliance. You are supposed to designate all land uses. Again, a known outcome. Every square foot of 824 acres should be accounted for, whether it be in roads,
Mr. Trino?
drainage, stormwater.
Mr. Trino, so, question. So are you saying that our planning department is incompetent, doesn't understand math, or doesn't understand the process?
I'm not saying that at all, Commissioner O'Brien. What I am saying is I don't understand why this type of data was not brought to the attention of the applicant. And I will say this now as opposed to saying it later. I want to allude to some of the comments that Mr. Sciamento made.
Just bring up the time just so you're aware of how much time you have.
7?
7.
I'm here for exactly what Mr. Sciamento said. Why are we here? I question why we're here. To me, this should not be at this level of review, number one. We're here for site plan approval. This is more than site plan review. It's a modification, and I'll get to that in a couple of minutes. He references that they followed the rules and regulations. No, they didn't. This is a classic example of it. Not only in these land use tables, but in the master site development plan. He mentions that devil is in the details. Absolutely is. The devil is in the details. He mentions that they're in compliance with the land development code. No, you're not. You didn't submit required information that is mandated. And I'll leave it at that. Six minutes. I'm sorry, Jared, I shut myself down. Maybe that's a cue. So based on what I've just presented to you and what I've just stated, my findings from my point of view is that based upon the lack of required land use data and conflicting land use table data, I find this application not in compliance with the submittal requirements of Land Development Code, Article 3, Zoning, Section 3.0403. I'm happy to answer any questions to that, but I'd rather move on to the second part of what my findings are and go over those issues with you. My second finding, again, is I feel that this master plan that was submitted for review exceeds the bona fide purpose and intent of the Hammock Beach River Club Development Agreement, and we'll move along with that. Section 4.7 of the PUD agreement, which Mr. Sciamento again communicated to me, along with the conceptual plan, is all that they are focusing on. I'm not going to read it to you, but essentially that section of the development agreement breaks down to two different elements. It talks about the location of roadways and other improvements, that they may be changed as deemed appropriate, or as to the site plan, modifications to the conceptual site plan are permitted as long as they maintain the same general land uses, no increase in intensity or density. What we're looking at here is the conceptual site plan that was adopted as Exhibit 2. The highlighted area is the east side of this development. This is an enlargement of that area. At the conceptual level, we're looking at the 5,000-foot level. It speaks to two different entities, the primary roadway system and the land uses associated with this phase of the development. Each one of those blue bubbles, if you will, speak to single-family attached, single-family detached, or golf course. The southerly portion of the development, the westerly section is shown as golf course, single-family attached or detached. The northerly sector, up to the center of the development, the same notations. There is an area heavily outlined in hash line black that reads to the River Club, multifamily, and golf course. Also on this conceptual plan, you'll notice in the lower left-hand corner, public land area A. I believe that's approximately 10 to 12 acres. That was the site that was supposed to house the utilities plant if GIN would move forward and construct that. And that's a very interesting item, and we'll get to that in a minute itself. What you also see in the lower left-hand corner is some type of a structure. Obviously, it's not an at-grade intersection, but you see some type of a structure that's represented there. And over to the right-hand side of the lower portion of the development, under the land uses note, you'll see an emergency access or secondary access for the project. What we have here on this next slide, the top half, again, is the conceptual plan. The bottom half is the site development plan. It's step 2. Step 1, conceptual. Step 2, more refined. Highlighted in yellow are the residential areas. The green circles with the black lines delineates the golf course. Obviously, you can tell from the configuration of the conceptual plan and the configuration of the site development plan that they tested whether or not a regulation golf course can be constructed within that area based upon the roadway delineation. And another item I'd like to point out, if you look at the conceptual development plan on the top, Mr. Sciamento mentioned about modifications. Typically, when you speak about modifications to a PUD, they're internal oriented, and they're speaking to roadways. Not talking about intersections. Those are critical. Those are critical and fixed based on studies by people like Mr. Lassiter. Internally, roadways can change. And the bottom picture speaks to that. 1 minute left. Okay. What I wanted to show you is that, what to tell you that I scaled this golf course out. I measured the distances. The green circles delineate landing area, green area, or tee boxes. I might speak with a little bit of authority on golf courses. I must have done golf course routing for at least a dozen golf courses in South Florida during the late 60s and early 70s for developers. This golf course works. We look at the master plan again for the gardens. The golf course piqued my interest. I'll jump right to the next slide. I measured the distance. I understand these are only illustrations, but I measured the distance for the golf holes as they're represented there. There's 3 par 4s, 2 par 3s. I do the measurements, I do the distancing. None of the par 4s are close to being par 4s. You'll see a par 4 at 300 yards, a par 4 at 280 yards, a par 4 at 217 yards. The par 3s measure what they should. They could definitely be 217 yards, generally from the back tee box. But more importantly, if you look up at the top, you'll see some hyphened white lines, which is shown as the first hole. It's denoted as the first golf hole, with the clubhouse being to the right of that. That hole is the starting hole, measures 280 yards. There's no way that that could happen. More importantly, the corridor for that golf hole is tremendously under-designed. The typical landing area for a golf course is anywhere from 250 to 350 feet. You can see by this diagram here that these are 250-foot circles, radius. Half of the landing area is in the roadway.
I think Commissioner Hanson would like those distances for par 4s.
In closing, what I'm saying to you, and let me drop back, excuse me if you give me 30 more seconds, you'll see 4 round circles on the plan, on this enlarged golf area.
Need to get to the conclusion.
Those are curb cuts. The preliminary plat shows those as curb cuts. You do not do curb cuts on a master site plan or preliminary plat unless you have done some work to see what can be done within that area. My contention is, in looking at the scaling of what was done here, there's no way a golf course can work in here. I don't care whether it's 3 holes or 2 holes. 2 regulation 4 par 4s cannot be built. So I challenge the developer and the applicant to provide to the county, to you, what is proposed here. They're showing 5 curb cuts.
Time has expired.
I thank you for your time.
Mr. Chairman, do we have a few moments for a break?
What does everybody think? Yes, I think it's a good time for a break. We had one about 2 hours ago or so.
It's appreciated by
All right,
your
5 minutes.
Thank you, Your Honor.
Donnie, I added 50 yards today. By drive.
I think it's Mr. Tanner's turn, and to start the 30-minute clock, once you get started. John, go ahead.
Thank you, Mr. Chairman. I'm John Tanner, attorney at law. I represent Preserve Flagler Beach and Beulah Creek, a nonprofit citizens group that organized and existing under the laws of the state of Florida. I also represent 6 named residents who live along John Anderson Highway and who all received notice from the county. I provided that list to Mr. Hadid, and also I'll file the list of names, the 6 people, with the records keeper when we finish. I would first say you're not going to have to hear much from me because I think you've heard about enough from lawyers, and I'll try to just stick to the meat of our case as best I can. I'd like to call Mr. David Tillis. He's a land planning and entitlements professional, and I would ask him first to tell you a little bit about his qualifications and then go directly into his analysis.
Mr. Chairman, Commissioners, my name is David Tillis. I'm a sole practitioner, land use planning and entitlements consultant. My career has been exclusively in Florida for over 40 years. In fact, early in my career, from 1979 to 1986, I was a senior community planner for ITT Community Development Corporation and was the senior planner on the Hammock Dunes DRI for the company. I have testified numerous times in administrative hearings and judicial hearings, and in fact have testified about 10 years ago as an expert witness for Flagler County on a matter concerning the Hammock Dunes DRI development order. I spent 20 years with the St. Joe Company in Jacksonville, which was the largest private property owner and developer in the state of Florida. Then I spent 3 years with Bonita Bay Group, a community development company out of Southwest Florida that was expanding into North Florida. And then I had the worst job of my life. I worked for a consulting firm for a few years. And then I finally decided to retire from that and do a few selective consulting projects. I was retained by the Preserve Flagler Beach and Beulah, Inc. to take a look at this site plan modification proposal and give them advice. My comments are going to focus on 4 areas. One, I believe the current proposal is procedurally flawed. While arguably not beyond the 15-year expiration timeframe on the original PUD, the project is out of compliance with sections 13.2 and 13.3 of PUD Ordinance 2005-22. It requires development actions to commence within 1 year of enactment of the PUD and be ongoing. It further defines ongoing. A project is considered ongoing as long as substantial and good faith progress has been shown by the developer or its successors and assigns, conducting construction activities in a regular, continuing, and orderly manner designed to meet the approved development scheduled dates. The site remains undeveloped, and there's no public record or sign of ongoing construction activities. You know, PUD 2005-22 vested the developer with development rights, but also requires timely execution of its obligations under the same PUD. There is no feasible way for a project of this size to achieve the scheduled 15-year build-out, plus the extension that the applicant has applied for under state statutes. That's the build-out that's required under Section 13.3. Further time extensions would be necessary. And I've done this for 40 years, and I know how long it takes to design and construct a project of this size. Section 3.04.02 H.4 of the County Land Development Code states, no time extension will be granted by the County Commission if the project is considered not to be an ongoing PUD. Under subsection 3.04.02 H.5, once the county determines the project not to be ongoing, it can revoke the PUD approval. This applicant has failed to perform as required by the original PUD. It's well within the County Commission's authority to declare the original PUD revoked and require the process to start over. I have a full report that I gave to
Mr. Tanner, he will subsequently give you that. I'm just trying to highlight the important parts of it. The site plan does not meet PUD site requirements. Mr. Torino alluded to that and actually did more than allude to it. The PUD process requires a site plan depicting the full build-out consistent with the number, type, density, and intensity of uses within the approved project boundaries. The revised plan does not meet the requirements and should be denied. If you look at the earlier site plan for the Hammock Beach River Club that's found in the public on the county's FTP site, it clearly labels all the parcels by acreage, land use, location, shows location of roadways, including the John Anderson Highway overpass, and utilities. For example, open space is a specific use, but the original one even refined open space by golf, wetlands, and lakes by acreage. For example, golf in the original was 231 acres. The revised plan shows a golf course, but assigns it no acreage. It also shows 5 parcels as future development. And the map that I found in the public record, the parcels were 2A-A, 1C-2, 1C-5, B, B, and Y. These are all designated as future development with no other land use or acreage assigned. Again, the earlier site plan showed a grade-separated crossing of John Anderson Highway in both text and graphic description. Approval, from what I can tell, was no doubt based in part on that representation, and a construction, operation, and maintenance agreement between the original developer and the county was subsequently executed. The current proposal shows an at-grade connection to John Anderson with turn lanes. I would say that's a major change. Section 4.7 of PUD 2005-22 allows the locations of roadways and other improvements depicted on the conceptual site plan to be changed at the discretion of the developer. That section speaks only to changing location of roadways and other improvements, not design and performance criteria agreed upon in the original approval and a subsequent agreement. The revised plan refers to multifamily residential, but no multifamily, I couldn't find any multifamily parcels on the site plan. My question is, are they included in approved residential unit count, or is this going to be in addition to the units that have been approved? Inclusion of future development parcels with no assigned use or acreage begs the question of what else is planned beyond what is depicted and previously approved. To go beyond the previously approved amount of development would require a land use plan amendment and a new PUD. Simply, this proposed site plan revision lacks the clarity and certainty of the original and falls short of the PUD site plan requirements. Another item, just simply, this project fails to meet the purpose and intent of a PUD. Land Development Code identifies the purpose and intents of a PUD to provide an opportunity for innovative urban design techniques, improved use of land, protection of natural resources, and a unified development of large tracts using more creative and flexible concepts in site planning than otherwise possible using conventional land use districts. There is nothing creative or innovative about this site plan. It merely mixes a few different land uses on a site, design of which mimics conventional land use regulation categories seen in literally hundreds of subdivisions up and down the US 1 and I-95 corridor built on pine flatwoods. Lots are arranged on this in a linear pattern along streets for efficient delivery of utilities, drainage, and roads at the lowest price per linear foot and price per lot. There's no clustering, there's no destinations, there's no gathering spots. I don't see opportunities for bicycle or pedestrian or nature trails. There's no long views with a payoff at the end of the view. And if you buy one of the lots across the road from the Intracoastal, you might as well be over on US 1 because there's no connection of the rest of the community. You have no sense that this is a waterfront community. This is a cookie-cutter anyplace Florida. Lastly, particularly the east side of this site is a unique and vanishing resource in Florida. You take 300 acres with this amount of frontage on the Intracoastal Waterway and the depth from the road and the mixture of the natural resources that are there, you can't find another one of these, at least in East Florida. So this site deserves a better site plan. Flagler County deserves a better site plan for this site. The last issue that I came up with from a planning perspective deals with the use of already owned county land to meet a current development proposal. Now, bear with me. The original developer, having purchased 2,000 acres, made a business decision to take 1,200 or 1,100 acres and make a deal and go forward. And they came up with a site plan and went through all the processes. Now the current applicant has 824 acres and seeks the same use of what is now county-owned land. Well, that to me begs the question, well, then shouldn't the county be a co-applicant on this, because county's land is being used for density mitigation, for example. I think this is a major public land use and ownership issue that is dangerous and potentially precedent-setting. I saw one other piece in there that was of interest. It talked about a dedication of a public land site D, and it says it allows a portion or all of that area to be used as mitigation to offset impacts to water management and Corps of Engineers wetland impacts. I can tell you in my experience, having been Vice President of Regulatory Affairs for the St. Joe Company, that when you enter into a conservation easement with those guys, it highly restricts the use of your land. You can do little more than walk across it and enjoy it. It may even restrict your ability as a county to develop it even as a passive park with parking and associated improvements, even from a low impact standpoint. Then my question is, who negotiates those conditions with the Water Management District and the Corps? The developer or the county? So I think these are important issues that, from a planning perspective, need to be evaluated. My report goes into more detail, and I don't want to bore you with the detail, but basically my findings and conclusions come down to 10 items. PUD 2005-22 has a 15-year duration, which would place completion sometime in May 2021. I may be wrong, but I did the math for. I'm trying to go slower. Thank you, sir.
Mr. Chairman, may I have a copy? I filed it with the record clerk, and I have it.
The applicant has exercised an extension under Chapter 252.363 of Florida statutes. That pushes the completion out approximately 8 months to January of 2022. So again, I don't think you could complete this project even by that time without further extensions being requested. The project has failed to meet the ongoing construction requirements of Section 13.2 and 13.3 of PUD 2005-22. Section 3.04.02H.4 of the County Land Development Code prohibits time extensions on projects considered not to be ongoing PUDs. Under the next section, H.5 of the code, the county can revoke a PUD that fails to meet the ongoing requirements under Section H.4. Project fails to meet the purpose and intent of a PUD to provide for innovative design techniques, improved use of land, protection of valuable natural resources, and development of large tracts using more creative and flexible concepts in site planning than otherwise possible using conventional land use districts. Again, the 300-acre Intracoastal site is a very unique site with diverse coastal hammock, mixed wetland hardwoods, and wetland scrub habitat acreages for which I lifted right out of the application. This site
is scarce and a vanishing resource and that warrants an innovative and creative master plan. The site does not meet the PUD site plan requirements. It lacks the clarity and specificity of land uses by type, density, intensity, and location required in a PUD. The site plan eliminates a grade separation of project traffic from John Anderson on which earlier approvals were based. Site plan includes 5 parcels for future development with no assigned acreage or land use and shows no location or unit count for multifamily units referenced in the application. Finally, use of county-owned land to meet regulatory density requirements and to provide mitigation for state and federal wetland impacts is a dangerous precedent-setting public land use policy. I believe that we've presented competent and substantial evidence to warrant denial of this site plan modification. And I'll be glad to answer any questions that you have.
Chairman, I would like to ask Mr. Walter Fafidio to come up, and I will, again, get the lawyer out of the way and let him give you his analysis. And may I filed a copy of his report following.
Good evening, Commissioners. My name's Walter Fafidio. I live at 3 Whitehall Court, unincorporated Flagler County. And I was contacted by Preserve Flagler Beach and Bulow Creek because at the time of the adoption of the 2005 development order and conceptual site plan, I was the Flagler County Planning and Zoning Director. And the purpose of the 2005 PUD was to develop the property as specifically set forth in the development agreement and depicted on the conceptual site development plan attached as Exhibit 2 to Ordinance 2005-22. And now I'm going to come back to that point because we've been parsing where it says shall and where it says may, but I want to talk about that conceptual development plan. Our concerns in 2005, the administration was securing water and wastewater services in what was to be, prior to the water wars, as Adam puts it, the county's utility service area. We wanted to protect environmentally sensitive lands and prevent annexation by the city of Palm Coast, which was grabbing land left and right at that time. Hence, the dedication, the county is now the majority property owner, 1,200 acres, in this development. In fact, I was deposed because during one of the public hearings, I happened to term it as a voluntary contribution. Well, yeah, it was voluntary, but it wasn't, this PUD wasn't going anywhere without that dedication. And that's why it's such a big acreage. We also wanted to preserve the ambiance of John Anderson Highway. It is, as has been stated, a very unique area. And I recall that the word may in the development agreement with respect to transportation meant it may be either an aerial or a subterranean crossing of John Anderson Highway. Not that it may be anything you want it to be. And in fact, after my departure here, I went up to Nassau County as a growth management director. It turned out to be an underground crossing. Another idea that we had in mind, this was at Ginn's heyday, if you will, and this was going to be an economic development spark plug for Flagler County because it wasn't just homes. It was another resort community that was going to provide jobs and bring in outside capital in the form of tourist dollars and the multiplier effect that they have. And an axiom at that time, at any rate, was that all city and county managers had was that single-family development does not pay for itself when you look at the cost of services. So it was a business deal as well. And regarding the I think that was a really important point, that the transfer of development rights from what is now county land was part of the original deal. And I think it is correct that in order for that transfer to happen, you need to really be part of this application. Remember, when a governmental body owns land, it doesn't actually own it, it holds it in trust for the public. So you are using the public's land to give them whatever it is, 1,200 divided by 5 acres, not acres, units, excuse me. So I do think you really need to be a part of this. And I gave you a copy of the minutes of the Board of County Commissioners of July 12th, 2004. And the case in that, it was another amended site development plan in a planned unit development. It was called Los Lagos, and it was up at Matanzas Shores on A1A. And the salient issues at that time were transfer of density, sound familiar, and how binding was that conceptual development plan? Don't we have the right, because it to make any changes we wanted? And I mean, no case is identical, but it's definitely analogous to what's going on here. And that was a DRI, but as was fairly common in the 1980s, the development order of the DRI also served as the development agreement in the planned unit development. You won't see that happening anymore, but that was common at the time. And the same applicants, they argued, let me take that back. It was argued by the applicant for Los Lagos that we don't have to abide by the conceptual plan. We can do whatever we want. And the Board of County Commissioners at that time, through a tabling, effectively rejected that argument. And that set in motion a series of meetings with the community and with some of the organizations that were active in the hammock, and with staff. It empowered staff to work with the developer to come up with what they really wanted and what the community's interests were served. And ultimately, it got approved. In fact, it was approved in August of that year. So I think what the Flagler Beach attorney said is quite right, that if you recommend denial, you will empower Messrs. Cameron, Hadid, and Adam, and Mr. Mengel to go back and negotiate an amended development agreement or a new PUD site plan that will serve the interests not only of the property owner, but of the county as a whole, and in particular, the residents who live along John Anderson and will be affected by this. There isn't much land left in unincorporated Nassau County. You've got the hammock and you've got this. And I ask you to use a little bit of caution and be businessmen and come back with the best deal you can for the county and for yourselves. Thank you.
Barbara Revel. Again, I have provided
Good evening, gentlemen. I know it's late. I'll try to be brief. I know we're running shy on time here. Barbara Revels, live in Flagler Beach, lifelong resident of Flagler County. I've been a realtor for over 40 years, owned my own company for most of that time, as well as a general contractor, and am active in the real estate community. My testimony here tonight is to describe for you what will happen to the property values of the homes that are nearby the Gardens development, the subdivisions both north and south, and the immediate property owners along John Anderson. I recently had a listing of a property in the Halifax Plantation subdivision. It was actually a year or two ago, just down the road, down Old Kings Road. And what I discovered is, as a new portion of Halifax Plantation opened up by a builder of new homes on smaller lots, no mature landscaping, but they were new, and they were listed $50,000 below the existing homes that were there, which were established, older homes, quality built, larger lots, mature landscaping, oak trees everywhere. And it immediately dropped the surrounding older subdivisions' home values by a large amount because you could buy new for that much less. It's happening in Palm Coast right now, where some of the smaller, older homes were gaining value and getting up to the $200,000, $225,000 price range. And now we have new construction all over Palm Coast, and I'm not complaining about it. It's a great opportunity for new home buyers, but you can buy a brand-new home on a small lot in Palm Coast for $180,000. So the older homes that were gaining value, maybe a little above $2, they've all been affected by it. The prices have gone down. That is the exact same thing that's going to happen to these houses that are going to be surrounded by this development, in that their property values are going to go down, and one of the main reasons is the traffic. What is going to happen to John Anderson Highway? Will some of their property be taken for any type of road right-of-way improvements? But mostly the fact that there will be a tract development offered at a price, new, and people are not going to look at these existing older homes. So I'm here to speak for and give testimony that you need to consider what this development will do if you do not keep the traffic off of John Anderson Highway. That would be the one thing that would assist these property owners in keeping their value, is if they didn't have to deal with the traffic, and that's always been the purpose and intent, and I'd ask you to consider that. Thank you.
We're at the point where you're going to get public comment in a few minutes, so I'm going to try to not talk about things probably the public's going to be talking about. I know Mr. Schmento is going to get rebuttal here. But does anyone really think this is the same project that Mr. Ginn got approved? Battled really hard to get approved? Does this really look the same in any respect except the geography of the property? That's about the only resemblance. This is really different from what the Planning Department and the County Commission in 2005 agreed to. And the amazing thing about traffic, all due respect to Mr. Laster, he's a neighbor. In 2005, that County Commission was so very concerned about the John Anderson Highway, the scenic highway corridor, that they insisted that there be above or below grade crossing. Good reason. Now here we are 15 years later, and we know how the traffic has increased. You know what's happened in Flagler County in the last 15 years. There are hundreds of more homes on John Anderson. Of course, there are thousands of more homes in the county. And yet here we are 15 years later, and traffic's no problem. We don't need to get it off of John Anderson. John Anderson will never be the same. It will no longer be John Anderson Scenic Highway. It will no longer be that wildlife corridor that it is. It will be just one more, soon-to-be 4-lane, ripping back and forth. But where's this 4-lane going to go? It's kind of the 4-lane to nowhere. You know, we have the Bulow Creek crossing, we have there the loop. We all know about the loop. All the motorcyclists know when they come into town. So they're going to put traffic light down at the loop to control the 4-lane coming out of Flagler County. You got a bottleneck. And what about the emergency that we talked about? If there's an emergency, and there are going to be emergencies, this is Florida for gosh sakes. There are going to be emergencies. When there's not hurricanes, then a few years later we get the fires. This is a great place to live, but you don't want to be bottled on John Anderson with hundreds of cars ahead of you trying to get out, because you know how people are. They don't leave till they have to, most of them. Some plan ahead and leave in their motorhomes a week early and make it a vacation. But by and large, people don't leave until they have to leave, and then it's a jam. Health, welfare, and safety of the community. These little communities we have all over Flagler are unique. This is a different county from the rest of the state of Florida. We don't want to be Florida somewhere. We want to maintain the uniqueness. That's one of the reasons people come here. This is a place of Florida like it was. And this is a grand developer. He does grand developments, and he's done great jobs in Palm Coast here and there. We may not agree on everything that he's doing, but he has the capacity to develop properly. This is not his starship. This is a cookie-cutter development on some of the finest land in the country, let alone in Flagler County. We're not asking you to shut him down. We're asking you to take control and help him do it in such a way he'll be remembered well, and that you'll be, this is your legacy. This can be the commission that ended the John Anderson Scenic Highway Corridor and put the traffic jam on 100 because you're not rerouting the traffic the way 15 years ago they were able to figure out would be the way to save it and keep that precious piece of road in these precious neighborhoods. You know, I heard Mr. Hadid a few weeks ago saying that he was going to ask you to condemn property regarding the seaside land, regarding the shore up the shore. And he said he hadn't done that before. If you allow this traffic to start coming in out of this development, and it starts right there, and no telling where it's going to go, who knows what this future development thing is going to be, this next time, the next time, who's going to buy it from the developer, what's he going to do, or what are they going to try to do? So we have an opportunity to help the developer do it right, to protect the people of Flagler County. You wouldn't buy a pig in a poke. We've got too many pokes in this development. We got to look at what it might be. $3,999 was the initial request, something like that. Maybe that's where they're going, or maybe that's where someone who buys a property from him. Mr. Schminto said it's never going to be for sale. Well, everything's for sale at a price. Someone's going to buy it. Someone's going to get it. You have a chance to help protect it, and I hope that you will do that. You know, one of the things that has us all upset is this doggone election because people don't think it was fair. We have a gut-wrenching thing going on in the country. We want the people of this county to know tonight that you've been fair. Thank you.
I don't have to.
We haven't called for the public to address under their 3-minute the project. You can choose how you want to manage the proceedings in the way you think most efficient.
Okay, but we're through with the initial part. It's time for public comment. So what I'm suggesting is everybody else has been given a half an hour, that we give the public a half hour. to come forward in 3-minute sections. Is that too much, too little?
I think that's okay, but remind them about, this is a quasi-judicial hearing, and what we're dealing in is facts, not what you think, but facts.
Right. So, and you've heard what's been expressed so far, so let's just see how this goes. So, half hour, does that make sense to the rest of the board members? Yeah. Half hour, public comment, and we'll give the, Mr. Chimento then one last shot to rebut at that time. So, if you line up and come forward for the first person for public comment. And identify yourself, talk to me, and we'll go from there.
Good evening, Commissioners. My name is Ken Bryan. I'm a Commissioner of Flagler Beach, and I'll probably take less than 3 minutes for the interest of time. At any rate, I'd like to thank everyone for coming here tonight and listening to this, as well as all the speakers. First of all, I would like to thank the developer and his planner as well for meeting with me, because I was very much concerned about how the water was going to flow down on Palm Drive. I do have an interest because I actually live on
This
Palm
will
Drive.
cut into your time, but remember, we've got the court reporter here, so she's trying to keep up with you, and so you can be
I'm
here
out of the
clearly.
DC area. I talk fast.
All right, I know.
I'll try.
But it may be easier if you take your mask off. So
Okay, I'll take it off, but I'm going to stay away from the mic. Okay, one thing that I want to make clear, there has never been a homeowners association on Palm Drive. And all due respect to Mr. Parker, I looked up the developmental codes and all that they had, and I have the documentation to show that there was never ever one formed. Unfortunately, the commissioners at that time accepted the fact that there was never an HOA, and City of Flagler Beach accepted the responsibility of maintaining those particular ponds or whatever they are that are here there. That's on me now, so I got that, and I met with our city engineers and our staff. The other thing is, the pipes that actually run under Palm Drive, they're 72 inches. I have a photograph to show you that during the last water that was coming through, it was only 3 inches from the top of the pipe where the water was flowing, so it wasn't flowing adequately in order to let all the water out of that marsh area. So one of the things, the concessions I would like to see is to have another pipe or additional pipes put in there to ensure that there's free-flowing water coming from that particular wetlands area. The other concession that I'd like to look at is that I'm sure that this is a very good plan here. We've had engineers look at it. We've had our staff look at it. But I think it would be in the interest of the people in the community and Palm Drive and future homeowners to at least have some level of bonding that would ensure that there's some kind of finances there to ensure that there is something there to help in the event that you end up in a situation where I am right now on Palm Drive without the funds in order to maintain those type of retention ponds. The other thing is, I did meet with the developer again. 70-foot buffer there is from the end of my driveway out to the cul-de-sac to the new development is 75 feet now, buffer. Before it was 50 feet. I made Mr. Belcher aware that he did increase that to 75 feet. So I did get criticized for meeting with the developers and others, but I think there has to be open communications in order to do these kinds of things, in order to come to some mutual agreements. I'm finished with my time, so somebody else can come up here. Thank you very much.
Thank you, Ken. Next. Identify.
Once again, I'm still Pat Ferraro, and I still live, I haven't changed. I'm a longtime resident of John Anderson Highway, and I'm also, because I'm here repeatedly, a scrupulous defender of my property, my neighborhood, and my city of Flagler Beach. I also belong to the Friends of the Barrier Island when we were just getting the PUD passed for Palm Coast, and we were just discussing how many times that PUD's been brought back and how many times that's been changed, and how Palm Coast doesn't look like anything that IT&T or ICDC, IT&T Community Development Corporation, proposed the very first time, if you want to go back. That used up some of my time, I'm sorry. Anyway, I'm also addressing you in adamant opposition to the widening of John Anderson Highway. Firstly, this road, John Anderson Highway, is also known as Kelney Road 201, not State Road, not a highway, not an interstate. It's also the Ormond Scenic Loop and Trail, which we've already talked about, and it's an extension of the Heritage Crossroads Miles of History Scenic Highway. So somebody before all of us understood the value of that road. and all these designations. It's a premier roadway that traverses some of the most beautiful and diverse natural scenery remaining in all of coastal and central Florida. And it also has ready access to the ocean and to the dunes and the beach. And it provides all this without public access, with public access with no tolls. John Anderson should not be a 4-lane highway. It should not be bulldozed through this pristine environment. I'm not against responsible development. As a matter of fact, I love to share my homeland with people who have a like appreciation. But we do not need to grab more and more land obtaining by purchase or worse by eminent domain when we can have an alternative. As we've seen in the original PUD, entrance and egress to the gardens can be accomplished via Moody Boulevard, State Road 100. Now, if we go to Colbert, we can make exit on that same State Road highway with also having that state road with a median, sidewalks, and bicycle paths. We do not have to create this kind of 4-lane highway on John Anderson. The option in the original PUD should be adopted now for the development. We do not need to rape and pillage any more of our already dwindling habitat. Kindly return to the idea of an over or underpass which will connect the east side of the gardens with the golf course that I heard a couple weeks ago was going to be partially on the west side, and the commercial development, which is supposed to eventually be on the west side at Colbert. This will afford a more seamless access and provide additional options to protect and enable usage of Bulow Creek and all of the burgeoning restaurants, storms, gym, and everything else. It's a win-win for your current neighbors and good neighbors on John Anderson, and it will be a plus and sell win for your new developers.
Thank you.
Good evening. Thank you for the opportunity to address you. I'm Sally Arnoff, and I live in Sugar Mill Plantation in unincorporated Flagler County. Over and over again, the staff report called your attention to the fact that the developer has failed to answer requests for additional information required by the rules and regulations for building a development in Flagler County. What is requested is not trivial. For example, the developer was asked to match the legal description and plat boundaries. That was never done. How can inspections confirm that structures are being placed on the correct property? If you approve the application as presented, you are being complicit with the developer to ignore the rules put in place to ensure a safe development. For over 30 years, I was a senior manager for development and implementation of projects as large as $286 million. It is my expert opinion that when an applicant refuses to put in writing details of how something will be done, it has been intentional. It's simple logic. If nothing is in writing, the developer doesn't need to comply with the rules. Talk is cheap. We are looking to you to protect the citizens and request that the developer follow the rules. The applicant has talked the talk, you heard him tonight, that this development will not worsen the flooding of surrounding land. Please require the applicant to bond those words. So if the talk was cheap, there is money to correct the design. My last concern is Flagler County Municipal Code Tree Ordinance that was enacted in 2004. The code requires the developer to survey the index trees 6 inches in diameter and larger, state which trees will be removed and which trees will be saved. Then, for the trees removed, there's a formula to specify how many trees the developer needs to plant as replacements. How did this developer meet the tree ordinance? They only identified trees greater than 20 inches. They ignored the smaller trees 6 inches and above, and provided no plans for how the trees will be saved. In my opinion, this is another example of the ignorance of this developer thinking they can do what they want. Your approval gives the applicant the permit to start clearing the land without a survey of what trees are there now and a plan identifying what will be removed and what will be saved on day one. When the heavy equipment comes in, all evidence is gone. Without a plan, the county has no basis to require trees to be saved or replanted. If you approve this request tonight, you are accepting what I think is a blatant disregard of Flagler's rules of development. Thank you.
Next.
Chairman, Ms. Arnoff asked me to, she didn't slide, but she prepared slides, so.
All right. All right, go ahead.
Hi, my name's Steve Noble. I live at 614 John Anderson Highway, which is in the 300 feet distance from the development. The main thing that I think has really got to be addressed here is access to John Anderson Highway. When the developer purchased the property, there was no access to John Anderson Highway. It was clearly shown and it was clearly stated in the 2006 plat. I have a letter here from Mr. Mingle, who all of a sudden has flip-flopped his stance in this development. In this letter dated October 11, 2019, he also states to the developer that there is no access to John Anderson Highway. You either go under or over. And I really would have liked an explanation of how Mr. Mingle has flip-flopped all of a sudden now to be supportive of this development, when in this letter, which I'm sure, do you have copies of this? It's a complete change. And we kind of would wonder why that's happened. It seems a little odd that in this letter here, he's basically telling the developer to go back to the drawing board, and he's also telling him there is no access to John Anderson Highway. But now, he asked you, Mr. Mingle asked you to approve this development. I don't understand that. Does anyone here understand why that happened?
Okay,
I don't.
Just address me. It's okay. You have to.
Sorry, anyway. So getting back to the fact of the matter, if you allow this man access to John Anderson Highway, it will destroy the lives of the people who live on the north side of John Anderson Highway, which is myself included. The traffic right now is getting bad, and it's because of the certain developments on John Anderson Highway, with Seaside Landings also being this developer's development. That's causing a little bit of an issue.
I don't think that's true.
Excuse me?
I don't believe that's true. Remember facts.
But I think that he did start the development. Did you, or one of your companies?
No, he did,
Did you tell me?
yeah, go ahead.
Okay, well, I apologize for that. But that's what I was told. But anyway, so we've had 3 developments on John Anderson Highway in the last 15 years, and the traffic's getting worse and worse and worse. If you pile all that traffic onto our street, our home values will depreciate. We'll have so much traffic. It's a situation to where you're taking away our quality of life. And I don't think it's fair that a developer is trying to get away from building the bridge to make us suffer so he can save himself a whole bunch of money. I don't think it's fair at all. Thank you.
Thanks.
Good evening. My name is Anna Maria Abad. I'm the Executive Officer for the Flagler Home Builders Association, and I'm here to speak for all of the members of the industry who can't join us in person tonight. It is quite late. They are finally, I assumed it would be 6 o'clock, so they're finally taking their boots off or sitting down for dinner with their family, or taking their heels off at the door, finally taking a breath after processing loans or title insurance all day. Those are the folks who make up our industry. They're no different from you or I. They work hard all day, hoping to give others the opportunity to live in our slice of paradise. Oddly enough, many of them even need the affordable housing options I've spoken to you in regards to before, and some other folks in this room have also spoken to you about before. There's no doubt that construction is a fruitful industry, which employs a good portion of our community, and those same people will work very hard to build your paradise. For the 335 housing units, a study by the National Association of Home Builders Expect $68 million in local income, $20.2 million in local business owners revenue, $48 million in local wages and salaries, $12.5 million in taxes and fees, and over 1,100 jobs. But this isn't about jobs and money. This comes down to one question. Is Flagler County open for business? If someone lives here and says they love it, then surely they'd want to share it. If not, buy the land. If you don't want neighbors, buy the land. It's the only way to be sure that you won't have them. If I were a developer outside of Flagler, looking at this time-consuming, money-draining process, well, I wouldn't be signing up to develop here. Tonight, I ask you to answer the question with your vote. Are we locking the gates and saying, not here, not now? I love Flagler. I've been here for 28 years. I returned by choice to raise my child here. And no, it's not the same as when I came. It's so much better. We have more amenities and opportunities for the folks that live here. That's called growth, and it's a good thing, and it's something that we should be proud of. Some have selected Flagler to retire or to start a business. These are goals. These are things you want for your county and for your community that you all work so hard for. People choosing to come live here, it means you've done it right. With no true evidence supporting the opposition, I ask you to vote in favor of the gardens and loudly answer that Flagler County is open for business. Thank you.
Thank you. Next.
Thank you, Mr. Chair, members of the commission. Greg Blasset, President and CEO of the Palm Coast Flagler Regional Chamber, 145 City Place, Palm Coast. Just in case we don't get to them, there are business leaders who have joined us here today to speak in support of the project. And I wanted to share with you that recently the board of directors of the chamber voted to support the Gardens project. And one of the chamber's key initiatives is to lead a conversation about the future of Flagler County using data and analytics. What will this region look like in the year 2030? What will this region look like in the year 2040? And thanks to researchers and demographers at the University of Florida's Bureau of Economic and Business Research, we know approximately 115,000 people currently call Flagler County home. UF's projections show Flagler County is going to grow by 30 to 40,000 net new residents by the year 2040. So our population is growing and will continue to grow for the foreseeable future, which is why we need to continue to plan to construct a variety of housing options throughout the county. But the Chamber Board didn't decide to support the Gardens because of future housing. Chamber leaders also considered the impact that this project will have on the local economy. According to data from the Florida Legislature Office of Economic and Demographic Research, last year construction jobs in Flagler County represented more than 7% of all jobs in the county, and that's not including real estate, banking, insurance, and other industries that support home builders. There are more recent numbers to suggest that despite the global pandemic, the construction industry in Flagler County has grown to nearly 8.5% of all jobs in this county. So simply put, construction industry in this county is a major economic engine. Many residents rely on future construction jobs, and as you heard earlier, this project alone could support more than 1,100 construction jobs. As someone who has recently moved back to this community, I speak from experience when I say that people who buy new houses that come to our community, one of the first things we do is we go out and buy new items and frequent local businesses. I've spent thousands with local businesses buying refrigerators and washers and dryers and towels and whatever else. But I did want to touch on one point that you heard Anna Maria talk about, which is I think voting in support of this project sends an important message to builders and developers. And that message is that Flagler County is open for business. Unfortunately, our region doesn't have the best reputation when it comes to being business friendly. And the message that a no vote sends to the construction industry is that it would be more of the same in Flagler County. Here you have a developer that has significantly revised the project to address the concerns of both the local government and residents alike. A vote to support the Gardens this evening will show future developers interested in investing in our region that we will work with them to make sure the best version of their respective projects earn an approval from this board. So on behalf of the Chamber, we urge you to vote in support of the Gardens project this evening, and I thank you for your consideration.
Thank you. Next.
Hi, Pam Hathaway, Flagler County resident. I was going to say something entirely different, but after the last two people spoke, we are not against development. That is the last thing we're against. We are just for development that is already approved, They want to use an existing PUD. It is entirely different than what the existing pub was under Ginn. So I'm a small business owner. My son, who'll be up here, is a small business owner. We want to see Flagler County business, construction, everything thrive. But we wanted to do it under good circumstances and under circumstances that were actually approved back in 2005. It's not fair to those residents who bought on John Anderson, knowing what the PUD was at that time, to have to go through an entirely different development than what was approved back then. And the most significant, which has already been mentioned many times, is the crossover. That crossover, I think if we had the crossover, that would be one major step in the right direction. Thank you very much.
Thank you. Next.
Going to pass out. Again. Can I use this? Can I? It's still the time.
Yeah, we can use it. It's,
How do I turn this on?
hold off on the time here for a second. Is it working? This is what you're going to show, right? Okay.
That light?
There it is. You got it now.
Okay, cool.
Okay.
Yeah. All right.
All right, start the time now.
All right, here we go. It's going to be flooding 101 right here.
Okay.
So this is a common sense approach to flooding. Okay, we heard last time, what's that? Matt Hathaway, Flagler County, John Anderson. We heard last time, 2 weeks ago when we were here, flooding was a huge topic. They addressed it. They addressed rainwater. They didn't, in stormwater. I didn't hear a lot about the surge. And that's why I want to just bring this to your guys' attention. That seems to be the major issue down there, okay? And we have folks that have been here 20 years. Lots of people have been in this county for a long amount of time, a lot longer than I've been there. So with this, what we're looking at here is when the water comes, when it's coming down the intercoastal, it's fine when we have an issue with the runoff. But like you said, what happens when the intercoastal rises, okay? The issue with the flooding in Flagler County is strictly based off of storm surge in what I've experienced. So what's going to happen is this parcel, this is a major parcel here. This is 50 acres. 50 acres of surface area that right now is absorbing water. That's taking water during any kind of hurricane event or storm event. That 50 acres will essentially be homes and will be raised up. Where does that water go? So what I did, I'll try to go quickly here. This is kind of tricky going between these microphones. I flew my drone over, and as you're going to see, if you go to slide, or page 5, there's a significant amount of water in there. Okay, and that 50 acres is absorbing water currently. So they address flooding. They address flooding specifically for the Gardens project, but they didn't talk about flooding for the surrounding neighborhoods. Where's that water going to go? We got roads in Flagler Beach that are filling up, not on hurricanes, but on nor'easterns. So you're talking about, let's go back to the first one. $50 acres that currently holds water under any kind of storm event. That water's coming, that water's going to be pushed away. You're essentially building like a massive seawall there. Where's the water going to go? Surrounding homes, Palm Drive. I don't know how they can handle it. You can't even quantify the amount of water that area currently absorbs. Billions, millions, if not billions of gallons of water. That's going to have to go somewhere. Now, ponds, retention, that's all good for rainwater. But we're talking about surge. What's the number one threat for death in hurricanes, in any kind of tropical cyclones or events? Storm surge. That hasn't even been addressed. That's the issues. Look at the hurricanes this year. It's unbelievable. That acreage, we're not talking about anything on the backside. That front acreage, There's a problem there. You're going to build that up, that water's going to have to go somewhere. I want to show one last picture. Just real quick. That's the backside wetlands. You can see how much water was in there on that last storm surge we had. That would be in relation to where the water would go. Look how close it is already to the homes. That's not even on a hurricane. Thank you.
Next.
Good evening. My name is Scott Sowers. I'm the very sleepy president of Klein Construction right now. You know that projects like this one are the lifeblood of our economy. This project will bring millions of dollars in economic activity to our county. It will employ hundreds of people and small businesses in our community for years to come. All these small businesses involved with this project pay a lot in taxes, and we all know that in the next few years to come, due to the COVID crisis, there will be drastic cuts in state budgets which affect our local grants and other revenue streams that you all depend on to operate our county. Does it make sense that for years we all talk about and strive to make Flagler County a place where developers and businesses want to come? Now we have that opportunity. Don't drive them away. Please listen to your staff who do the legwork to vet these projects to make sure that they comply with our codes and ordinances. Listen to your local Chamber of Commerce. Listen to your local Home Builders Association. And finally, listen to our businesses and approve this wonderful project. It will look great, as do other projects they have built, such as Marina del Palma and Palm Coast Plantation. Thank you.
Next.
Yes, my name is Charles Meekins. I live at 710 John Anderson Highway. I've lived there since 1960, most of my life, a few other places, but about 50 years. I've seen a lot of changes, and I have never complained about the growth of Palm Coast, but this is a little excessive. We're seeing traffic. My house is rattling when we have trucks roll down the road, and it's starting to shake the windows, and this is only going to increase. And we also, all of John Anderson, from the county line down, they're all wells. And we have really good quality water. But what's going to happen when all the influx of traffic and building, I don't know, these are shallow water wells. And what are we going to do? Are we going to go on city water? I don't know, but the only thing I could ask is that we could keep them off of John Anderson, and that's going to preserve the nature of the beauty of that area. Thank you.
Thank you. Kim, as you come forward, it'll be fine. But we're right coming up against the half hour that I set aside. Now, if the board feels we can extend that, but one or two more, and we'll have hit the half hour point. Does anybody have any comments on that? Well, okay.
If you cut off the line with those people that are in line right now, I think we're
Who's in
okay.
line right now? Just raise your hand. It's 1, 2, 3, 4, 5, 6. Okay. No one, okay, that's it. If you're in line right now, we'll go. Okay, Kim, thanks.
Hi. Kim Carney, Flagler Beach. A fact, 15 years ago, this board voted on a PUD. That PUD met the needs of our entire community. The development agreement painstakingly included provisions to protect the citizens of Flagler Beach. The adjoining community to this PUD, provisions for reclaimed water, provisions for traffic, and provisions for a golf community. What has been presented to you does not provide for reclaimed water, does not provide for traffic or a golf course. You heard all that already tonight. These are facts. The board was concerned about the neighboring community 15 years ago, and we are asking you to do the same thing tonight. You and this community are entitled to a viable plan meeting the requirements of the current PUD. There is no water treatment plant, there is no golf course, and there is no overpass or tunnel to control traffic. We are asking you to vote to develop a new PUD and, more importantly, a new development agreement. The need for the community has really not changed in the last 15 years. There is no agreement to provide the plant to make the reclaimed water, nor is there an agreement to purchase the water when and if Flagler Beach has the resources to provide such water. With regards to Mr. Torino's statements, if you look back in the notes of every TRC meeting, you will see that your lawyer pointed out almost every single thing that was said by Mr. Torino. I sent an email to Mr. Torino after the last meeting and asked him if he was contacted by the county to provide his input, and the answer was no. And I forwarded that email to Mr. Mengel. All we're asking you to do is to follow the process. Thank you.
Next.
James Fisk, Palm Coast. In June of 2018, I received a certificate of training through the Florida Department of State Bureau of Archaeological Research for Archaeological Research Management, Resource Management. Archaeological sites, the history in this area. There have been a total of 18 known prehistoric sites and 4 other historical sites located on the property. A letter from the Department of Army Corps of Engineers, Jacksonville District, P.O. Box 4870, Jacksonville, Florida, on May 22nd, 2019, was addressed as a public notice. The applicant was the Palm Coast Intercoastal LLC. Attention, Mr. William Allen, 3129 Springback Lane, Suite 200, Charlotte, North Carolina. Southeastern Archaeological Research Incorporated conducted a cultural resource assessment survey of the project area in 2005 and evaluated 4 sites as potentially eligible for inclusion in the National Register of Historic Places. They recommended preservation or Phase 3 mitigation, which is reinterment. The findings of the action, which included the identification of very minimal amount of human remains. Yes, there were human remains found in middens. Based on the information above, I have consulted the president of the Flagler County Historical Society. I'm a board member there as well. We will be pursuing potential inclusion in the National Register of Historical Places for these sites. Listing in the National Register does not in itself impose any obligation on the property owner or restrict the owner's basic right to use or dispose of the property as he or she sees fit. It does, however, encourage the preservation of significant historic resources. History matters. The concerns I have are based on occurrences that have happened in the past in Flagler County with an entire 1820s historical sugar mill site being bulldozed for commercial and residential sites, along with prehistoric animal bones that were buried while constructing canals in Palm Coast. Cattle dipping vats. Approximately 3,400 cattle dipping vats were constructed throughout Florida from 1906 through 1962. 45 were located in Flagler County. It is now known that the solution used in these cattle dipping vats is harmful to humans, and vats may have contaminated the groundwater in their vicinity. Other possible contaminants are BHC, DDT, DDE, and toxaphene. I'm running out of time. Thank you.
All right, thank you. Next.
Good evening. My name is Bryn Newton. I live in Beulah Woods, or what's left of Beulah Woods. And I'm here to speak on behalf of the Sierra Club and to reiterate the letter we sent you in September asking you to consider several things, but in particular, the future development designations that were on the map at that time. At the time of the agenda was published, it didn't say whether that had been addressed. But in any event, we think the letter that you've received in the meantime from the city of Flagler Beach makes a very modest proposal, and that's that you specify that any increase in residential density or commercial intensity beyond that approved within the 2005 PUD shall require amendment of said PUD or other appropriate rezoning. So we ask you to please include that. Don't let anything called future development just be a placeholder for more development within the project. Stick with what's been approved. I thank you for your time, and I commend you for your endurance. Thanks.
Next.
Carol Weissel, Halifax Plantation. And I have my notes here, which I would like to get to, but first I would like to address the realtors and developers. There is plenty of development in Flagler County slated and in the pipe. I think it's like 8,000 units. Barbara Revels could talk to that better than I can. We are not anti-development in any way, shape, or form, and Flagler County will survive. This development is just in the wrong place at the wrong time. Palm Coast Intracoastal LLC has modified this PUD site plan application from 3,996 units in July of 2019 to the original 453 units negotiated in 0506. But the original had only 219 lots on the east side versus 335 lots now. More important is what has not changed, the location. It is still an environmentally sensitive area that will access roads that are failing or have failed to meet level of service requirements and will likely directly impact an adjacent municipal jurisdiction. This is a direct quote from a report by Rachel Bennett, who was hired by Flagler County to conduct an independent analysis of the gardens. The other thing that hasn't changed is the incompatibility of the flume with the proposal. This agricultural district allows bona fide agricultural pursuits, timber production, and limited residential development. This is not limited, at a gross density of 1 unit per 20 acres. Policy A155 Flagler County shall not amend the land use plan to change the land use classifications of agricultural pursuit and timberland production areas as designated on the county future land use map. It fails to adequately protect and conserve natural resources. Again, Rachel Bennett's report. I'll skip to a final thing that hasn't been touched because I know a lot of things have. This proposal still directly impacts Flagler County schools. It will increase student population by over 111 students and cause overcapacity at Old Kings Elementary and Flagler Palm Coast High. This will necessitate a concurrency application and mitigation if required. Old Kings Elementary is also a designated evacuation site that is impacted by the gardens. I volunteer reading in Flagler County, and the school concurrency is very important. Thank you.
Next.
Good evening, Commissioners. Eric Cooley, resident of Flagler Beach. Appreciate y'all sticking through this. I'm not going to bombard you with the voluminous amounts of information that has been presented to you about why the existing PUD should not be approved, but just want to talk a little bit about options here. So there's really only two options. There is the developer build to the existing agreement that was set forth. They can go ahead and do that. The other option is we go back and we build to current land development regulations. Those are really the only two options. A spiral and a modification of what the agreement was, and it has now become, all the evidence is overwhelming as far as it can't be approved that way. It's all black and white. City of Flagler Beach, they represented huge amounts of evidence of why that can't happen. Redoing the developer agreement, if the existing PUD If they don't like it, they just redo the existing development agreement. If that's what you vote for, you're not saying no, you're saying, yes, let's do it correctly. And that's what I would like you to do. I'm not against subdivisions, I'm not against development. What I am for is quality, following the land development regulations, doing what's right by your neighbors, doing what's right for the area. And to all the special interest groups that want to push this forward at all costs, as a business owner and a business representative of the business community, and a big one in Flagler Beach, I'm very concerned at the move forward at all cost approach and not the quality approach. Shame on them. Shame on home builders. Shame on the chamber for even tabling it. One of the things that I do as a representative of the business community, if it's not the right idea, and if it's not a good representation of the business community, I'll push back on it. One of the most important things that we need to do is make sure that we are moving forward in the right direction. What I would ask of you is for you as commissioners to do the right thing by requiring the developer to do the right thing. Thank you.
Thank you. Next.
Good evening, Commissioners. My name is Chelsea Barney Herbert. I'm a resident as well as a second-generation business owner here in Flagler County. When we moved to Flagler County in 1998, my father started his own company as an owner-operator who built house pads for new construction homes. Through his own hard work and by investing into himself, he grew his company to a full residential site work service that employed 14 people. Then in early 2006, he made the transition to commercial site work development and underground utilities. Unbeknownst to him, the housing market would crumble not long after, making his timing impeccable. Some may call that luck, but it wasn't luck, it was vision. And again, by savvy investments and his own hard work, he trudged through the worst economic times his generation had ever experienced. On the back end of that rough patch, I joined the company during my last year of college. My dad tossed me onto a pipe crew for $10 an hour. He let me work in the office, unpaid I might add, on Fridays to learn estimating. At the time, I thought it was a bad dad joke. But again, it was just all a part of his vision. Fast forward to 2020, even amidst a pandemic, we are a successful general contractor, underground utility contractor, and complete site work development company who employs 35 people full-time. We're able to offer consistent local work, company health insurance, and retirement benefits for our employees. None of that would be possible without positive growth and leadership with vision. And although we are here now, without that continuous growth, we are not guaranteed that success in the future. In recent years, my dad has really allowed me to take the lead and shine. This has given me the opportunity to create my own vision. I realized quickly the impact I could have on the people who work for us, our community, and my own family through this company. I am here not only to make a living, but to make a life in Flagler County. My vision is not one-dimensional. I hope that our commission's is not either. My hope is that we continue to grow our community with vision and purpose, that we think to our future generations. What opportunity will be here for my children? I think about that often, probably the same way my dad did when he was a younger man, which is ultimately why he created this company, to create opportunity for his family. I hope to do the same. I hope you will do the same. I hope our community and its leaders have a vision that gives companies like ours the opportunity to thrive here, and children like mine the opportunity to be third-generation business owners. I'd like to thank you for your valuable time tonight and end with one of my favorite quotes. Vision without action is merely a dream. Action without vision just passes the time. But vision with action can change the world. Thank you.
Yeah, would you please? Good evening. Thank you all for being here. My name is Sandra Netubik, and I live on Pine Tree Street, right off of Palm Drive. I'm here to talk about the flooding. I live on the street that the canal runs down from all the wetlands from the back of Palm that comes back from where this development is going to be built. And if he builds and elevates and fills in, then all that fill will not soak in and it will drain off. I have had my canal, the back of my house, has been, those are pictures that were taken during some of the flooding that we've had. That is the back of my house. This last time, I had flooding all the way to the top of that bridge, all the way over my seawall, and it came all the way around the back from the wetlands and came all the way down the street and stayed at the end of Palm. For 3 days, I could not get out. I couldn't go the back way and I couldn't go down the other way. I couldn't get out because I was totally logged in with water all the way around. So this is really a big concern for myself, my neighbors, and where I live. And I have lived here for 20 years. And I was definitely flooded out with the hurricane in 2017. But I'm asking you to please think about the people, the residents, and what can happen to all of us. And I know you'll try to make the best choices possible, but it's really very scary and it's very frightening that I get up every day and the water in the canal is up to my seawalls, and it was that way for days and days and days. Thank you so much, and I will close it off at being the last one.
All right, thank you. I think that the agreement was that, Mike, you have a chance. I would say roughly, are you looking for roughly how much time? You've got 5 minutes or so to start with. Or you may need more. Just give me an idea. There's been a lot of information put out since you spoke.
Well, before I get started, we can just put our closing quote comments and then be available to answer any questions that you may have. Is that what
I think that's probably, that's fine.
So, there's a lot of comments here tonight. Many of them have been addressed. I think it's quite evident that people want to relitigate the PUD that happened years ago. This isn't about that. This is about the plan we put forward match the concept plan. And your staff has said yes. I don't know this to be true or not, but there may be arithmetic errors on the chart that was brought to your attention by the city of Flagler Beach and others, which we're obviously willing to correct if there is an issue. But I think it's more important that you all, as commissioners that represent our community, the residents in North Palm Coast and South Flagler County and Flagler Beach on the west side, and really are geared to represent the community as a whole and not any one group, that you hear from Mr. Belchie, who's been here for probably 20 years. He developed Palm Coast Plantation. And I just think it's important that you hear from him in closing arguments. And then if you want to talk about specificity and certain issues that the public brought up, we're here. We have our experts to address them. So, Mr. Belchie, if you just take 4 minutes of your time, please.
Okay.
Thank you, Mr. Chairman. My name is Ken Belshie, 164 West Village Drive. Thank you very much for the opportunity to be here. I know this has been a long and a difficult struggle for everyone, especially the people on the commission, and I thank you for that. I have remained relatively quiet in these meetings because I feel that the public deserves the opportunity to tell you about their feelings, to be passionate about it. And I think that's very, very important in our political process in our country. However, I do believe that facts are important also. And many times our company has been villainized in some of these people's comments that we're going to rape and pillage the land, we're going to do all these things. One thing that I took particular offense to was a video that showed Bulow Creek. Bulow Creek is a pristine, beautiful place. We don't own any of Bulow Creek. All of that property and much of and a whole bunch of the land on the east side of Bulow Creek was given to the county by the previous developer. We're not here to talk about developing Bulow Creek. That's not what we're here for. We're talking about the east side of John Anderson. But the part that really bothered me was that they then switched to a photograph of what is now Marina del Palma. And as if to say, and it was when it was under construction actually, as if to say that Bulow Creek was then going to look like Marina del Palma. A lot of the people here haven't been here long enough to remember what Marina del Palma and the adjoining property looked like 15 years ago. It was an industrial nightmare. There were giant concrete structures on that property. There was trash and cables and bricks and concrete strung all over 150, 100, 200 acres there. The fact that it's gone now, you can thank a developer for that. Okay, we took on the job of cleaning up our property. Bob Million took on the job of cleaning up the property next door. He spent millions of dollars trying to do that. And the result was we had a flat piece of land with not very many trees, okay? But it looks remarkably better than it did when we all started. And again, you can thank a developer for that. But in that process, if any of you remember back 15 years ago when we were permitting Marina del Palma originally, we entered into an agreement with Sea Ray because Sea Ray was very concerned about their jobs. We entered into an agreement with them to pay them over $1 million to help them upgrade their equipment so that their emissions would be much cleaner. We were happy to do that. Not happy to give them the money, but happy to enter into a partnership to do that. You know what happened to Sea Ray? Some of the same folks that have so vehemently opposed our development were applauding them on their way out the door with the 400 jobs that they took. So facts are important. Developers can do things right. We feel like we have done this development right. I have tried many, many times to speak with many of these people that stand up and say that we're not doing things right, we're not working together, all that sort of thing. I have copies of emails where I've requested meetings. I have phone calls, numerous requests through my attorney, through others to try to sit down and meet with folks. Some have, many will not. Had a great meeting with Ken Bryant a few weeks ago. Very reasonable person. We got to the facts, he understood them, and I think that he realizes that maybe it's not exactly where he would like it to be, but it's being done well. Anyway, I want you to know that we do follow the rules. There is a litany of government agencies that require us to follow all the rules and regulations, whether it's DEP, the Corps of Engineers, St. Johns River Water Management District, the LDC. We're required to do all that. We do it, and we do it consistently. And I would just ask that you support us and do the right thing. Thank you.
Thank you. All right. We're now at the point where I'm going to bring it back to the board. We're back to the original item, which is 9G, which is the original application 3209, request for modification of a PUD site development plan. Yeah, yes, it is. It's on, right? Can you hear me? Okay, sorry. I'm just trying to read at the same time. Let me get my glasses on, take this off. So back to the board. We can go with a motion right now. We can do a further discussion among our, up here. Just trying to get an idea of where we want to go at this point. And Mr. Adid, am I right in that we're at that point?
Yes, sir, you are correct.
Okay. So I'm looking for comment. This is a very, this is difficult. There's no doubt about it. It's very hard. And I don't want to lead the discussion here before the other commissioners have a chance to look at this. I can't make the motion anyway, as chair.
Well, a couple of things I think are still sitting out on the table. They're talking about widening John Anderson. That's not going to happen. I mean, that's not going to happen. So people get that off the table. That's not going to happen. John Anderson is going to stay John Anderson. We've said that from the very beginning. I'm concerned about the issue of the tree requirements. Mr. Chimeno didn't address that issue. Was a tree study done? I think that's a valid comment because it's all wooded. That's a lot of trees there. So I'd like an answer on that.
I guess on that, is it true that they only looked at trees that were 20 inches in diameter.
I just want to know what the facts are on that.
Yeah, what we did is we did a tree survey of trees 18 inches and larger, and then we demonstrated with the 100-foot buffer that we're preserving. The trees we're preserving in the wetlands and the upland buffers around the wetlands, kind of those white areas in the green. I showed you guys earlier that we met the tree requirements. We also have requirements for every lot to have a certain number of trees be planted per lot to meet the requirement.
What kind of trees?
They would be shade trees, oaks, elms, magnolias, some palms right on the waterfront.
How do we get from, the original PUD was 219 homes, and this one is 335 or so on the east side. How do we get there legally? How do we get there? How does that happen?
I'm sorry. Thank you. As Adam pointed out to you, the PUD has a total number of units that they can place in the golf course residential community.
But that included, Mike, both sides of John Anderson.
Both sides of the road, right. He also pointed out to you that there's no requirement. They put so many on one side or the other. It was left open for a future analysis. For example, remember when Walter Fafidio or maybe Larry Torino said we started at 30,000 feet,
right,
and we worked down to 10, and now we're on boots on the ground. So the PUD has flexibility. Again, after the PUD, years later, came in with their proposed site plan and said, this is what we want to do. And that site plan was found consistent with the PUD. We just have a different site plan. There's no binding site plan on anybody through the PUD. There's a site plan that can be consistent with the concept plan. So we've proposed to put more over there, less on the other side when we come back and do that. And remember also that there's 100,000 square feet of commercial, retail, and condominium to be placed in that areas. And then there's about 253,000 square feet of commercial and retail and condominiums to be placed up on the front.
And can you address the, it still bothers me about on your site plan, the areas that are sort of undescribed. That still leaves me with a funny feeling in my tummy here. What can happen in the future? And I don't think you can do anything to those pieces of property without coming back to us. But it scares me that you've got this 300 and, it's actually 353, I think, isn't it? The number of units?
Total, 453.
Yeah, but
we can
on
do
our
it.
side, the
And
east
then
side.
on this side is 335.
335, right. So what's to prevent you from taking those undefined areas and building more houses on them?
First, we'd have to come back and get that next phase approved by you. Remember, there's also a marina plan there. So that future development phase could have some of those. There's 150 condominium units that could be developed in the residential commercial area. That's all in the future development. So that's why we said when we were dealing with your staff that they wanted to have some restrictions. And we said, okay, it's just future development and we can place a restriction on it so long as it's consistent with the PUD that exists. You know.
So your traffic study, did that only take in the 335 homes?
Yes,
when
sir.
you did the
Yes, sir.
traffic study?
So when we get to the next
So-
phase, we'll have to do an updated traffic study, and if there are issues with the second phase, as in all development, you have to meet the requirements then, and then provide mitigation. So we can put additional restrictions on the plat, dealing with that future development area, whether it's the marina area that you see down there. That was part of the unique design and spirit of the PUD. That any development in those areas will be consistent with the PUD. Now, everybody understands that anybody can come back in the future and ask for a change to the PUD. That's what the city of Flagler Beach wanted you to do, is say, hey, we're going to renegotiate our deal. I'm not too happy about those comments, particularly from a city. But those are all things that can happen in the future. But right now, we're not asking for that.
Right. One thing that concerns me at this point is just the position of the city of Flagler Beach right now on this. Is there a, other than the letter we received concerning the I think 4 items that they were concerned with, it sounds like there's no, the city of Flagler Beach is not committed to anything at this point. But I don't know the answer to that. I'm just kind of wondering, I don't think we were really briefed on that.
This is the general process, and Adam can come up and talk to you about how the county has done this historically, as do other jurisdictions. When you get to this site plan process or preliminary plat, you get a letter from the jurisdiction serving utilities. It's called a will serve letter. Clearly, the city of Flagler Beach has plenty of capacity for water and sewer. Their presentations have demonstrated that. What happens next is then we, or any developer, goes and execute a utility agreement with that provider. And that utility agreement provides things like how many connections you'll get at what cost and timing and phasing of that type of thing. So that's the next phase in this process, that we go get a utility agreement. That is always done. It's a standard operating. Now, at that point in time, if the utility provider, whether it's the city in this case, or it'd be Palm Coast or Fuqua, those discussions are had with the utility. But certainly we can't start construction or do development until we have a utility agreement with the provider.
Okay.
You got another one?
One more.
Yeah, go ahead.
I think it's probably for Ken. I was interested in the comment or the criticism that you didn't make good use of what is a very scenic part of Florida, that you just kind of did a cookie cutter type approach to it. And you don't have to answer that, but I just thought that was an interesting comment. And if you had any thought on that. I know that. That's why I say you don't have to answer. I just thought that was an interesting comment.
Look, can I comment on that real quick?
Yeah.
You know, I think when you look at a project of 2,000 acres and you look at just this one side, it's easy to say, oh, that's just a road and subdivision and some nice amenities there. But when you step back and you look at it from 30,000 feet and you look at the binding agreement, what was the deal? The deal was we had 2,000 acres, and they negotiated with the county at that time. We're going to take 1,200 of them. We're going to put them in the most pristine. We're going to put it in conservation and give it to the county. Guess what else we're going to do? We're going to give you 10 acres for a boat ramp for the community. Guess what else we're going to do? We're going to give you acreage for a fire station and for your mosquito control. And. So when you look at it, when you go back to the history and you look at the PUD from the global perspective, clearly this is unique design. Whether you like the design or not, it's in the eyes of the beholder.
Well, Mike, it wasn't a criticism. I thought it was an interesting comment. I was just
I found
trying
it
to
be
get
too.
something
Me too.
out of you. All right.
Me too.
Did you,
Yeah, no, I
Ms.
want
Robbins?
to say a couple of things too. You know, you brought up, that's a good point, the land sitting there like it. I mean, there are some flooding issues. I've seen that. And I see the pictures. I've also seen a lot of developments correct those if they're done right. You know, we certainly believe, you know, I personally believe in land rights. I believe that, you know, we're not going to stop growth. Growth is going to happen regardless. There's no way to stop it. You know, Adam, one thing I do have a comment, I've got a question for you. And Adam, a lot of this stuff that we seem like we're dealing with would have been better suited and better resolved in the planning and zoning group, the meeting. Who chairs that? Who's over that?
Well, staff sit, and then you have a chair every year that's nominated from the membership.
chair currently?
It's Tim Connor currently.
Yeah, it may be good to have a conversation with him and just say, listen, these are issues that need to be resolved way before we get to this point. I feel like we're trying to make decisions that the technical, I mean, there's a reason that committee's there, is to either turn this stuff away or bring it to us. And I feel like a lot of this stuff is making it through with a lot of unanswered, you know, these are people's lives. And they're having to come in. We're all staying here this late. And these are things that I think need to be vetted a little better. So maybe just speaking and talking to them, you know, having him talk to them, just getting on top of this a little better. Because this is not just this project. It's many of them coming in.
And maybe I need to answer that better, that there's staff level technical review committee. You saw the entirety of that record, and then you have planning board that provides a recommendation to you. based on that TRC. And so that, you actually have two lower bodies, the TRC staff, planning board holds that first public hearing that happens in any PUD. And so I'll share the comment with
No, I know
everybody.
we've met a lot. We've met a lot, and this has been an issue for a while, and it needs to get, we need to decide something on it.
Right.
But
Well, here's, just for a second, for the continued comments from the committee. I don't think we're going to change a lot of minds at this point. I think it has been discussed ad infinitum, to be honest. I don't think there are a lot of new things, although, Adam, you did come up with some wording that we had not seen before. But I think we're at the point where it's time to make a decision, and that, like it or not, that's our job as commissioners, is to make a decision on this. The staff has done, I believe, everything they're going to do on this, unless we come up with some new direction. But I just feel that it's time to make a motion here and vote one way or the other, and then we have to live with that decision. If I'm wrong, I'm wrong. But a couple of minutes, go ahead. No more than 3.
I promise you.
Okay.
The bottom line is, this is really a legal decision again. I know we're humans. We have emotions, all right? And that's all right. And I think it's good to tell you how we feel. But this plan is not consistent with Flagler County's comprehensive plan. It is not. You've heard testimony out here. You've heard the expert witnesses. There is no way this conforms to Flagler County's comp plan, nor does it conform to Flagler County's land development code. Legally, it doesn't make it. They can make it. They're good. They got a great lawyer. They've got good minds and they've got good intentions. They need to do it right. It needs to be sent back, and they need to start again instead of trying to cherry pick this PUD that Glenn put together, take what they like, and not do what they are obligated to. In other words, they want vested rights but not vested responsibilities. You cannot allow that even for the biggest developer in the county.
Well, back to the board.
Mr. Chair, I had one other question here about we seem to, on the grade-separated crossing of John Anderson, can you just clarify your position on that, Michael?
Certainly. You've heard your staff review this and go through, and I'll say this intentionally, the entire paragraph that dictates this issue of traffic. The entire paragraph talks, as Adam went through line by line with you tonight, it's clear. We can have access to John Anderson. We can have roadways or entryways on John Anderson, and you may provide an above or below grade crossing. That was in the agreement. That was in the agreement, okay? What Ginn did years later in their design and plan was to do something unique and, as Adam said, provide some type of isolated community. They elected to do it, but it's not mandated. It's not mandated, and it's not part of the PUD, and it's not necessary under the traffic study to minimize impacts on John Anderson. So, we can talk about that. It was brought up at the last meeting, concerns about when we build the golf course, how we're going to get people across that. I mean, we're more than willing to make that as a condition, that when we do the golf course, that will provide the pedestrian golf course overpasses or underpass. We can look at that at that time to make sure that there's pedestrian safety across it. But there's nothing to indicate anywhere in the PUD. I mean, he went over the meeting minutes where Mr. Tanner's wife herself pleaded to change it from may to shall, and the commission did not do that. I mean, it couldn't be any more clear. I know it's what they want. I know that's what people want, but that's not what the agreement is. That's not what the law of the case is.
Well, I keep going back to this one sentence in the staff report. It says, intuitively, a grade-separated crossing for the Gardens project would reduce the traffic impacts and delay the need for widening. We heard a lot about that tonight, and if we haven't, I understand you don't need to do that right now in terms of the impact of the additional units from the condos or whatever other development's going to be there, but certainly it seems like we'd be making an attempt to address it by looking at the grade separated crossing in some form or fashion. So,
You know, again, I mean, we've made our position very clear. The plain meaning of the language says what it says. Your staff has supported that. I don't know how to address it, that it's a requirement. It just, it is never been.
Well, why don't we address it not as a requirement, but as maybe a necessity? 335 homes, and you're going to probably double that, or at least come to us and ask us to double that. I think that at some point, I think it's going to be necessary to route traffic over John Anderson and send it out to Colbert. But I agree, not now. I agree. I don't think the traffic is an issue, right, with 335 homes, but I think it's going to be.
I will say this as some of other people have said. If there is a desire for Mr. Belchi and his group in the future to come back and modify the PUD or amend it, when an applicant does that, it opens up the agreement and everything becomes negotiable. So I don't know what the future is going to happen, what's going to happen with the development or when these other phases will come in. But again, your process, the state, federal, local processes all dictate these traffic analysis. So I understand your comment.
So is there any desire on the part of one of the commissioners to make a motion concerning item 9G?
Mr. Chair, looking at the options that the staff, some of the options that the staff laid out, I would make a motion to, for approval, using option 2, which is the Board of County Commissioners approves the application, a modification to the PUD site development plan for the Gardens PUD, finding that the proposed PUD site development plan is consistent with the Flagler County Comprehensive Plan, the Flagler County Land Development Code, and the Hammock Beach River Club PUD Development Agreement, subject to all development conditions within the 2005 PUD Development Agreement as approved through Ordinance 2005-22. The condition that the developer exchange the current fire station parcel tract PL2 with the county for a better suited station site of comparable or greater developable area within the parcel prior to the issuance of the 50th single-family residential building permit by the county. C, or number 3, the use of future development tracts shall be limited to the approved uses within the PUD development agreement. I would also add language in there that they should, in acceptance of what Flagler Beach discussed, that they should be described with the planned and exact acreage delineated. No wells be, number 4, no wells be drilled within the project, and that's my motion.
Okay, you have that all written down?
Yes, I do.
All right. Is there a second? I would second it. We have a motion and a second by Mr. Mullins. We'll open it up. Mr. Hadid, I believe I do have to open that back up then for public comment concerning the motion. Is that correct or not? It's a quasi-judicial?
No, sir. You're in a
I've provided the-
quasi-judicial.
Okay. All
You've
right. I
engaged
talked
in a
about that.
quasi-judicial hearing. You've had all the input, and now you're formulating a final decision to see what the board can agree to.
Okay, I agree. So we have a motion on the floor, Commissioners. Is there further discussion concerning the motion that has been, and we'll have it restated before we go forward with any kind of vote.
Just a last comment. This is a big change to Flagler County. We're making a decision here that's going to have a large impact on our county. That's.
Okay. Mr. Erickson, any further comments? And we'll have it reread. Anything else right now?
No, I think we've put this thing down the road, and more things keep coming up. We need to, whether we approve it or not, it needs to be decided. I mean, we've got to make a decision. We've got to move forward. again, I have said it over and over, growth is going to occur. We are going to grow. We can't stop it, but we need to define it. And if this is the definition everybody wants, then look to it. But we need to make a decision.
Mr. O'Brien, Chairman, would you go back, can you read through slowly so our
Well, Mr.
secretary
Chair-
can kind of get this down correctly?
Mr. Chair, all I did was read option 2 as was stated on page 14 of 15 of our agenda item.
But I thought you made a couple of little modifications as you went through.
The only modification I made is that the delineation of the future development tracks be specifically described with exact acreage. The usage.
All right, so the motion on the floor is for item 9G, application 3209, request for modification of a PUD site development plan in the PUD, Planned Unit Development District for the Hammock Beach River Club PUD located south of State Road 101 and east of 100 east and lying east and west of John Anderson Highway with the associated parcel numbers, which is on our agenda, option number 2. And we're approved with conditions as stated in the motion. With that, I'll ask for a vote.
John Tanner again, did you make a decision we could not make further comment?
Yes.
Yes.
Yep, we did, I did. I asked our lawyer. So the motion is on the floor. It's been reiterated. I'm going to go ahead and pull the board. Charlie Erickson?
No.
Greg?
No.
Mr. Mullins?
Yes.
Mr. O'Brien?
Yes, made the motion.
I am going to vote yes on that. No comments. Now we're going to go on to item 9H, quasi-judicial application 3210. It passes 3-2. Okay, we've got Adam, if you come forward. Please be quiet as you leave. Is Adam here? Adam, come forward for the 9H.
Mr. Chairman, Adam Mangle, Growth Management Director. I'll be brief with this, and I'll actually skip my, my slides. This is for approval of 6 separate plats, 6 phases, Phase 1A, 1B, 1C, 2A, 2B, and 2C, consistent with the PUD site development plan that was part of the previous agenda item. There are 4 options available for your consideration, and I'll read the choices under the condition for approval. Board of County Commissioners approves application 3210, the preliminary plat for the Gardens PUD, finding that the proposed preliminary plat and construction plans are consistent with the Flagler County Comprehensive Plan, the Flagler County Land Development Code, the Hammock Beach River Club PUD Development Agreement, and the PUD Site Development Plan, subject to A, resolution of outstanding staff technical comments, B, acknowledgement through a general note on the final plat that tracts reserved for future development are intended for development which has been already approved but has not yet been platted, as in reserved future development tracts do not vest additional development rights beyond the golf course, dwelling units, or commercial square footage as provided in the PUD development agreement. Item C, no construction to commence prior to issuance of a county land development permit. Item D, no final plat approval to occur until extension of potable water and sanitary sewer
is installed and approved by the City of Flagler Beach as a utility provider, with a general note added to the final plat that no wells, whether for potable or non-potable purposes, will be permitted, and E, any subdivision improvements not completed by the developer to be bonded or other surety provided consistent with the requirements of the Land Development Code, but subject to the PUD Development Agreement's requirement at Section 8.1 that all needed infrastructure is provided concurrent with each phase. That is the first option. Second option is identical to that, but with an additional condition at the end that says other conditions that you feel necessary to add. Option 3, denial. Option 4, tabling. With that, I'll close, await any questions or comments. Thank you.
Comments from the board?
Mr. Chairman, I move we approve item 9H.
You have a second?
Second.
So we approve option 1, basically.
Right.
We have a motion and a second by Mr. O'Brien. Mr. Adid, did you have?
I just want to make sure you ask for public comments. I think you had a second, right?
Yes.
Yeah. So this is option 9H, and so before we vote, anyone in the public wishing to speak can do so now. You have 3 minutes each.
Drew Smith, City of Flagler Beach. Just for the benefit of the record, I'd like to restate and incorporate our comments made in 9G into 9H.
Thank you.
Thank you.
It's John Tanner representing Preserve and also the citizens involved. And whatever additional conditions you may place on this, I hope that in the near future, Mr. Hanson has said it, we all know it, this is going to be a disaster for John Anderson if something isn't done to protect it. This is the best time to protect it. And let this developer know that this is a condition of this development, that they stay within the PUD, which requires the over or under off grade. So I hope that you'll table the first motion and someone will make a motion to add that condition and that it be constructed with the outlet on 100 as provided in the PUD and with the the right-of-way agreement that was passed by the county as well, where it describes in detail those responsibilities. So I hope you hold them to that responsibility. It is some additional cost, but Bobby Ginn found out you could put a big culvert underneath and it's a lot less expensive than running the concrete and everything on top. So I hope you will add that condition to this process now rather than later, because later sometimes never comes. Thank you.
Thank you. Any additional comments?
James Fest, Palm Coast. One thing I need you to consider as you go forth, what is at stake? On 4/17/2019, in the Flagler County TRC meeting, comments concerning hazardous materials, number 16. According to the Division of Historical Resources Master Site File FL00225, DIPVAT is located on the east side of John Anderson. The question was asked, is there any record of the site being addressed or closed? If no record exists, staff recommends that remediation is addressed as part of the amendment. To our knowledge, it has not, and we demand that remediation be addressed as part of the amendment. Lives depend on it. The county is aware of it and its location. A preliminary soil arsenic testing came back very low for the kettle vat. The vat is basically located at the wetland line low in elevation compared to the upland area on site. There is a tremendous likelihood that the arsenic has flowed into the wetland over the past since 1940. Further soil testing will be required as they get closer to any construction down on that end of the property. Prior to any construction in that area, the soils are required to be grid tested, and any areas where the development is affected, the soil will have to be removed as part of of the remedial action plan, as mentioned previously, with the Florida Department of Environmental Protection. I will end my part of it with this quote right here. I'll leave you with this thought. When all the trees are cut down, when the animals are dead, when all the lands and all the waters are polluted, when all the air is unsafe to breathe, only then will you discover you can't eat money. Thank you.
Thank you. Further public comment on 9H? If none, I'll bring it back to the board for a vote or additional comment. We have, this is 9H, application 3210. The motion is to approve, request for approval of a preliminary plat, PUD, district for 335 lots in 6 phases in the Hammock Beach River Club PUD located south of State Road 100, east and lying east and west of John Anderson Highway. All those in favor of the motion signify by saying aye.
Aye.
Aye. Charlie? Aye. What did you say? Ask for the negatives.
Negative, no.
Okay. All right. So it's 4-1 in favor of item 9H, Mr. Erickson being the dissenter on that one. With that, that approves that item. So we're complete of our items in 9, the public hearings. So now we'll go forward with the county administrator report and comments.
Thank you, Mr. Chairman. I'm going to try to set an example, which I hope will prove an inspiration to others. I have no comments.
Okay. Thank you. County attorney report and comments.
Well, I've got to follow suit. There's no way that I can do otherwise. No pun intended.
Okay, this will now be the second period of community outreach. This 30-minute time period has been allocated for public comment. For items not on the agenda, each speaker will be allowed up to 3 minutes to address the commission. Speakers should approach the podium, identify themselves, and direct comments to the chair. See no one coming forward, and I do want to thank you very much for hanging in there with us today, our court reporter. With that, we'll go, I don't see anyone coming forward. With that, we'll go on to commission reports, comments, and action. Mr. Erickson.
I have none.
I spent 12 hours Saturday interviewing candidates for the United States Naval Academy for Senator Scott. It was a well-spent 12 hours. There's some great kids. There's some great kids in Flagler County, let me tell you.
Mr. Mullins?
Yeah, we do.
I got a couple of pages here. No, I'm kidding. No, all I want to say is great job with the Day of Prayer. I saw that from Boston, and it was
Prayer
pretty
Unites.
phenomenal. Prayer Unites. Yeah, that's up.
Mr. O'Brien?
Just want to wish Commissioner Erickson happy retirement.
Absolutely. I think we all say that.
Absolutely.
Charlie. We gave you a long one for your last full meeting.
Got our last out.
With that, I'll look for a motion to adjourn.
Move we adjourn.
Second.
All right, we're adjourned. Thanks for all being here.